Hey y'all, what did you think of the new intro? Hi. I've been busy this morning. What do you think? I changed a few things up. I I had the intro long while back, but the music that I had on it, YouTube kept like copyright striking me. So I ended up using the same videos that I made, but I had to take the music off of it and add a different music. So, from the YouTube catalog of music. Anyways, thank you. Thank you. Thank you. I'm glad you like it. I got a new background. Yeah, I got a new background too. Let's see. Let's see. The background, it drives me crazy though, because if you look, hold on, I won't take myself off the screen, but you can see like behind my screen, it says crime, but you can't see it when my screen's on there. Look, hold on. Look. See? So, anyways, still super pretty cool. I like it. I like it a lot. I like it a lot. So, how are you guys? Today is day 4. Good morning, Shiraz. Hi. Oh, I need to go in and say hey to everybody. I need to go scroll up real quick and say hi to the peoples. I want to grab this stream. Wait, what's going on? Ooh, we have a motions hearing today for Kohberger. Ooh, wow. Let me open this up and see what time this starts. Looks like it goes live in about 5 hours. 4:30. Let's see. Okay. So looks like 4:30 my time. Okay. All right. Let me open this one up. This one starts in 7 minutes and 33 seconds. Let me share it. La 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 la. La 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 la. I can't make it big till it's actually on. So let me go up and say hi to you guys. Hey, Ween Baby. Ween Baby's first. I think that's 2 days in a row. Look at you. Hey, Patricia. QB. Margaret's here. And Margaret's on vacation till Tuesday. Yes. Here, don't forget to put your DNA all over the like button for our gracious host. No collection or analysis will ever be done. Thank you, QB. While you're at it, please do all the other YouTubey things like subscribe and share to let others know about this awesome content. Yeah, you guys, please give the video a thumbs up real quick before I forget to tell you to give the video a thumbs up. That really does help. And if you have true crime friends who don't know that we're over here, let them know. Send them a link. Tell them to come join the fun. Hiya, Henny and JB's mama. Hi. I'm glad you guys like the new stuffs. Yay. Miss Morgana Banana. I'm glad you guys like the new intro. That makes me happy. Makes me happy. Margaret says it's all very techno. Oh, good morning, Gail. Thank you. Thank you. Thank you. And then our Shiraz is here today. Good morning. Mm-hmm. Margaret says we'll just know it's there. Yes, 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 yes. Oh, Shiraz is a celebrity. Oh, she says, dang, feel like a celebrity walking in here. Oh, yes, Margaret, let us know when they call. Let us know. We need to know when things start happening. Ma'am. Ma'am. Oh gosh, Margaret. Margaret says she's saging her space for it. It would be a nice job, nice place. The people were really nice yesterday. I'm nice too, or maybe I fooled them. I think you're super nice, Margaret. I think you are super, super nice. Y'all got your coffee? Y'all got your coffee and things. Oof, 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 oof. Hold on just a second. I need to hold on a minute. Copy. Let me go over here into my panel chat real quick and as soon as it loads. Hold on, hold on, hold on, hold on. Okay. Oh, I didn't see you put that in there. QB. I'm sorry. She put the QB, put the oh, wow, you guys have been busy in the panel chat. Wow. Good morning, good morning. I'll put the StreamYard link in the panel chat, girls. Okay, let's see. Let me go back. Yeah, I know Morgana's not a coffee person. I'm on my second cuppa. Shiraz says this case and the Hildebrandt Frankie has really messed up my algorithm. YouTube thinks Mom. I really need me some church. What, baby? Yeah, you got a T-Rex. Yeah. You gonna take it in there and let it bite your finger? Yeah. She has stolen her brother's dinosaur figurine and she's obsessed with it right now. Yeah. Rawr. Rawr. Oh, we got a QB. Hi.
You
gonna
Good
say hi, Joey?
morning. Hi, Jolie. Hi.
She's waving. She actually said hi, Grace. She thinks you're
It's
Grace.
okay. It's okay. I'll take it.
But then when you start talking, she's like, wait, that's not Grace. Yeah, that's not
Tell her
Chris.
I'm
That's
waving back.
she's waving. She's waving at the computer. Can you say QB? QB.
I'll take it.
22, here. Here 732, here 751, here 776.
Ooh, we have audio already.
Can I read your number on?
779, excuse madam.
Well, they're on the ball.
Juror 834,
Here.
juror 874, juror 997,
Here.
juror 1014, juror 1024,
Here.
juror 1078, juror 1093, present, and juror 1100. Thank you.
All right, thank you. In this group, the court will note upon further review of questionnaires, there were 2 jurors excused. Juror 776, the court reviewed with counsel the questionnaire, and we released that juror based on bias expressed in the questionnaire. Does the state agree that there was a strike there that was confirmed by the court as to juror 776?
Yes, Your Honor. Thank you.
Does the defense stipulate also on that strike?
Yes, Your Honor.
Okay, one other juror we addressed was juror 1080, based on a hardship and some bias, was excused for cause. Does the state also make that motion at this time to excuse that juror for bias and hardship?
Yes, Your Honor. Thank you.
Does the defense stipulate?
Judge, yes, we're good. Thank you.
All right, and the court again has reviewed questionnaires as to both, and finding the information in the questionnaire supports those challenges. Those jurors have been excused. We did have one other juror this morning who will be returning for the afternoon, and that was juror 977. So this time then, addressing the jurors again, to assist you in understanding and participating in the jury selection process, I'll introduce you to the lawyers and briefly summarize what the case is about. When I introduce an individual, please stand and briefly face the jury panel, then retake your seat. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state is held by Lindsay Blake, Fremont County Prosecutor, Rob Wood, Madison County Prosecutor, Ingrid Beatty, Specially Appointed Prosecutor, and Rocky Wixom, Deputy Fremont County Prosecutor. The defendant in this case is JJ Daybell, and he's represented by his lawyer, Mr. John Pryor.
Good morning, ladies.
This is a criminal case, meaning the defendant is charged by the state of Idaho with a violation of the law. We read to you a summary of the charges in the amended indictment when you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho has alleged that JJ Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. And count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember, this is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence, you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions. I will later give to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, You must follow those instructions regardless of your opinion of what the law is, or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed you are not to discuss the case among yourselves or with anyone else, including talking to anyone or use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, I'm going to request that our clerk administer an oath to the jury panel for the voir dire examination. Ladies and gentlemen of the jury, if you would all please stand at this time and raise your right hand.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God.
Thank you. The clerk has now impaneled these 13 prospective jurors for questioning in a small group today. Will the attorney stipulate that the juries were properly called and impaneled, beginning with the state?
Yes, Your Honor. Thank you.
That's
Yes, Your
Court will also note that a juror affirmation has been filled out and signed by all the returning jurors without any issues noted. So these jurors have committed that they have not discussed the case or investigated the case since the time they have filled out their questionnaires last week. In this part of the jury selection, then, you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law, and in Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs. Simply, it is for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your red card or your hand. When you're called upon to speak, please make verbal responses to any questions so that we can take a record of what was said, and try to avoid speaking over the top of any attorney questioning you. In addition, I'll note that this proceeding is being broadcast. You are not being filmed or videoed, but your audio is coming through on the court's broadcast, which is being streamed on an official court channel for public access. Or to a question that you think might be either embarrassing or uncomfortable to discuss in that public setting, please notify us before, and we will be able to discuss those issues with you in a private setting outside of public access. Similarly, if your answer to any question might prejudice other jurors, please refrain from making those kind of comments until we talk to you individually, so that other jurors don't learn information you may already have about the case. This case has also had pretrial may have individually and not here in the group setting. I'll now read to you a special instruction for this case as follows. The defendant, JJ Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Vallow Daybell and/or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I'll also instruct the attorneys to please avoid repeating any questions already asked by the court. However, you do have the right to direct follow-up questions to a juror regarding that juror's response to previous questions. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, by which I mean that each side can ask that a juror be excused for a specific reason. In addition, each side has a certain number of peremptory challenges, by which I mean each side can challenge a juror and ask that he or she be excused without giving a reason for the dismissal. If you are excused by either side, please do not feel offended or feel that your integrity or your honesty has been questioned, because it is not. I'll also advise you, if you are excused from jury service after a challenge, then you may be approached to discuss this case. You are permitted to do that. However, I would ask you to be mindful of your fellow jurors and the fact that this court is trying to find impartial jurors in this case. And if you don't want to talk to someone about the case, you don't have to. And if someone persists in trying to talk to you, please report that to the court. At this time, then, I will begin the court's portion of the voir dire process, after which I'll allow attorneys for both the state and the defense to make their own voir dire inquiries. If we are discussing questions with any given juror, please pay attention to the questions and answers that you may be called upon later to answer those same questions. The first question I'll ask is not in relation to the long questionnaire you filled out last week, but just your juror information form, which has information such as your residence in Ada County. I'll ask each one of the jurors now as a group, are the answers given by you in that juror information form still true and accurate? If so, please raise your red cards. All right, thank you. It appears all the jurors still have accurate juror information forms. The next question I'll go to is on your jury questionnaire. And those were last week, they were lengthy. Is there anything in there that you think needs to be corrected or clarified at this time that we wouldn't just discuss with you individually? All right, nobody appears to have any correction at the outset to the questionnaires. The next topic I want to discuss then involves the length of this trial. This will be a long trial. We're estimating a time frame of 8 to 10 weeks. I'd like to know if any of you believe serving for that much time would create a serious hardship upon you or your family or your business or profession or occupation to prevent you from rendering service as a fair and impartial juror in this case. So if you believe you have a hardship based on this time commitment, please raise your red card at this time. All right, we've got 3 on the back row. All right, we're going to take these up individually at this time now. So the first juror we'll talk to about that will be juror number 834. All right, juror 834, you did talk about in your questionnaire concerns as to whether or not you would lose income and employment during this case. Can you explain what that hardship would be if you were required to serve? And you can remain seated if you wish.
Thank you very much. I'm a field service tab 71 that's supporting all the send out sponsors. And that would be conflict so much of my work because I don't have anybody right now. So I'm following hospital from Boise to get the city. So I don't know, so that would be difficult for me if I be injured for up to 10 weeks.
Have you been able to discuss with your employer required to serve on this jury?
I did.
And did they advise you anything about whether or not they could accommodate your service or provide pay if you were serving?
I just notified them because I didn't know it would be before. because I just told everyone to stand by, so I haven't discussed after this yet.
All right, is this employment your sole source of income?
Yes.
All right, let me inquire, well, have the state asking Board Dyer on the issue of hardship, and then I'll allow the defense as well.
Your Honor, the state actually had it marked to discuss hardship with juror 834. I had noted that he had listed that in the questionnaire. I think we've been provided more information today regarding whether or not there's ability to provide coverage for him. Given everything that was in the questionnaire and indicated today on the record, the state would make a motion to remove this juror for cause based on hardship.
That response from the defense.
Judge, I also reviewed the facts, and I would also move to excuse this juror for hardship.
All right, based on that, the court's also reviewed the information in the questionnaire, finding that for this particular juror, service of that time frame would create a serious hardship financially for the juror and his family. And so for that reason, juror number 834, you'll be excused with the thanks of the court. Thank you for filling out your questionnaire last week and coming back. I'll have you drop a copy or your questionnaire with the bailiff, and then you're excused from jury service. Let's next talk to juror number 874. You stated in your questionnaire you thought the financial strain would create a distraction for you if you were required to serve for that much time. Can you explain that a little more?
I would be going without income for all that 1 week of the trial, and that would create financial hardship.
Have you talked to your employer about the possibility that you'd be serving for this case?
Yeah.
And did they indicate any policy of allowing for service or pay during your jury service?
They would allow the service that they're in the petition.
All right, and I may be confused there. So they're not paying you income. In other words, they'll hold your job but not pay you while you're here. All right. Did they have any time frame they could pay you that you're aware of?
For 40 hours a month.
Okay. And is that your sole source of income?
Yes.
Any questions for this juror on the hardship issue?
No, Your Honor. Similarly, we had it marked to follow up with this juror regarding the indication for potential hardship in the questionnaire. Given that additional information, the state would make a motion to remove this juror for cause based on hardship.
Response from the defense.
Judge, I'd also concur on the state's motion for hardship. It has to excuse this juror.
All right, juror 874, given your explanation here today and the length of this trial, you'll also be permitted to be excused from your jury service for the expression of the hardship. And so the court thanks you for filling out your questionnaire and taking the time to come back today. Please drop that off with the bailiff and you can be excused. Juror number 1014.
I was thinking too often things would be
Sorry.
Oh, sorry. I'm working 2 jobs and I'm in school full time, and so doing a 10-week trial would be very difficult for me to meet deadlines for in college. And then also for one of my jobs, I would be able to have a fund set aside, but for one of them I do not.
All right, are you currently in a semester in school then?
Yes.
And are you full-time or part-time student? All right, if this trial were taking up pretty much all of your time and energy, if you were serving with that for that length of time, would you end up losing the semester basically, do you think?
I would think so. It's pretty busy semester.
And when does the semester end?
It ends in April, the very end of April.
Questions on board are from the state, please.
Your Honor, similarly, we had it marked to follow up with juror 1014 based on some indication of a potential hardship. And given all the additional information today, as well as what was stated in the questionnaire, the state would make a motion to remove this juror for cause based on hardship.
All right, response from the defense.
Judge, I would also concur in that motion to excuse this juror.
All right, juror number 1014, the court has considered the motion to strike as well as the information contained in your questionnaire and your responses today. And I do find that service for that length of time would create a serious hardship upon you. So for that reason, you'll be excused with the thanks of the court also. So please drop your questionnaire with the bailiff, and we'll give you instructions. All right, did we have another card raised by 1024? All right, juror 1024, you raised your card as well and mentioned something in your questionnaire about a trip coming up in late May. Could you explain that, please?
Correct. Yeah, I have a family trip that my parents have been planning for a while. That starts May 25th, and we've already booked plane fare and hotels. And so, yeah, certainly, if it ran into that, that would be a problem. It's, you know, my kids are gone, my wife and my parents. So.
All right, if we did go into that time frame then, and we were coming up near that, do you think that would start creating a distraction for you and paying attention to the case here?
I mean, certainly it would be a challenge. I mean, it's a pre-planned trip. I mean, if the trial happens before that, that's fine. I don't have any financial hardship otherwise than that. So my income isn't dependent on a specific job that I show up to. It's dependent on some investment. So, yeah, it's just the trip itself. So it's, I haven't honestly looked to see, I mean, rescheduling it would be rather challenging. So, that would be the main issue. So, I mean, certainly if the trial is less end before that, then that's fine. But.
All right, I'll have the state inquire.
Your Honor, this is also a juror that the state had marked to follow up with, given what was indicated in the questionnaire regarding that trip. It sounds like where that trip is planned and the current estimation of time on this trial, I think the state would make a motion to allow this juror to be removed for hardship.
Response from the defense.
Judge, may I have permission to one matter?
You may.
Sir, I noticed that you have a couple of kids, if I remember right, 10 and 12. Is that
I have 11 and 12-year-olds. Yes, correct.
12? Sorry.
Yeah, so it's a trip at basically the end of school, right?
Right. It's a family trip that involves the grandparents as well.
Yes. Yeah.
Okay. And if you were fulfilling your obligation to be on a jury at that time, would it be safe to say that you would probably be distracted by your children and everybody else on the trip while you were trying to go through this process, and maybe would be anxious to move this process along while you're thinking about them while they're on that trip?
I mean, certainly if they weren't on the trip and I was still here, that would be, I mean, my kids are fairly independent, but any parent would be nervous about their children traveling. But I mean, my wife would be on the trip with my parents. So, I mean, certainly they're not going to not go because I can't go.
Right.
But yeah, I mean, certainly, before the trip, that's fine, but it's just during the trip.
Well, I guess,
That would be a challenge because, just making sure, I mean, they're going to Boston, and so, just all the logistics of moving two children around a large city would certainly be.
well, I guess I was really concerned about the emotional impact that it might have on you, the fact that this is a long scheduled family trip with extended family and celebration of your kids getting done with school, and I read about that. And I guess what I'm concerned about is that potentially this could be a significant distraction. That's what I'm concerned.
A significant distraction before the,
If you were to go here, and the indications, at least what I'm getting, is that there's a likelihood that children may go on this trip, and you're going to be, if the case goes until the 25th, I think that could be a distraction. That's what I'm concerned about as well.
yeah, I mean, I understand your question, and I would say up until the point of the trip, as long as the trial ends before that, it's not an issue for me. It's just if the kids went on the trip. So, yeah, that's the only issue. I mean, if the trial ends before that, that's fine. I mean, not a problem. So it's just, yeah, if the kids going on the trip and me not being there, with it being a busy city, and then, them having to navigate with my wife, parents, grandparents, as you would imagine, any father, would be concerned. I mean, it's pretty common. So,
And Judge, based on the responses, at this point, I'm going to move for cause as well and ask that the court excuses George.
All right, the parties have both made the challenge for cause for an express hardship. The court will grant the challenge, and juror 1024 is excused. Thank you.
thank you.
Okay, thank you, ladies and gentlemen, who are remaining here and have expressed a willingness to commit this extensive time for your service.
Ron, I'm sorry, but may I as well?
Very well. Juror 1093.
I am the primary provider, caregiver for two young children, 6 and 8, and they homeschool. At the beginning of this, the time frame was stated at 8 weeks, and I assumed it would be starting a little sooner. There is definitely the ability for me to put my kids into public school to cover that. But as time has gone on, and with the possibility for this trial to be longer, 10 weeks or more, if that should happen, it would definitely be a difficulty for us for childcare, as I take care of the kids and the farm, and we're out playing.
All right, and when you say the farm, could you just describe a little bit more about what responsibilities you would have there at your homestead?
Sure. We have 5 acres and we raise sheep and chickens. Lambing is coming up soon. We're going to have baby lambs, and we grow a lot of our own food and raise meat birds.
Okay, and there is a potential of this case going into the time frame you were discussing. So let me get some additional voir dire input from the state.
Your Honor, I think given that information, the state does not have any additional questions. With all of that going on and the described hardship, the state would make a motion to remove this juror for cause based on hardship.
Mr. Pryor.
Judge, I would agree with the state. Ask that she be excused for hardship.
All right, reviewed your questionnaire, juror 1093, also looked at makeup of your family and what you've got going on with your children as well. And so for those reasons stated and what you've indicated on the record today will allow you to be excused for your hardship request. Court does find that it would constitute a hardship for you to serve for that time period. So thank you for taking the time to complete your questionnaire and coming back today. You can be dismissed.
Thank you, Your Honor.
Okay, for the remaining jurors, then we're gonna shift topics to something else. The next issue is whether or not you have any knowledge of this case from previous media coverage or otherwise. You've heard a summary of the charges that are contained in the amended indictment. Other than what you've learned here so far in the court proceedings, do you know anything about the case? And if you do, please raise your red card. All right, and we've got several, if you'll hold those up for a minute, we are going to talk to you individually about your knowledge of the case a little later this morning. So I won't ask you any details about what you know. We'll talk to you about that one by one. And 751 also. Thank you. We next address the subject matter of the charges here. In this case, you've heard what the charges are, but that subject matter of this case involving charges of murder, conspiracy, and insurance fraud make it difficult or impossible for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict. All right, no one answered affirmatively. I'll next ask a series of questions that seem like they should be very obvious if we looked at your questionnaires, which we did, but I'm required to go through these on the record to satisfy certain statutory requirements, making sure you don't have any connections to parties involved in the case or the defendant. So with that in mind, first question on that topic is, are any of you related by blood or marriage to the defendant, Mr. Daybell, or do you know him from any kind of business or social relationship? No one answered yes. Do any of you have a legal relationship of some kind with any of the attorneys in this case, such as guardian and ward, master and servant, employer and employee, creditor, debtor, landlord and tenant, boarder, or lodger? No one answered yes. Are any of you a party in any civil action or lawsuit against the defendant? No one said yes. Have any of you ever brought a criminal complaint against the defendant, Mr. Daybell, or have you been accused by any of the prosecutors here today of any crime? Okay, no one answered yes there. Do any of you have any attorney-client relationship, either now or in the past, with Mr. Pryor or his law firm? No, and just to be clear, that's the defendant's attorney again. No one answered yes. Are any of you related by blood or marriage to any of the lawyers in this case, or do you know any of them from any kind of professional, business, or social relationship? No one answered yes to that. Have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? No one answered yes to that. Do any of you have any type of bias or prejudice either for or against the defendant, Mr. Daybell? No one answered yes. Is there anyone here that is unwilling to follow my instructions to you as the jury as to the law that you must apply in determining the case? No one said yes to that. Do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? All right, no one answered yes to that. Are there any of you that if you were a juror on this case would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in the courtroom and the law instructed by the court? All right, no one said yes. A final question then. Do any of you have any other reason why you believe you would not be able to give this case your undivided attention and render a fair and impartial verdict? All right, no one answered yes to that. So that concludes the court's section of voir dire I'll next allow the state to commence with its voir dire, and after that, the defense may do so as well. Who's going to be conducting voir dire of this panel this morning?
I will be, Your Honor. Thank you.
All right, Ms. White, if you'd like to commence, you may.
Ladies and gentlemen, thanks for being here with us this morning. I know this process has already been somewhat lengthy. You were all here last week and you filled out a questionnaire, and now we brought you back this week. So I want to thank you for sticking with us through this process. As we go through this, and just to kind of let you know a little bit about what we're doing here, is we're trying to ensure that we go through an extensive process to make sure that we get jurors that truly feel that they can sit on a jury in this matter and provide a fair and impartial verdict, and that they feel that they can see that duty through. Because there's a few reasons for that. The defendant, Chad Daybell, deserves a fair trial, and so does the state of Idaho. So that's why we go through this process, to just make sure that we get there. If I use the term brutal honesty, I'm going to ask juror 1100, what comes to mind if I use the term brutally honest, if someone wants someone else to be brutally honest?
I think for me, brutally honest means that you have to be truthful in all aspects, and that you need to be not hiding any of the pieces, but you, as difficult as it may be, you need to be able to articulate what occurs, what brutally honest.
Thank you. I appreciate that response. And juror 751, how about you?
Speaking the truth and living the truth. Can't find other things.
And would everyone agree that it could also include not worrying if you're hurting someone else's feelings? It can't be a little white lie. It's just got to be, it's what it is. Thank you for that. And the reason I bring that up is there's a couple things with that. So today, obviously, I'm asking you questions. I don't want to make anyone uncomfortable or put you on the spot, but we're just going through this process. And as we go through it, we want everyone to be brutally honest with us. If there's something you think we should know, tell it to us straight today. And the second part is, if you're selected to be on this jury, you're going to be given instructions by the judge. And when it's time, he would let you know that you could begin discussing things with the other jurors. And we want to make sure that everyone feels that they can be brutally honest, that they can be truthful with everyone as they're going through the process. So could everyone today commit that they can be brutally honest as we go through this? I see everyone shaking their heads in some audibles. Thank you so much for that. And one other thing I'll mention, the judge also mentioned this, but as we go through this process, if at any point there's something that you want to discuss without everyone present, let us know, and we can work with the court to make those arrangements. I recognize sometimes there's sensitive subjects, and they may be things that I don't even realize are sensitive. So I want to make sure everyone knows that. We want to be respectful as we go through this. Has everyone here been on a plane before? Everyone's nodding yes. When you get on a plane, usually at some point you get an announcement over the PA system. You know, sit back, enjoy your flight. We're going to take off. We'll arrive at the destination at approximately such and such time, and they take off. If instead of hearing something like that, you got on the plane and the pilot told you, I'm going to try to land the plane, I think we'll be there at this time, how many of you would feel comfortable on that plane? I'm seeing people shake their heads no. And can I ask juror 779, would you want to stay on that plane? Why not?
Because I would fear for my life, because I know the pilot was not experienced if he said something like that.
And juror 1078, how about you?
I agree. I would definitely not feel assured hearing an announcement.
Thank you. And the reason I ask that is because we're basically going to ask you all to be the pilot with this case. So again, we talk about it, but the judge will give you instructions, and at some point it will be up to you to make a decision in this case when you render a verdict that you believe is the correct verdict. And does everyone here feel that they could do that they could sit on this jury and at the end of it, listen to all the evidence, give it the weight you think it's due, deliberate, and ultimately render a verdict that you felt was the best verdict. Thank you for that. So the other part of this, and the judge has gone over what the charges are in this case, and we have several counts of conspiracy to commit first-degree murder, and we also have several counts of first-degree murder. The victims in this case involve 2 minor children and a mother of 5. As we go through this, the state has the burden of proof, and as part of that, we present evidence. Some of the evidence may include some photos that are unpleasant. They may be graphic autopsy photos of children or that mother. Does anyone, as they sit here today, have concerns that if they were to see graphic images like that that are unpleasant, that it would cause you concerns about your ability to still sit on this jury? And juror 722, I think you have children. I believe they're adult children.
Yes.
Being a mother, does that cause you any concern, or do you feel you'd be able to look at those images and provide them the way you think they're due?
I think that's a fair question because you just, you see things on TV and it's kind of like more hypothetical. But I believe I can. I believe it's significant enough of a thing that I will be able to confront.
And do you feel like even if they maybe elicited a reaction from you, that you would still be able to weigh them fairly in light of the other evidence?
I would.
Thank you. And your 732, I'll ask you as well. I think you also have children, adult children. Same question. Does that cause you any concern?
It causes me no concern for my impartiality. It causes me concern for sleep and mental health. But it does not cause me concern.
Thank you. And just to follow up on that, because it's normal to be disturbed by these. It's normal to have whatever reaction we have as a human to images that are unpleasant. But anything about maybe having an emotional reaction or losing some sleep that would make you think you would, for any reason, give them more weight. Thank you for that. So I have a young kid, and when we get up in the mornings, if I ask him what he wants for breakfast, 9 times out of 10, it's cheesy eggs. But there's a very specific recipe that he likes me to follow, and it's simple, but it's what he likes. So it's the eggs and the milk and the cheese and the salt and pepper. And if I don't follow that recipe, sometimes he's not very happy with me. And sometimes I might modify it because maybe he wants a little bit of extra cheese in it. Can others relate with having someone, whether it's a kid or someone else that maybe has a very specific recipe or a very specific way they like things done? And juror 716, I see you nodding along. Have you had a similar experience?
Yes, I have. I mean, I have 2 kids, or 3 kids. One lives with me still, and yeah, it's yeah, I've been in that situation.
And do you end up a lot of times just following what that kid may want?
Sometimes, I wouldn't say all the time.
Do you sometimes modify it?
Yes.
And juror 722, I saw you also nodding. Is it similar for you?
Yeah, just where I remember the 2-year-olds and 3-year-olds, you know, they think they know what they want, and then of course you do it, and then they change their mind, and somehow you cut it wrong.
Yeah. Yes. I have been there as well. So with that, so we all kind of have recipes that we follow for certain things, and sometimes we might tweak them in our everyday lives. Maybe a kid wants something done a little bit different. Maybe we think we can make it better. But in this case, the judge is going to give us all, or you all, jury instructions. And those jury instructions will include an instruction on the elements of each crime that the state has to prove. And kind of like ingredients, they're going to be listed out. And unlike real life, where we might say, I might tweak this a little bit, or I might add this or take this away, you're not going to be able to do that. Whatever the judge gives you as the instruction, that's it. Does anyone have concerns that if you look at that and you think, oh man, I don't like this element, or why don't they have to prove this too? Could everyone commit that they'll just follow what's given by the judge? Does anyone have concerns about that? Thank you. With some of these charges, with the murder charges, there's going to be elements listed out in those instructions given by the court. And with regard to homicide, it's going to say the defendant engaged in conduct which caused the death of a person. There is not going to be an element on there that says the state has to prove the cause of death. So essentially, the state has to prove they did it, there was a murder, but we don't have to prove how the person actually died, what the actual cause was. Does that cause anyone concerns, or would you be able to follow the instructions as given by the court? It's like people are nodding along, but they could follow the instruction. Thank you. Do we have anyone here that's an NFL fan? I see one hand. Some people kind of say maybe. Juror 997, you're an NFL fan?
Yes.
I think Kansas City Chiefs won this year.
Good.
And you may or may not be happy about the outcome.
We'll talk later.
Yeah, I won't make you publicly disclose. I know some people hold those things very dear. But regardless of your feelings on it, do you feel that every person on the Kansas City Chiefs deserves to get a Super Bowl ring if they were part of the team?
Absolutely.
And with that, so even if the quarterback maybe played a bigger role, should the second string players also get a ring? Coaches?
You bet.
And why should they all get a ring in your opinion?
Because they all participate as a team effort.
Thank you. And juror 751, I'll ask you the same thing. Do you think they should all get a ring?
Yes.
And what's your reasoning behind it?
They work together, they feel they're together. Just take one person to follow.
Thank you. The judge already gave you an instruction today, and he'll give you a lot more instructions as we go through it. The instruction today dealt a little bit with conspiracy. And the judge has already said conspiracy includes an agreement by two or more persons to commit a crime. He also instructed you that you would not consider the co-conspirators what may or may not be going on with any cases with them or their guilt or innocence with regard to this trial. So with regard to Lori Vallow Daybell and Alex Cox, you wouldn't consider those things. However, in this trial, you will hear evidence regarding actions alleged to have been taken by those two. And as I said, the conspiracy itself, an agreement by two or more persons to commit a crime. And then again, the judge will give you the specific instructions, but it also includes that then only one person has to, but any one person that's part of that agreement takes one act in furtherance of it. So just one overt act, one act to try to commit the crime that they all intend to commit. All of them don't have to do an act. Does anyone have concerns here today that if person A and B or A, B, and C agree to commit a crime and only person B does an additional act, does anyone have concerns still holding person A and C accountable? If you believe the state proved there was an agreement that they intended to commit a crime, does that cause anyone concerns? Thank you. So, and today it did actually rain. But let's say that as you were on your way here today, the sky was just gray. It was starting to turn gray. You came here in the courtroom, they closed the blinds, you couldn't see outside, and you go outside after court and there's water all over. So water on your car, water on the grass, water on the pavement. You start driving home, everything's wet. You see a rainbow in the sky. Would you be able to determine what had happened? And juror 732, what would you determine had happened?
Rain or moisture, snow, rain.
Something had happened, some kind of precipitation, moisture had come from the sky. And juror 1100, how about you?
Yeah.
And you would be able to make that determination without ever having seen it rain. So in the trial, you may see different types of evidence, and you may hear the term circumstantial evidence. Does anyone here have concerns considering all the evidence presented and weighing it and not worrying about what type of evidence it is, whether it's circumstantial or other? Does anyone here have, because knowing the nature of the charges, does anyone have in their mind a specific type of evidence that you think the state would have to show or that you would expect us to show in this case? I don't see anyone saying yes. And again, just can everyone commit that you would follow any instructions as given by the court? And would everyone agree that even if someone tried to convince you or try to tell you that the instruction was different than it was, would everyone commit you'll only follow what the judge tells you? Thank you so much for your time today. I really appreciate it.
Judge, could we approach from that?
Yes.
Hey, y'all. They must be taking a break. Hey, we're on a break. Yay, Ween Baby off work tomorrow. So I guess they decided to take a break. I don't know. The defense said, can we approach? And then all of a sudden the jury was going out. So I don't know. Maybe they needed a bathroom break. Is tomorrow Friday? Tomorrow is Friday. Yay, 4-day weekend. So I think Jenny's probably still waiting for the bus. Hopefully I won't fall out, go bounce to bounce. So, what do y'all think? Do you think they should shake these questions up? Like, I get where they're coming from. I get the cheesy eggs. I get the rain. I didn't know they had used it. I guess they're taking a break, JB. They didn't have any audio, but the defense attorney said, "Can we approach?" And then they stood up to let the jury out, and then everybody left. So, me, baby, I don't know what in the world. I knew it would be a matter of time before the bridge killed our part situation. I don't know. Hi.
Hi, I'm back.
Hi.
Hi.
So did you hear that?
I was listening on my phone. I heard him say, may we approach or something, and then all of a sudden it went to this little screen.
Yeah, Shiraz, I get that, I guess. It's just that they're different groups of people. So it's not like, I don't know. I feel like they should shake it up. I'm tired of hearing about cheesy eggs or chegs because I don't have any. And I'm mad about it. Also, I
Well,
may have added eggs and cheese to the cart.
they keep those, they keep those, and they keep them in their back pocket. Like, I've heard the rain one, the if it rains. I've
Right.
heard that one like in other juries, not just this one. And the recipe one, I've heard the cake one.
Right.
And now it's the cheesy eggs, and I've heard the land the plain one. That was a big one. But
Well, and y'all got to remember, this is my first time hearing of voir dire, so, or voir
yeah.
dire, depending on if you're the judge or not. Um, he says it weird.
I've heard it said every which way.
But he corrected him. He was correcting himself in the beginning, and then now he's just like, no, I mean, this is how I say it. It's voir dire. That's how I say it, and that's how we gonna say it. But he's pretty chill. Like, I don't know. I know, Jenny, you've been watching part of it. The Apple River trial. That judge, he ain't playing.
Yeah.
He's like, nope, no, we're not doing that. Move it along.
Yeah.
He keeps saying it. Move it along. And then on day 2, oh, who's making modified cheesy eggs? I want cheesy eggs. But yeah, he's but somebody made a statement that he looks like Harry from Night Court, and I can't unsee it.
Oh, he does. You're so
Doesn't
right.
he? Right? Somebody said that in one of the comments, and I was like, okay, I can never unsee that now.
Yeah. I mean, now that you said it, now I won't be able to
Yeah.
unsee it. I never
No.
thought that before till just now.
Yep. When they said that, I was like, oh man. But yeah, he's not, and his timing, I mean, he's like, we will be here in 15 minutes, and at 14:59, they are there. Yeah. He's not playing. So I've only gotten through day 2. So I've got day 3, and then today is day 4. But I think sorry y'all. I don't know what's wrong with me. I'm like, I feel like I could sleep until May.
Yeah. You had a busy day yesterday, so.
Ugh, blech, blech, blech,
Blech,
blech.
You want to update us on how that went?
No.
Okay.
No, I can. It's fine. I went to the back surgeon yesterday, and of course, in true QB fashion, I am in a gray area as far as surgery goes. And so he showed me on the MRI. It was really good, really great guy. Came very highly recommended. Said if I wanted to go have another have a second opinion, he would understand, which I really don't. But it's like 60% could help, 40% could not help. And so he said, it was obviously my choice, and I don't know. I'm not liking them odds really.
Yeah, I mean, they're not great odds.
So I mean, the thing with me is it's where the way he was showing me on the MRI. So I do have nerve compression, okay, and impingement, but there's also still spinal fluid around the nerves, which means they can free themselves. That's why it's intermittent. That's why I get that stabbing, or my leg goes numb or whatever, and then it like stops. It's because there's still movement. So, when you start talking about, I'm going to go in and chip away bone and move ligaments and to give you more room for those nerves, I'm like, meh.
Yeah. Shiraz says with those odds, I'd get a second opinion. Maybe it is worth getting a second one.
Yeah. I'm gonna see what they say. I'm gonna go to see. So I'm in a tough spot because my whole right side is injured. So I have a really bad shoulder injury, back injury, the hip, and the ankle. The ankle's better, but the shoulder causes a problem for physical therapy for the back because a lot of things that I would do for the back um, involve me using my shoulder, i.e.,
Yeah.
you're like on your stomach, lifting yourself up. I can't do any of those things. So, really, until they fix my shoulder, I mean, I'm doing PT for my back. Um, but yeah, so Shiraz, it's under workers' comp, so it's a little different. But yeah, see, that's the thing, JB. I mean, I don't know. I don't know. I don't know. It's it's in my back pocket. It's in my
In your
back
back
pocket.
pocket.
In my back pocket. The problem is that there's so many problems. The problem is that the injections, the steroid injections are not helping and they're causing more harm than they are good.
Mm.
So, yeah, it sure has. I will tell you this. I am very blessed and fortunate that somehow or another this particular workers' comp
Oh no.
am oh my gosh. Did I drop out?
Yeah.
I hate it here.
Hey, Lauren.
Hey Lauren.
Good to see you.
Yeah. Yeah, so I've worked for attorneys that do workers' comp, so thankfully I do have some knowledge about it, and I am lucky to have a nurse case manager. I will say that because he's an more of an advocate than anything. So I don't know. I'm still trying to wrap my head around it. But I go see the surgeon for my shoulder on the 7th of May. So we'll see.
Fun, fun, fun.
Not really, but anyways, you're not late. You're right on time, Lauren. You are right on
Yeah.
time.
It's
We've
just
been talking
more of the
about cheesy
same.
eggs,
Yeah. The
the
airplane.
airplane, some rain.
The only thing you missed was my new intro.
It's fantastic. I love it so much. Oh my gosh. It's when I saw it pop up, I was like, my girl, look at my girl did it.
Woohoo! It's super
And I
fun.
mean,
Super cute.
it's beautiful. Like it's beautiful. And the intro with the information, like we a little cafe, we a little crime.
Uh-huh.
I mean, well, we a lot of crime and a little cap. Well, it depends on the day, but
Sometimes we're half and half.
yeah.
Some days we're way more cafe than we are crime.
Well, that's because they put us on read and then they leave.
That's true.
Like
That's true.
this, they didn't tell nobody. I just knew that they stood up for the jury. I was like, okay, the jury's apparently leaving. And then we got, the court will resume shortly. So I don't know what happened. I mean, did somebody have a gastro problem? I mean, oh Lord, the helicopter.
What?
Ma'am, Shiraz said the helicopters are back.
Oh my God.
It's freaky. Like, I mean, I will tell you, I lived outside of Houston, but I did business in Houston. And 610, 10, 45, all of those. Oh, but 610 is just like people are crazy. And so when you would go to leave, um, when I would go to leave Houston, if I saw helicopters, I was like, nah, homie, I'm gonna go get something to eat. Because it was
Mm.
usually a wreck and it was gonna have everything shut down. She said she's gonna have to put pants on. Go outside in your moo with the chainsaw. You
Yeah, the
my kind of
chainsaw
people.
comment made me laugh out loud.
Um, yeah, the intro is so good. I'm so glad it's back.
Me too.
So
I just
did
kept
you
putting it off, like fixing it because I had to change the only thing I changed was the music. So
I remembered, look, I remembered I was like, I know that I am not losing my mind. I mean, there are times when I am not sure, but this time I knew because I'm like, I saw a different intro.
yeah.
And so it's fantastic. I love it. Like, I love it.
Thank you. Thank you. Thank you.
I love it. And you got some YouTube friendly music,
Yes.
so
I
they
picked
won't.
it from the YouTube audio library.
Oh, good. Nice. Uh-oh,
Oh,
they're
I
back.
think we're back.
Yes.
All right, please. Council President Young.
Thank you. Please be seated. We're back on the record on CR 22-211623 State versus Chad Guy Daybell. The state just concluded its 4-hour examination of the group. Mr. Pryor, if you'd like to commence with the defense, you may.
Judge, I may approach the podium.
Yes.
Good morning, ladies and gentlemen. My name is John Pryor. I introduced myself to you folks earlier, and I represent Mr. Daybell. The reason we're here today is because Mr. Daybell has stated to the court and now to all of you that he's entered a plea of not guilty. The part of this voir dire, the French word that the judge used, is really an opportunity for all of us to get to know each other a little bit. Would everybody agree that we all have different experiences in our lives? We all have different biases. Some of us have job biases. Some of us have occupational biases. We try not to do this, but some of us have religious bias towards certain people, and that can be problematic as well. But what we are trying to do is get to meet you folks, trying to understand what your opinions are, how you feel about a variety of issues, and Ms. Blake did a very nice job of talking to you a little bit about that with some of the discussion about cheesy eggs and I think airplanes. And I'm going to talk to you about a few things as well. But before we start, I think Ms. Blake talked about this a little bit as well. It's really important that you speak your mind. It's really important that you say how you feel about an issue, because quite frankly, I probably have 10 or 15 minutes to get to know you folks and decide. Both of us are trying to say, okay, these jurors are the folks based on their experience, all of the things in their life are the ones who would really be the best jurors to give us a fair trial. That's really what we're trying to do, have a fair trial. So I'm going to ask you a couple of questions, and I don't want you to think that these questions are designed to suggest that Chad is guilty. I have to ask you the questions because I have to delve into this. And again, if there's anything that you don't like or anything that you feel uncomfortable about, just stop and say, John, hold off. We're going to talk to the judge privately, and I don't want to talk about this in a more private setting. Is everybody okay with that? Okay, thank you. So I'm going to go down a couple of the questions and I'll cover some other items, but just basically, when you heard the charges read, did anybody just assume, well, he must be guilty because of the charges? Raise your cards if you think that. Okay. Does anybody believe that Chad has to testify in this case? Does anybody believe that Chad has to testify and prove to you folks that he's innocent? Do all of you folks understand that Chad doesn't have to put on one bit of evidence? Does everybody agree with that? Just pop your hands up or cards, whatever you're comfortable with. Everybody understands that. And if Chad doesn't put on any bit of evidence, you can't hold that against him. Does everybody understand that? Thank you. Thank you. I want to talk to you a little bit about the media and your opinions on the media. Would everybody agree that the media has a tendency to maybe inflame things? Raise your hand if you think the media has a tendency to sensationalize or inflame things. All of you agree with that. Does anybody believe for a second that you get the whole story from what you hear in the media? Would you raise your hands just so I can see? And I guess I'd like to talk, I think what I'll do is I'll start with 1078. Talk to me a little bit about what your view is of the media's role in a case like this.
I guess the media definitely uses it as a story, not so much fact-based. So yeah.
Okay, and we'll go over to juror 997. What is your thoughts on the media?
I try to avoid it as much as possible.
Okay.
Because I agree, whether it's local or national. I don't think you're getting all the specifics or all the facts. There's a reason why I think the media chooses stories, whether it's for clicks, whether it's for viewers, whether it's for attention, whether it's to get their name out there to the population.
Okay.
Yeah.
Okay. And you said clicks and attention, and quite frankly, a lot of it is the greater the sensationalism and the more viewers, what does it really come down to? Right?
Absolutely.
Comes down to money, right? So when the media is sensationalizing and calling somebody a name and making a suggestion or stirring something up, really, they're hoping everybody watches what they have to say. They're hoping that this is a way for them to gain, readership. And the bottom line is it's all about money. 779, you're shaking your head, you're acknowledging it. Do you have any thoughts on this?
I mean, I think it's kind of been explained, and I agree with what the past jurors have said. A lot of the time, I think journalists try to make a story, not always make it as factual, or if it is factual, maybe not leave in all of the facts, just try to make a story for people that catch their attention.
And would everybody agree that we shouldn't convict or judge somebody based on all of these outside influences? Would everybody agree with that? Okay. And I want to talk to you a little bit about some terms. Okay. Now, the judge already instructed you that the case is about facts and evidence. Okay. Facts, evidence. Does everybody understand what I mean by facts and evidence? Is there anybody who doesn't understand? The car is red. The car was seen not stopping at the stop sign. Fact, evidence. Okay. Is it fair to judge anything by other than fact and evidence if you're making a major decision in any regard? Okay. And I'm going to go to juror 751 because you're the first and you really shook your head strongly. So talk to me a little bit about facts and evidence.
It's looking very black and white. They're also on gray. They're asking us to start with gray. The court's asking us to look at what's presented as evidence and to weigh that against the top of what's told.
And you have a wonderful voice, but you said something that's very important. The court is asking us to consider the facts and the evidence. That's it, right? Does everybody agree with that? Facts and evidence? 722. Is it about facts and evidence?
Yes.
Okay. So, and I'm not going to pick on Ms. Blake, but I want to use her example because it's important. It's important because if we're looking at making a major decision and we're trying to guess whether that plane's going to crash or not, and we have to make a major decision, should we be basing it on speculation? Ever? Should you be guessing about what facts may be? Ever? Does everybody understand what the term conjecture means? It's a big word. And I try to avoid big words. Does anybody not know what conjecture means? Okay. Would everybody agree that speculation, conjecture, and guessing are pretty much the same words? Is there anybody who would disagree with that? Okay. We all have to make major decisions in our lives, very serious decisions, things that can affect us long term. Serious decisions, and all of us have had to make, I would assume all of us have had to make those serious decisions. When we're looking to make major decisions, it's important to look at the facts. Would everybody agree with that? Would everybody agree that we should not engage in conjecture or speculation or guessing? Now, this judge read us an instruction. And aside from anything else, more than anything else, we listen to him. I will listen to him. I promise you I will listen to him. And the court, and I'm going to commit you and ask you to commit to listen to him as well. And the prosecutors will listen to him. And when Judge Boyce gave you that special instruction, he talked about not taking anything on the outside and looking at those outside influences, okay? And what I'm looking to see if what you folks could do is commit to something and commit that we're not going to look at what the media people say. Can everybody commit to that? We're not going to commit to conjecture, speculation, and guess. Everybody commit to that? And we're going to commit to looking at just the evidence that's presented during the trial and the facts that are presented in the trial when we make a decision. Can everybody commit to that? And I want to thank you for that, folks. Thank you. A couple of other things. I listen to a wide variety of music. Because at my age, I had a chance to be exposed to everything from, I've been exposed to, oh my gosh, it's embarrassing, the 70s and the disco age. And I promise you I didn't wear the bell-bottom pants, but I was exposed to it. And I've been exposed to the movie music from the 80s and the 90s. And my children, I don't understand the stuff that they're listening to, and I can't even understand the words. I don't get it. But I do listen to a little bit of country music now. I find it very relaxing for me. And there's a song out there that the title of the song is "Everything That Glitters Is Not Gold." Okay, and 716, you had an acknowledgement and you smiled. So talk to me about what you think that means.
Something's really nice on the outside, but once you get on the inside, be it a person, be it piece of equipment, be it whatever, it may not be the same as others.
Right. And sometimes you get into it and you see this gold glitter, and it could be, like you said, it could be a job where someone has a job and they make the job sound absolutely wonderful. And then suddenly you get in the job and you find out, oh my gosh, it's too late. I'm in this situation. I don't really know what I got involved in. And you're blinded. And can people be blinded by the glitter? Is there anybody who believes that you can't be blinded by the glitter? Okay. Many, many years ago, I was reading a story, okay? And I'm guilty as well. Sometimes I read their stuff as well. I like juror number 977, I try to avoid it. But I read a story about a 92-year-old millionaire, and he married an 18-year-old woman. And I think that's a big age gap. Okay? Yeah. Juror 779, you're shaking your head. Okay? 74-year age difference. Is that an example of looking at the glitter and maybe not thinking it's gold?
Oh, yeah, 100%.
Okay, yeah. Juror number 1078. Is that a case of looking at the glitter and not realizing that there's no gold there?
Yeah, I would think so.
Okay. So sometimes you get into these positions and maybe you're fooled, or maybe you're tricked, or maybe you're convinced of something and it all sounds really great. And I don't want to just talk about relationships, I want to talk in general. And you could be convinced to say things, to do things, to act a certain way, and be drawn into something. Do people agree that that's something that in real life, those sort of things happen? I haven't spoken to 732, and you didn't give me a big nod. So I guess I'd like to see if you can talk about that. Don't want to talk. If you don't want to talk about it, it's okay.
You have a lot of words in there, and I'm not sure I completely understand exactly what your question was, or the amount of verbiage that was used.
Okay.
Would you clarify that?
Well, let me ask you this. Do you have any difficulties with the idea of my song, everything that glitters is not gold?
You don't live to be this age and have grown kids and not experience that in some
Right, in some
way, shape, or form.
In some capacity. Okay, thank you. And again, when you're looking at an important decision in your life and making a big decision in your life, is it a checklist of things you go off to make a big decision? Do you just say A to B, B to C, C to D, E to F? Or are there emotional factors and other factors that you need to consider? It's not just black and white when you're making huge decisions. First, there's personal and emotional considerations that you need to make when you make a decision. Everybody agree with that? Okay. And everybody again would agree that when you're making a decision, and should you be on the jury, you're committing to applying facts and evidence, and that you will not speculate about anything. Is that fair? Okay. I'm going to talk to you about one more topic, and I will leave this to the end. Okay? And I want to talk about graphic photos. And you're going to see graphic photos. And these graphic photos are going to hurt your hearts. In this case, these graphic photos hurt my heart. Okay. I want to ask you folks, is it fair to look at graphic photos and because it's upsetting to you, that anger or emotion or whatever emotion you feel should be taken out on Chad? Does anybody agree that when you look at graphic photos, you should immediately take it out and blame him for those graphic photos? Again, you should look at, and as an example, I think it was juror 1078. It may have been 997. One of you spoke about that there's images and photos showing, and media does this to sensationalize and try to draw. I guess it was 1078. You're nodding your head. The media shows graphic photos or images to gain a reaction from you, to sort of steer you in how they want you to feel or think, right? The concern is this, is that if you're shown these graphic photos that hurt your heart, is it fair to immediately put the cause and the blame on Mr. Daybell just because the photos are graphic? Everybody agree? Do you all agree with that? Because again, what we're doing is we're looking at facts and evidence. We have to consider the facts and evidence. And again, everybody commits to that, right? All right. I want to thank you folks. I know this isn't easy. I know that's very difficult, and both parties need to have time to be able to spend with you and get to know your views on things. And I want to thank you for spending the time with me, and I appreciate that very much. Thank you, folks. Judge, that's all I have.
All right, thank you, Mr. Pryor. At this point in the proceedings, then we're going to take up individual voir dire of this remaining group. We'll go lowest number to highest, so starting with juror 716. So, Vallow, please rise for the other jurors to be excused, and 716 can remain. Thank you. Please be seated. All right. Thank you for returning again this morning, juror 716. We're going to conduct some individual questioning of you at this point, as well as all the other jurors that remain. I didn't see any information in the questionnaire about concerns of prior case knowledge, nor did this juror indicate they had anyone asked. So there is some indication that you may suffer hardship if you're required to serve for this time. I don't think you pointed that out again this morning, but there are some questions about that in your questionnaire. So if the state wants to conduct any additional voir dire on hardship, we can start there. Then I'll see if the defense has any questions following that.
Thank you, we do, Your Honor. So I do just have a few questions about sort of comments. Oh, okay. Sorry about that. So do you happen to have your questionnaire with you? Okay. Might invite you to go to pages 20 and 21. And I would just call your attention on page 20 under the question number 1 under trial length. It indicated I work 3 days a week. I would have to arrange this with my boss to find a workaround for my work during this time. I was only project manager. Can you explain what did you mean by that? And is it still a concern that it could potentially impair your ability to serve on jury?
I work for a very small construction company, and I manage construction projects. I did talk to my supervisor, who was actually the owner of the company, and he said he could fill in for 6 to 10 weeks, however long that this trial would be, he could fill in that role with project manager. So that's no longer.
Okay. So then you don't feel like it would impair your ability to serve. Okay. Now let's go down to one more comment. You did also indicate that you lose pay for 6 weeks. Is that still accurate, or is your employer going to help compensate?
I'm talking about that. He's very generous. That's saying that well, but I also get a pension. So I have another.
So then, as you said, you're not concerned about loss of pay if you're a juror. Okay, thank you. Anything else that you need to discuss about potential hardship or income? No, I don't have any more questions. Judge, I don't have any questions on bias or hardship.
Okay, thank you. What we'll do next then is go through a different topic that's included in your questionnaire, juror 716. If you have a copy there, please turn yours to page 12. In the questionnaire, we asked you about your attitudes regarding the death penalty. And do you recall thinking about those questions and putting these responses in the questionnaire? And as you sit here today, do you still feel the same way in terms of how you answered those questions?
Yes.
All right, I do want to notify you in this case, when you're filling out the questionnaire, perhaps you're thinking hypothetically, but here in the case, it may actually be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you're considering should be done as if it would be absolute and carried out in the case. So with that in mind, I'll just have a few questions for you about your responses. You first indicated on page 12 in the option of supporting or opposing the death penalty, you said you support. Is that still the way you feel today?
You support it, depending on, the case evidence, if it's proven, and that should be the crime and punishment for that crime, yes, we support it.
Okay. If you turn one more page down to page 13.
Okay.
On that page, we gave you a choice of 7 different options that most, for you to select what most accurately represents the way you feel. And I assume you read through each of those, then you selected letter C, which is, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Do you think that still most accurately represents the way you feel of those choices?
Yes.
Okay. Do you believe that the death penalty, or would you be in favor of it in every case where a murder has been committed?
No.
All right. Just one final question for you then. Do you think there's anything at all about your views on the death penalty that could prevent or substantially impair your ability as a juror to perform your duty in this case and follow the court's instructions? All right, that concludes the questions the court has on the topic. Does the state have any questions?
We do not, Your Honor.
Any questions from the defense?
Just briefly, in your questionnaire, you said punishment, basically the punishment should be crime, right? So if there were to be a conviction in a case, if it's a murder conviction, and one of the options is the death penalty or life in prison. In your position, if there was a conviction for a murder and there was enough evidence to support that there was a murder convicted, is your decision going to be for an automatic death penalty in that case?
No, it depends on the case. You could have a case where it's self-defense or anything. So no, it'll be based on the evidence.
Other than self-defense, if it's truly a conviction, they say, yes, this was determined to be a true conviction for murder and someone was murdered. Is that a case where it's an automatic death penalty?
No.
So if the judge were to instruct you that first you're to look at the evidence and make a determination. The second part would be to, after you make a determination, you're to evaluate all of the facts related to that case. And there are going to be 2 options. One will be life imprisonment. One will be the death penalty. Can you commit to us today that you will look at the facts and evidence when in the sentencing phase, if there were to be one, and make your decision based on the facts and the evidence of the case?
Yes.
Thank you, and I appreciate that.
All right, that'll conclude the individual voir dire for this juror. So I'll go ahead and have you return with the bailiff to the jury room for further instructions. It's next to talk to juror 732. I'm sorry, 722. All right, thank you. Juror number 722, you're returning to discuss some of the information in your questionnaire outside the presence of the other jurors. The first thing that we want to discuss with you at this time would be your knowledge of this case and whether or not that may have led to you forming any kind of opinion. So I would note that the juror stated they've followed the case somewhat and have some information about it. I'm also indicated they have not formed an opinion, but we need to discuss this further. So I'll let the state proceed with some individual voir dire to see if there's any bias here.
How are you today? Good. In this case, you indicated that you watched some news on this case. And it didn't sound from your questionnaire like you had learned a lot about the case. But if you're comfortable, would you mind kind of telling me what you did learn about the case?
I actually did follow it quite a bit. I was interested, I guess, in it. So what I understood was just what the news said, and you don't know necessarily if that's or true or not. For whatever reason, it was interesting, and I enjoyed learning about it. But I knew that I didn't have enough information for that case for me to make a judgment.
Did you watch any court proceedings in any other cases related to this case?
I remember there being an audio that was available for people to watch, listen to a bit of that, but not watched.
Okay. And what was that audio of?
I think it was a couple of days around the autopsies being shown in the pictures, just what the judge was saying and what the happenings of that episode. It's not an episode of that day.
Sure. Are you aware if that was a preliminary hearing or a trial, or?
It was in the trial.
It was in the trial, and that would be the trial of
Lori
Vallow. Okay. Did you watch or listen to any other court proceedings surrounding the charges against Lori Vallow?
Not really, no.
Did you form any opinions about Lori Vallow and whether or not she was guilty?
No, it always just kind of confused me. I figured there was certainly stuff that went on that I didn't know about. And somehow it wasn't something I needed to worry about, but for whatever reason, it was something that was interesting.
And the evidence that you did listen to in the trial, did any of that relate to the defendant, Chad Daybell?
No.
And you understand that as Mr. Daybell sits here today, that he is innocent until the state meets its burden of proving him guilty.
Correct.
So he's entitled to a presumption of innocence.
Yes.
And you have not formed any opinions about Mr. Daybell's guilt?
No.
Okay. Your Honor, I have no further questions for this juror. Thank you.
All right, thank you, Ms. Fahey. Mr. Pryor.
Good morning.
Good morning.
Did you happen to watch any documentaries on this case?
I did watch one.
Which one was that?
I think it was the Netflix one.
Okay. Did you watch anything on Dateline?
No.
How much of the trial did you actually watch?
Probably like everybody here in the Boise area, you clicked on the headlines and read a bit of what occurred the day before.
Okay. But at least a portion of it, you took the time off out of your, and you have 6 children. You have a,
Well, I live alone now, so I'm an empty nester, so not as busy anymore.
okay, and I noticed that. So you did have the time to sit down and watch part of the trial if you felt you wanted to.
Yes.
And really what you were trying to do is just educate yourself about the facts of the case.
Correct.
Okay. And there was an interest there.
Mm-hmm. There was.
Okay. And as part of that interest, you have an idea about some of the facts and how you feel about those facts. Would that be fair?
Probably, yeah.
And part of the process is that despite your knowledge of the facts, despite whether you have an idea of what you think about the case, at the present time. When you're making the decision, we would like you to be fair and impartial and be able to block out those images, block out that knowledge that you gained. And you would agree with me that you've had extensive media exposure to this. Would that be fair?
Probably, yeah.
Quite a bit.
Yeah.
And there's been a very high interest in your regard about this case. Would that be fair?
Yes.
Other than your family and people who are very important in your life, this was an important thing for you to look at, and you were drawn to this. Would that be fair?
Oh, I wouldn't say that it was really important, but you know, when you got home from work and you wanted to relax for a little bit, I checked the news and then I did a little bit more work, turned on the TV, you know, nothing terrible.
Right. Watched the documentary.
Yeah, I wasn't obsessive. That's
No,
what you're saying.
no. But you watched the documentary, you looked at some of the other stories, you sort of piqued your curiosity about that.
Right.
And it wasn't hard because, you know, you looked at a lot of things as part of this. Is that fair?
Right. Right.
So when the time comes, if you're chosen as a juror, you form sort of an impression in your mind about this case. Would that be fair?
Probably, but also at the same time, as my number was called and everything like that, I'm confident within myself that I wouldn't be impartial about it.
Okay. But, you know, and that's, I appreciate you saying that. I really do. Because it's important that despite the fact that you've had a massive amount of media exposure, you would agree with that, you have, right?
Mm-hmm.
And the fact that you have, and I want to be careful, you formed an impression of this case.
Probably.
You still think that you could go into the jury pool and be absolutely impartial and not consider what you learned about this case, maybe block this out despite the impression that you've already formed?
Yeah.
Okay.
I would be able to.
And Judge, I'll move for pause here.
All right, I've been listening through the questioning on this with juror 722. I have a couple of follow-up questions. You do seem to have somewhat actively followed that previous case. Did you watch, for example, the verdict in the case of Lori Vallow's trial?
I think I did. At the end of the day, it wasn't live.
All right, and do you know how her trial turned out?
I wouldn't be able to tell you the specifics of all the different charges, but they found her guilty.
Okay, and do you know what her sentence was? Or did you watch anything involving her sentencing?
I probably did a lot of it. I don't really think a lot about afterwards. I think she got life.
All right, I appreciate your responses here. You've stated pretty unequivocally that you could be impartial in the case, and I'm not challenging or questioning that. The concern I just have here is whether or not implicitly that would sway your opinion one way or another, knowing what occurred in that other case, and most importantly, some knowledge and observation of evidence that was admitted, which may be the same evidence in this case, or may leave you wondering why evidence you saw in that case doesn't come into this case. I do find it problematic, and so for those reasons, I am going to sustain the request to strike this juror based on a bias in terms of too much information and knowledge about the other case that's already been through trial that would overlap this case. So for that reason, you'll be excused from your service. Thank you very much for taking the time to complete your questionnaire and coming back this morning, and you can be excused. You're welcome. All right, let's next talk to juror 732.
You guys are cracking me up in the chat, by the way. Cracking me up.
All right, we are on the record with juror 732 who's returned here for individual questioning in Fort Dyer. This juror has some case knowledge and may have some information about the case, so we're going to discuss that with you outside of the presence of other jurors. And I'd like to hear some inquiry from counsel as to whether or not there may be bias based on previous knowledge of facts of the case. So who's going to conduct Fort Dyer for the state?
I will, Your Honor.
All right, Mr. Wood, you can commence.
Juror 732, just as a reminder, there's no wrong answers here. Just tell us how you feel, and there's no right or wrong. In your questionnaire, it sounds like you do know a little bit about this case, and you talked about info from early in the reporting. Do you recall what you saw and about when you saw it?
No, and most of my information, I think, is around missing children. That's something that would pique my interest. I am very selective in my news. I don't watch the news. I read the news. Trying to find balance between margin and avoiding stuff that I think uncomfortable. So missing kids is priority, or an interest, or so I remember a little bit of information about that. Once it was on my radar that it was a potential murder trial or murder situation, I just connected the story.
Okay.
So really early on, I really avoided sensational stories. I like to sleep.
Understood.
If I can't impact something, I don't necessarily need to.
Do you recall, you said online news, what sources of online news do you usually look at?
For local news, I use the three big Channel 7, Channel 2, Channel 6, their websites. I used to subscribe to the Statesman, so I would get some information from the Statesman. I don't want to pay for those subscriptions, so I don't get that anymore. National news is usually BBC, Associated Press. As a general rule, I try to avoid things that are right.
Gotcha. On page 18 of your questionnaire, if you can turn to it, there's a question 8, and it's the what have you heard? And it seems like you know some of the basic facts and individuals involved.
I think that's largely headlines. You can't open it up and look through the news. When you see the headlines, you decide what you're going to read and what you're not going to read.
Okay. So you do say that, and then in 8A, it says, could your knowledge of any of these individuals prevent you from acting impartially? You did say no. Is that still how you feel?
Correct.
And you, down on page 19, it says, where it asks if you'd be able to put what you have heard out of your mind and render an impartial verdict based solely upon the evidence presented in this courtroom. You do say yes. And is that still your position that you can commit to this court, to this defendant, to the state, that you will not rely on anything you did learn in the media?
I can commit to that.
You did bring up one thing earlier, and I just want to talk about it real quick. And you talked about being able to sleep, and I think that's the second time maybe you've mentioned that today. Do you have any concerns about the subject matter of this case affecting you emotionally, mentally?
My guess is it would impact almost everybody in some way, shape, or form. That doesn't mean I don't take this responsibility seriously. I don't really live there. I don't watch true crime. I don't watch, I don't read thrillers. I don't read Stephen King. I'm pretty selective of what I take in. I worked in healthcare for 20 years. I spent a short period of time early in my nursing career in the emergency department. Part of the reason I didn't stay there long, that's not for me. I don't need to see gunshot wounds. I know there's a lot out there. I spent a lot of my career seeing some pretty common things. Natural causes, disease, accidents. So I have elected to not seek out additional. That doesn't mean I can't process it or deal with it, but I have been very selective, probably my whole entire life. What I choose to take in, and again, it goes back to what can I impact and what can I not impact. In healthcare, I think I could have an impact. That changes how you process things.
Well, and I guess a good way to ask this would be, so when you were in the ER and some type of traumatic injury came in, were you still able to work through that, work through your normal work obligations, provide the level of care you were supposed to provide?
Yes.
Okay. And would you be able to do that here, even if this subject matter were disturbing to you? And I think you said it correctly, it probably would impact anyone who looks at it. But even if you find it disturbing, that you will be able to set that disturbance aside and weigh the evidence just on the evidence and the facts, rather than any just disturbing aspect of it.
I'm sure.
Your Honor, the state has no further questions.
All right, thank you, Mr. Wood. Mr. Pryor.
And juror 732, I didn't hear whether did you see the Dateline and the Netflix series? Did you watch those? Did you watch any?
I didn't know there was a Netflix
Perfect.
series. And I don't watch David. I don't watch any news. I read news, but I don't watch.
So you get most of your information off the internet, through the websites of these various news agencies. Is that fair?
Very fair.
Okay. And just something piqued my interest is that you said that you choose not to view that stuff as a way to sort of shelter yourself from those images and that stuff, because it is upsetting to you.
It is. And again, if I can't have any impact on something, I don't need to know about it.
Do you tend to react strongly to things like that?
I'll hold on to it.
What does that mean?
I still remember some really horrific patient scenarios from nursing school, and I'm old. So that was a long time ago. But it doesn't mean I didn't do the right thing. It doesn't mean I didn't take care of my patient. It doesn't mean that I didn't need to be there. Somebody needs to be there.
In what you read, do you have some strong thoughts on what you read?
No, because I think I disconnected fairly early on.
Okay.
And not on any kind of level that would impact any kind of trial. But gosh, when my kids were in elementary school, they're in their 30s now, so that was a long time ago. There was a school board change in Ada County. And I was quoted in the newspaper, the Idaho Statesman. And it wasn't, I said everything that they printed. I said nothing in the context that it was printed. And I was really impacted by that. So that's shaped me in a lot of ways. I can read a lot of things, but before I'm gonna pass judgment on anything, I wanna know a lot more information. I think that's a little bit why I got hung up on your question. I didn't understand your question. Were you asking me how I felt about an 18-year-old marrying a 92-year-old? Or were you asking me about everything that matters is both? Because I have very different opinions.
Right.
I don't think there's anything illegal about an 18-year-old marrying a 92-year-old. If it's mutually beneficial, I'm not gonna pass judgment on that. That has nothing to do with me. So are you asking me about that, or were you asking me about everything that glitters is involved? I mean, there's different opinions. So I have limited my news probably for a lot of reasons. I don't need sensationalism. And I think you can have accuracy in reporting. I don't believe that there's malicious intent in reporting, probably in the vast majority of reporters, news agencies. I think they probably are presenting largely facts as they were told or that they know them at that time. Does that mean you know the whole story? Probably not. Does that mean you knew that things aren't going to come up later? Probably not. Could somebody be misquoted or out of context? I happen to know that personally. So
I appreciate that. So what it sounds like is that in spite of the fact that you may or may not have impressions, you may have impressions in this case, but it sounds like you can compartmentalize and you can say, listen, I can push that stuff away and make an unbiased and impartial decision, despite the fact that I may have had some exposure or I may have had some influence in some way, but I'm still going to be able to look at this independently in spite of the fact that I've been exposed to this.
I would agree with that. And I would fully expect that there'll be evidence today that wasn't reported on the news, even if I read all of the news. I mean, I'm sure there's facts that were never reported.
Okay,
So,
and in the same regard, you've obviously spoken about a sensitivity to graphic images and violence, and you make an effort to avoid that and say, I'm not going to let that into my sphere, for lack of a better word. Is that fair?
very fair.
Okay. And please, this doesn't mean that your answers are right or wrong. I'm trying to figure out, and that's why we're talking so much in depth about this, because I don't know how to process some of the stuff you're saying. I guess my concern is that in this case, you're not going to be able to decide to keep these images out of your mind. And some of the images and discussion is going to be hurtful to the heart. And that's where I'm hesitating. Okay, I'm going to be honest, I am. Because I don't know if pushing it out and saying, yes, I'm going to be able to look at this independently, and I believe you have an ability to do that. You've worked in an emergency room, my goodness. So there must be some intestinal fortitude there. I mean, significant. But I am still concerned and always am concerned that maybe the impact that it could have on you could in some, even a small way, impact your decision. And that's where I hesitate a little bit.
That's valid. I don't think so. I think it goes back to, do I have the ability to have an impact? Do I have a need to know? I think if you're on if you're impaneled as a juror, if you're part of a trial, you have an impact.
Right.
You have an impact in somebody's, in this case, somebody's life, not just livelihood. I also have there's an impact, but I think there is a need to know. I think,
okay.
And that's different than just, in my mind, gratuitous sensationalism that I don't need to know. Would this be the highlight of my anything to be on this trial? Absolutely not. Do I think it's important? I couldn't believe more firmly in our judicial system.
Right.
So whether I want to be or not, it's an obligation. If I'm the right person, then that's what I'll do. If I'm not the right person, probably sleep easier.
So if I understand you correctly, and then please correct me, stop me and correct me. Despite all of the images and information that you've gained from this thing, at this point, despite the you may have come to a conclusion or not, an impression, despite that there's an impression because of the news and because of your sensitivity to graphics, you're going to tell me that you can block that out because there is I want to use the right word. You can make an impact on something. And because you can make an impact, you're going to make a concerted effort within yourself to say, I'm not going to let my previous knowledge, my previous decisions impact me. And even though I've made those decisions and I've come to some conclusions or understanding, I will block those conclusions and understanding out because I think I can make an impact by participating in this process. Is that fair?
That's fair.
Okay.
And I don't believe any prior information would have any impact.
Okay.
I think maybe you're questioning just the images. And I think
That's where we have to block.
that's where I have to look.
Okay. All right. And again, there's no right or wrong answer, and I'm torn here. I'm going to be honest with you, I'm torn.
I'm not offended by that.
And Judge, I guess just because of the images, I think I'm just going to move for cause. I just think I have to.
All right. I've listened carefully to this exchange and considered the knowledge you have. The question I have, just to be succinct as I can, despite what you've seen and heard about this case, are you willing to commit to hold the government to its burden of proof in the case?
I think I could, yes.
Okay.
I mean, I don't foresee any reason why I couldn't fulfill my obligation.
All right. Based on the responses there, the state has not made a request to strike. The defense has. I'll overrule the request for perceived bias, although this juror has expressed some knowledge of the case. There's another topic we do need to discuss with you as well, and that is part of the questionnaire that you completed that had a section on attitudes regarding the death penalty. Do you remember reading through that section and answering your questions?
I do.
All right. And that starts on page 12. I will advise you that in this case, it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you're considering should be considered as if it is absolute and will be carried out in the case. So with that in context, do you support or oppose the death penalty? You selected a choice that said you support it. Is that still the way you feel right now?
Correct.
Okay, you next on page 13 had a series of choices, 7 of them about what accurately represents the way you feel. And you selected C, which states, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still an accurate representation of how you feel about the death penalty?
Yes.
All right. Where you are in favor of the death penalty, are you in favor of the death penalty in every case where a murder has been committed?
No.
All right. So I just have a final question there then. Will your views on the death penalty in any way prevent or substantially impair you from performing your duties in this case to follow all of the court's instructions, including those relating to the death penalty? All right, that concludes the court's voir dire on that topic. Does the state have any questions for juror 732?
Not on this topic, Your Honor, thank you.
No questions, Judge. Thank you.
All right, that will conclude your individual voir dire. We'll have you return to the jury room with the bailiff, and you'll receive further instructions once we talk to the other jurors.
Thanks.
Thank you. Next up will be juror 7-5.
Right, Kel? Some of them are easy peasy, others not so much. I guess they kind of weigh each other out. But man,
Yeah, he went through every tooth.
jeez Louise, right? That's why I said that one was a whole daggone jaw tooth.
I mean,
pulled-
like,
God.
he touched every tooth and then said, I'll take that one.
All right,
Yeah.
thank you for returning juror number 751. We're going to conduct some individual questioning of you relating to your questionnaire responses. You indicated a little bit of knowledge. Well, I'll let you determine how much knowledge you have or don't. Didn't express a whole lot in the questionnaire, but raised your card that you know something about the case. And you also made a comment on page 18 of your questionnaire that only the report of them missing and their deaths when asked a question about the people listed in that question. You also anything regarding trial hardship. So does the state have any inquiries that relates to bias on this juror?
Just a few quick questions, Your Honor.
Go ahead.
Morning, then. On that point that the court had made, you did make some comment that you had learned of the report of the deaths. How did you learn about that?
It was just media reporting. I don't follow this, but it was on the broadcast. I don't know details. And I did not follow any of the other court proceedings prior to this. I don't normally watch the news.
So it is fair to say you haven't seen any documentaries, datelines?
No,
anything like that?
nothing of that nature.
Haven't read any articles online? So just with that report, is there anything about what little you apparently know about the case that you think would impact your ability to be impartial?
No.
All right, I have no questions.
No questions. All right, thank you, counsel. Without further questions then or concern of hardship, the next topic we'll discuss with you relates to that part of the questionnaire where you were asked about your attitudes regarding the death penalty. Do you recall reading through that and answering those questions?
I do.
All right, since you filled out your questionnaire last week, have you had any change you'd like to indicate in terms of how you answered the questions there?
No.
All right, I do want to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, as you consider that, consider it as if it would be done in absolute and carried out in the case. So knowing that, you answered in your questionnaire on the question, do you support or oppose the death penalty? You said support. Is that still the way you feel now?
It is if the evidence dictates that as a appropriate, then should, yes.
Okay. You filled out another choice when given 7 choices about what most accurately represents the way you feel. And you said, and I'll quote from the questionnaire, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that the way you feel as well?
Yes, sir.
All right, and just to be clear, you said you support it, but you said also generally you're opposed to it, but would follow instructions about it if you needed to. Can you just explain maybe a little bit more how you feel about those 2 choices?
I'm assuming, given the instruction from the court, we will be given all the facts that lead up to this case. If the defendant is found guilty, then those instructions would follow as far as what penalty would apply. It's what the law will allow. My personal opinion doesn't count. It's kind of like the black and white question.
Okay, so that part of your answer that said you would follow the instructions in the case, if you had personal feelings that were different, you still would be able to do that?
Yes.
All right. So based on those answers, then let me just ask you, would you be in favor of the death penalty in every case where a murder has been committed?
No.
Okay, and so,
Facts.
apologies, go ahead.
Just if facts prove the case, and that's what choices are, with the individual case by case.
All right. Is there anything you think about your views on the death penalty that could prevent or substantially impair your ability to serve as a juror in this case and follow instructions about that?
No.
All right, that concludes the court's order for this juror on that topic. Does the state have any questions?
We have no questions, Your Honor.
Mr. Pryor?
I have no questions, Judge.
Okay, thank you so much for returning. That concludes your individual voir dire. We'll have you go back to the bailiff with the jury room and call another juror in.
Hey, Brenda and Ween Baby, you are like, yeah, you're my person. I could totally like
779 is up
finish off a bag
next.
of donuts. Yes, ma'am.
Council, I didn't see any indication of case knowledge. Is there going to be any request to voir dire on bias from the state?
No, Your Honor, thank you.
None from the defense either.
Okay, thank you. All right, juror 779 is returning for additional voir dire. Having reviewed the questionnaire, I believe the only topic we would need to discuss are questions related to the death penalty. Does the state agree?
Yes, Your Honor.
Yes, Your Honor.
Okay, we won't have any further voir dire on bias or hardship for this juror then, but we will ask questions as it relates to those responses on the knowledge of, or I'm sorry, attitudes regarding the death penalty. So juror number 779, do you recall filling out that part of your questionnaire that asked you about your attitudes on the death penalty?
Yes, I do, Your Honor.
All right, having thought about your answer since you filled it out last week, would you change anything in there and how you filled this out or correct anything there?
I don't think it would change it.
Okay. I'll advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. So as you're considering a penalty, you need to think about that as if it would be absolute and done and carried out in the case, okay? You had a couple of choices in one of our questions on page 12, and it was, do you support or oppose the death penalty? You did say you support the death penalty, is that correct?
Yeah.
And you still feel that way now?
Yes.
Okay, you also had a series of choices about what most accurately represents the way you feel. And you selected a choice on page 13 that says, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. So does that still explain the way you feel most accurately?
Yeah, I would say like it kind of depends on the situation, but I'm kind of in the middle when it comes to it. But when a certain situation comes up, then I'd say I'd support it.
Okay, and back to that answer, you're saying that if it were called for in this case by the facts, law, and instructions, you would be able to impose it?
Definitely.
Okay. Do you believe that you would be in favor of the death penalty in every case where a murder has been committed?
No.
Okay, I have one final question for you then. Is there anything about your views on the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow any court instruction about the death penalty?
I believe so.
Okay, thank you for your responses. I'll ask if the state has any desire for this juror.
Your Honor, we do not. Thank you very much.
No questions, Your Honor.
All right, juror number 779, that concludes our questions for you individually. You'll return with the bailiff to the jury room and we'll have you back here shortly.
Hey, Steph. So my thoughts are if they finish and get their 10 more needed early enough, they might be able to get their preemptory challenges done today. If they
Let's start
don't,
with juror
then
997.
they'll do that tomorrow and then probably start opening statements on Monday. Hi, Steph.
All right, thank you for returning to the courtroom, juror 997. We're going to ask you some individual questions now about responses in your questionnaire. There is some indication of some knowledge about the case in the questionnaire, and I'll ask if the state wishes to pour dire on that issue on bias.
Just briefly, Your Honor.
Go ahead, Mr. Wood.
Juror 997, in your questionnaire, you said you haven't followed the case, just heard some things on the local news a few years ago. Do you recall what you've heard?
I think I was walking through our front room. It was when our kids were younger and they were home and had the TV on. It was a local TV station stating something about the gentleman and the female that were involved. And I think maybe they showed photos of them and that was it.
Okay.
Yeah.
So you definitely have not spent a lot of time following the case?
Not at all. No.
On page 18, do you have your questionnaire with you?
Yes, sir.
Page 18, question 8. You do talk about that you're aware that there are children who have been killed in this case.
Correct.
And it says with the help of Chad. Now, is that with the help of Chad? Is that something is that a belief you have, or just what you've heard?
Just what I heard.
And I do notice in the next portion of that question, it says, could your knowledge of any individuals prevent you from acting impartially in this case? And you say no. So, and so it really, I guess, I just cut to the chase a bit. Is there anything that you've heard that would make it difficult for you to render an impartial verdict in this case?
No.
And you understand that this defendant has an absolute right to the presumption of innocence.
Absolutely.
Until the state proves otherwise. And so can you commit to putting anything you have learned out of your mind and only making any decisions in this case based on the evidence presented in the court in this case?
Absolutely.
I have no other questions at this time, Your Honor.
All right, thank you, Mr. Wood. Mr. Pryor.
No questions, Judge Stevens.
Okay. The next topic then the court will discuss will be relating to your attitudes regarding the death penalty. Juror number 997, in your questionnaire, there was a section about that, and you went through, read the questions and filled out your answers. Do you recall considering that section?
I believe so, yes.
Okay, and it's been some time since you filled out the questionnaire. Is there anything in your responses that you think you would change today?
No, sir.
All right, well, let me advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And as you consider that, you need to think of it as if it would be done, absolute and carried out in the case. So with that context, then you had a choice of whether or not you oppose or support the death penalty, and you said you support the death penalty. You still agree with that in your opinion today?
Yes, sir.
Okay, you had a choice out of 7 of what most accurately represents the way you feel, and you selected a choice that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel?
Yes, sir.
And to be clear then, you would follow any instructions in the case provided by the court on the death penalty?
Yes, sir.
Are you in favor of the death penalty in every case where a murder has been committed?
No, sir, I'm not.
Okay, is there anything about your views on the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions about the death penalty?
No, sir.
Okay, thanks for your responses. I'll ask if the state has any board dialogue.
Not on this subject, Your Honor, thank you.
No question. Abstain.
All right, counsel, that will conclude the individual board dialogue, juror 997. You'll return to the jury room with the bailiff and we'll talk to you again shortly. Next up will be juror 1078.
Yeah, I got to get caught up on the Apple River trial. I keep wanting to call it the Apple Dumpling Gang. God.
Right?
I
Same.
struggle with that. Like, I want to call it the Apple Dumpling Trial or the Apple Dumpling River. I don't know. Jeez. I'm like, what is wrong with me?
Yeah, it's interesting. I'll tell you what, that defense attorney he's good.
Which one? Because
So one of them is from Kyle Rittenhouse. But I don't know which one. I don't know which one is. But the guy with the beard, and the hair, the other one's
Juror
bald.
1078.
Sorry.
go ahead, QB. I'm sorry. We'll pause it for just a quick second. What were
Oh,
you
it's
saying
okay.
about Kyle Rittenhouse?
Yeah, so one of the defense attorneys is from Kyle Rittenhouse is hearing, but I don't know which one, but the defense attorney that is not, one of them's bald, one of them isn't. The one that's not bald, he's good.
Okay.
Not that the other one isn't, but he's done most of it. And I'm not gonna lie, a lot of it I've been laying in bed with my eyeballs closed, so I don't always know who's doing what.
Yeah.
But disclaimer, QB, my views, whatever. He's pretty much discredited every one of them kids.
Really?
Yeah, well, they said one thing when they talked to police, and now they're all saying something different, and they're all saying it exactly the same. And they've all seen the video now. So now they're like, well, yeah, I saw the video, and the video shows this, and the video shows that. No, what happened? And all of them have all said, because they keep asking them, they're like, is your memory at the moment better, or is your memory now better? And they're like, it's the same, maybe better now. And they've all said the same exact thing.
Yeah, that don't
And
make sense. The whole
it's
my memory's better. I mean, I can say that there are situations where somebody's memory might be better later on because in the moment things are so chaotic, and if you're like dealing with trauma from it, or maybe your brain has
Right.
blocked things out, and then eventually throughout time, you start to remember bits and pieces. So I don't always think that, but for them all to say that, that
And
is a
they're
little.
saying it exactly everything they're saying exactly the same. When they're called on something, they have like a token answer. And they all say the same thing. And so and I get like you said, in the moment they were all drinking, they were all way above the legal limit. And so in the moment, yes, you might not remember, but like, you know, a couple months later, that's when you have it, not 2 years later.
Yeah.
And they've all said, "Oh, well, we discussed this right before this hearing. We watched the video right before this here." You know what I'm saying? Like,
Yeah.
and the video, I'm sorry, but the video doesn't show what they're saying to me personally. Hey, Chaloon. Hi, Spins.
Hey, Chaloon and Spins, you two both came at the right time. I was wondering where you guys were earlier. I almost said something, but I
You're not
didn't.
late.
So I'm glad
You
you're
right on
here.
time. Right on
Right
time.
on time. Right
Anyway,
on.
so I have not watched, I've gotten through day 2. I've not watched day 3 or 4. But in my opinion, they have discredited those kids' testimony. Now, the bigger problem is that in Wisconsin, premeditation is part of first degree, and they charged him with first degree. And I think he's going to be found not guilty. There's no way it's first degree. No way. No
Yeah.
way. No way. No
So
way.
what did you say? They said that premeditation has to be part of first degree?
In Wisconsin, it does, yes.
Okay, so they don't think that the premeditation could be because he came over there with that knife in his pocket?
He had that knife in his pocket. His story is he had that knife in his pocket because they had rope to tie the tubes together, and he brought it with him. I've gone on the river. We all have a knife.
Yeah.
We all have a knife. He had it in his pocket. He didn't bring it over there. In my opinion, I agree that he probably had it on him because they were cutting rope. Because you do that. You tie all the tubes together. You tie the coolers to the tube so if they fall over, the cooler doesn't fall out. And the one guy was like, "Well, don't you have rope there that they can use?" Yeah, they charge for it. So why are you
Yeah.
going to buy rope? Why don't you bring your own rope? We always brought I mean, I don't know about there, but I know where we went, they charged for it.
Yeah.
Yeah, we got rope. It's so much per length. No, I'll bring my own rope. So I don't think he had that knife on him because for anything nefarious. I think he had it on him, and I can't say that he didn't start swinging that knife because they were coming at him.
Yeah. 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 Yeah.
I can't say that he didn't. I can't say that he did. I can't say either way. What I can say is it ain't first degree.
Yeah.
It ain't first degree. I think those prosecutors got overzealous and thought they had an open and shut case because this man attacked these kids. And when you watch it and you break that video down, them kids went after him first. Now they didn't have knives, and they say that he punched that girl, but there's no evidence. There's no evidence. And then they said, "Well, we got pictures of the marks on her face. Where are the pictures?"
Yeah.
Oh, well, they said they didn't want them. Really? Really? The prosecution and the police said they didn't want evidence that showed that he punched her?
So what is he saying happened? Because it shows in that video him kind of lunge, but you don't
Right.
actually see him punch her. It's out of the view of the camera. So
So, you can see in the video that he walks away several times and they blocked him. Those other people that came over blocked him. Now, those other people that came over are saying that those kids were yelling for help, yelling for help, yelling for help. But there's nothing on that video that says yelling for help.
no,
They're all laughing and joking. Okay, they're all laughing and doing all these things. So, they don't even look scared. Like, they're all like, "Oh, we were afraid."
Mhm.
Were you? Because you're all laughing and joking and hooping it up.
Well, and they were being pretty
Nasty.
nasty.
And
They
then
were
they
being
all
pretty
came up
yeah.
all came up with this story now, not before. They never said this until now, that he said he was looking for little girls when they asked him what he was doing.
Well, I think they say in the video something about little girls.
Oh. Yeah, sorry. Yeah, there's nothing on the video. There's nothing but they all say the same exact thing. The same exact thing, that he was looking for little girls. And
But
I
they
don't think
don't
he
say
said
that
that.
in the video?
No.
I thought I
No.
heard him say something about I thought I heard one of the kids yelling something about
That he did. They were like, "Oh, are you
looking
over
for
here
little
looking for little"
girls.
yeah, "Are you over here looking for little girls, you pervert?" They were saying that, but none of them ever said in any of the interviews, anytime they talked with the police, on any reports, that he said that. You don't think that's important to say when you
Right.
were over there yelling the things that you were yelling at him? You
Yeah.
don't think it's important to say why you were they never said it until now. And now they all got the same story.
Well,
I
I
think
definitely gotta go back and get caught up. I keep
I
trying to get through the first day, and then I keep falling asleep at night, so, ugh.
Yeah, so I'm gonna tell you, I don't think he's innocent. He shouldn't have pulled a knife on them. Okay. And he certainly didn't need to stab 5 of them. But I also will tell you that I think he was afraid. They knocked him down in the water and they jumped him.
Yeah. They did jump him.
They jumped him. And, they all said in those reports that that girl was up in his face. She was all up in his face. But now they're like, well, she was like near him. Well, why'd you say she was all up in his face?
Yeah.
The one kid was like, yeah, I laid him out. Well, I mean, I punched him. Your report says you laid him out. And then your friend was behind him pushing him up so you could hit him again. I think personally, I don't think anybody deserved to get stabbed. Let me clarify. I don't think
Right.
anybody deserved to die.
No,
Okay.
absolutely not.
I don't, and what happened was brutal. Okay. It was brutal. But what I will tell you is I think they effed around and found out.
Yeah.
I think they were young punk 17-year-old kids that were drinking way more than any adult should drink. Okay. They were smoking pot. Don't have a problem with that. But again, y'all are out there drinking and smoking pot and acting a fool because they were all acting a fool. That video shows they were all acting a fool.
They were being pretty punkish to the guy. Now,
Yeah. Yeah.
I don't know. I thought they said something about the guy had come up to them beforehand that they didn't actually get a video of. I don't know for sure. So I
Yeah,
hadn't
and
heard the whole story.
there could have been something. Their story is that he was walking across is extremely rocky there. Even the father of one of the kids that got or two of the kids that got stabbed. Okay. And the father said in his report, he said, I sent my boys over there to make sure them kids didn't beat up that old man.
Yeah.
Well, then now he's trying to change that. No, homie, that's what you said. You sent
Yeah.
your kids over there to make sure that they didn't beat up that old man. But what they're saying, he hasn't tested. I mean, there's been no testimony for him, obviously. But one of the things that has been said is that that area was extremely rocky. And so when they're saying they lunged at him and he's got that snorkel, he throws that snorkel in his mouth. If you think about it and you look at it, if he lost his footing on the rocks, okay, he could have thrown his snorkel in his mouth so he could grab a hold of the tube so he didn't go down and hurt himself.
Right.
Or he could have been lunging at him. I don't know. But he didn't grab nobody. He grabbed that kid, he brushed that kid's leg when he grabbed the tube, and then he let go. If he was lunging at them, wouldn't he grab somebody?
Yeah.
And again, I want y'all to understand, I think he's guilty. Okay. I think he didn't need to do what he did. I do think he acted in self-defense. I think he was afraid. I think the moment got away from him and he just started swinging that knife, and whoever he caught, he caught. He was swinging it with no disregard or no regard. Um, I don't think anybody deserved to get stabbed. I don't believe anybody deserved to die. But I also, my personal belief is that he acted in self-defense. Now, is it still manslaughter? Absolutely. All day, every day, but they didn't charge him with manslaughter.
Yeah.
They didn't even do a lesser included. It's first degree. That's it.
Jeez.
And that to me, and you see it all the time, that to me is a punk prosecutor that thinks they have it in the bag and they're going to nail him, and they're not going to nail him. And he's
Yeah.
going to be found not guilty. I'll put $1 on the wall right now. I'll put $1.09 like Margaret did. Put $1.09 on the wall. That look, I'll go even further. I'll spend my $1.25 tree money. I'll put $1.25 on the wall that
Wow.
says
She'll put a box of lemon heads on the
a
wall.
box of lemon heads. I'm gonna put a box of lemon heads on the wall that they find him not guilty. There's no way. There is no way that anybody can come to first degree.
Well, what about the fact that he walked off and then like changed his clothes and
That
didn't?
again, I agree. That's guilty. But again, okay. My problem is that you can have a story for both sides and it makes sense.
Right.
Okay, that's reasonable doubt. So on the one side, you say, hey, he threw the knife in the thing, he changed his clothes, yada, yada, yada. Okay. But then the defense shows pictures of him wearing the same exact outfit that he was wearing after the fact when he got to the river.
Yeah, I saw him
He had
taking
the
a
hat,
picture with
the
the group.
sunglasses. Yeah, he
Yeah.
had the hat, the sunglasses, the shirt, and everything on. Okay. They were all in and out of clothes all day.
Yeah.
Sometimes they had their shirts on, sometimes they have them off. That's what you do on the river. Okay. When you go to leave, you put everything back on because you don't want to carry it. You put everything back on and you leave. So the clothes, I say you could go either way on that. The knife, yeah, he threw the knife. Okay. Me, I'm the type of person I would have been like, look, I was swinging and here's the knife. I'm sorry, my bad, but they scared the crap out of me and I just came up swinging. Him throwing the knife does make him look guilty, but also, you're in shock. Could you be
Right.
in shock? You could be in shock. That's my point. I feel like that you could go have a story to fit a narrative to fit either side, and that's
Right.
reasonable doubt. What's
Yeah.
Margaret saying? It's a sad case. One day you're going to PO the wrong person. The person could be a guy on a half case of beer with a knife. But see, they didn't even show he was drinking, Margaret. They haven't even shown that he's drinking. There's been nothing that's been said that he was drunk, that he was drinking. There's no pictures of him with alcohol. His friends have alcohol, but he's off of not just off of, but a few years off of a massive heart attack and a massive bypass surgery. They haven't proven that he was drinking. But, in this day and age, I tell my kids all the time, especially man-child, when driving around here and I'll see him start to get angry because people around here are stupid. Okay. They drive stupid. They run red lights. I tell my kids all the time, count to 5 before you jump the line. I don't care if people behind you are screaming or whatever, because they run red lights here on the reg. Okay. We're in a tourist college town. But I also tell them, you don't never, ever road rage at somebody. Don't ever be blowing your horn. I mean, you can honk, honk. Don't be laying on the horn. Don't be screaming, because you know what they do here? They pull out a gun. Okay. I don't live in a bad area, but bad things happen around here. Y'all still
Yeah, I
there?
get it. I
You know what I'm
understand
saying?
it.
And
Yep.
so, like Margaret was saying, you don't know you're gonna PO the wrong guy. That's what I tell my kids. You don't know they're not gonna pull out a gun because people carry around here. They
Yeah.
carry,
Yeah.
and you get the wrong person and they'll shoot. You get somebody having a bad day, they'll shoot.
Right.
And I'm sorry, but if somebody's coming at me, calling me a perv and all the things that they were calling him and riling the crowd up. I mean, they riled the crowd up.
Mm-hmm.
Brought a whole nother group of people from up the river. 13 on one. Not at one time, but there was 13 there and he was by himself and his people were way down the river. Now I will say this, I have not seen the quadruple bypass. Thank you, Morgana. I have not seen the wife testimony, the ex-wife testimony.
Oh, they're not married anymore?
No. So I have not seen that testimony. I will tell you that I will give it the credit that it deserves in that she is his ex-wife. I don't know if it's contentious or not. I haven't
Yeah.
seen that part, so I don't know. But through day 2 of what I've seen, if I'm on that jury, I can't. There's reasonable doubt all over the place. And everything the prosecution brings up, the defense knocks right down and they got receipts. They're like, tell me on this video where you see blah, blah, blah. Yeah, I don't see it. So where was it? You're saying that these kids were yelling for help, 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 help. You heard them across the river, but they're standing right next to the guy videoing and the video didn't pick it up.
Hmm.
But you heard it across the river? Mm-mm. Mm-mm. And not a one of them looked like they were in distress. Not until the knife started flying. When the knife
Yeah.
started flying, yes. Yes. And it
Yeah.
broke my heart because a couple of them kids weren't even part of it.
Right.
They were just sitting there being, I mean, even the one kid, when the one on the video you can hear, sorry, I've gone down a rabbit hole with this, but the one kid, when the one kid calls him the R word, okay, I don't want to say it
Yeah.
but the one kid goes, hey, 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 you hear him go, hey, 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 like, dude, what are you doing?
Mm-hmm.
That Isaac kid, so
Yeah.
far, I haven't really seen him doing anything.
Yeah.
I'm not saying he didn't. I think he was just in the way. And that's sad. And they both, honestly, both sides should be held accountable. Them kids should be held accountable too. Them kids should be charged with assault for jumping that man.
Well, I know the kid in the yellow trunks that pretty much have been gutted.
Yeah.
But he lived. He was with the crowd from across the way. He
Yes.
wasn't even with
Yep.
them.
Nope, he
And
wasn't with them.
yeah.
And the problem is that they kept saying, "Oh, we came across the river to find out what was going on," but they never asked any questions. They just jumped
Mhm.
in.
Yeah.
They just jumped in. And so, and like I said, nobody deserves any of that. I mean, they life flighted that kid out of there. He's lucky he survived.
Well, they said that he had to have emergency surgery and
Yeah.
was in the hospital for like 6 months or something.
Yeah. I think it was like
And
6 weeks, but
oh, I thought
I
they said
mean,
months,
it
but
might have been. I'm
and
not
then the
gonna lie.
girl, she had to have emergency surgery too, and she was in there for a long time.
Yeah.
But
I mean, that knife was
well,
sharp. He was cutting rope.
yeah, you could tell the knife was sharp. I
I
mean,
mean,
you could tell.
you start swinging and and I'm not excusing it because that's not okay. Nothing about that is okay.
Right, right, right.
But in the condition that he was in, as far as his age, okay, his heart, all right, his health and all that stuff, him fighting back at 13 people, does he have a chance? And they threw him down. And
Yeah,
then
they
they
did.
jumped him. And
Yeah.
then they hit him again, and they hit him again, and the one guy's behind him pushing him back up. Now they're focusing on the fact that, oh, the water was only 10 inches deep there. Okay. That's fine. But it's very rocky there. All right. You can cut yourself on a rock. You can bust your head open on a rock. They could bash his head into a rock.
Right.
Okay. You're also, that river drops off. Because when he comes across, you can see he's wading in high water. So what
Right.
if I mean, there's so many things that you don't know what's going through his head.
Right.
And again, I want everybody to understand, nobody deserved to be stabbed. Nobody deserved to be killed. And he shouldn't have been swinging that knife willy-nilly like that. I mean, would we be having this conversation if he would have stood up and wielded that knife and said, y'all better back off?
Right.
And they came at him, and then he ended up stabbing him. I don't think we'd be
Right.
having this conversation.
Right.
Anyways, I'm gonna be done now.
Definitely tragic. Definitely tragic. But I do need to go back and
Yeah, I'm sorry.
watch it.
No,
I mean, I need to go back and watch that actual trial. But yeah, we do need to get back to the jury selection. But yeah.
I'm sorry.
No, I'm glad that you mentioned it because I want to go back and watch it. And
I get irritated with prosecutors that allow people to go free because of their ego. And that's what I feel like this is. I think their ego, they thought it's first degree, he attacked some kids, yada yada yada. No, he attacked some people that were attacking him, that were drunk and high. Okay. That were so drunk that they were 1.5 times the legal limit.
Yeah.
Some of them. Okay. The one kid, I'm sorry, I'm going on it again. The one kid, they're questioning him. He's like, yeah, I had a few beers. And he named out, I had a Truly, I had this, and I was carrying a Celsius or whatever. And then when the defense attorney's like, dude, your blood alcohol level was like 0.121 or something. You're 6 foot tall and 175 pounds. You don't get to that with a Truly and a Celsius and a beer. And he goes, well, yeah, I had some shots on the bank.
You didn't say that.
Right. And then he says, well, he didn't ask me that. He asked me how many beers I had. But you know what he's asking you.
Right.
And he's like, so you're not going to tell them that you were doing shots up on the riverbank and y'all are impaired. Because a Truly and a Celsius, you're like, meh, you're not impaired.
Right.
0.121, you're impaired.
Yeah.
Especially at 6 foot and 175 pounds.
Right.
Anyways, I'm done now. I'm sorry.
All right. Well, we'll have to do a little group discussion on this trial. Maybe we can do a maybe that can be something where we all go watch and then discuss it during the lunch breaks during the trial. I don't know. We could try that. Yeah, the knife was all he had to try to even the playing field, unless he'd grabbed a rock up out of it'd have been the next best thing. But, yeah, let's get back to the jury selection.
Sorry. I'm sorry. I derailed it.
No, you're good. No, quit apologizing, ma'am. Stop it.
I have very strong fit, like Patricia says, like Casey Anthony. They overcharge. That's how people that need to be. I mean, I'm not saying that he don't need to be charged with something. He killed somebody.
Right.
Okay. He maimed 2 others. Okay. And it's traumatic for everybody. All right. He needs to pay a price, but first degree murder because you think your case is so good because you got a video. Well, you didn't depend on the defense coming in and being like, oh, well, right here and then right here and right here and refuting everything you're saying. Sorry. I'm done.
Okay.
I'm done. I'm really done. I'm going to mute myself.
No. Spence says, ma'am. What is it?
can't.
Margaret says, I'm sure we're behind on I can't serve on this jury because I don't have enough underwear for 6 weeks. That made me
Exactly.
cackle.
Exactly. My wife can't make my lunch.
Ay, ay, ay.
And I get, you know what? We were all making fun of that poor girl about her making her husband his lunch, but they've been married 41 years. He's got health issues. If she don't make his stuff, I mean, they excused her. If he don't make his stuff, he going to McDonald's. Like,
And that makes him sick. Yeah.
yeah,
And you know what? That's the thing is the prosecution and the defense both and the judge is probably like, yeah, that's me, or yeah, that was my
right,
honey.
right,
Let's just let them go because yeah, we don't
right.
want daddy to get sick.
The only one that I don't get is the police officer and the police officer's the police officer and his wife is a police officer, and he's got the contentious relationship with the ex-wife. And the defense and the prosecution both said, this is a hardship. We're releasing him for cause. And the judge was like, nah, homie, you get to stay. I was like, what? What? Now
Yeah.
that doesn't mean he won't get kicked later, but Morgana, yeah, John, John would be like, "Ooh, she didn't make my lunch. I'm gonna go mow the leaves and have a Whopper,
A whopper.
a Whopper."
Patricia says, I
So,
think a lot of us don't know how our husbands would survive without us that long. I
right?
don't know. My husband's the cook. My husband's the one that cooks, but does he eat things he shouldn't eat all the time?
Yeah.
He would always eat off of dirty plates and silverware because he never
Yep.
washes dishes. And yeah, so there you go.
2 double cheeseburgers and mowing the leaves. I'm just saying, he'd be out there on the lawnmower eating his double cheeseburgers. See, I'm with him though, because I like them McDoubles and they buy one get one for $1. I'm just saying.
Mm.
I don't
See,
know
you're
why I
making me
know that.
hungry again. Let's quit talking
Right?
about food. All right, let's go. Let's go,
All right,
Kiki.
let's
Let's go.
go.
Let's go.
Let's go. All right, mute.
Welcome back. We have some individual questions for you. In review of the questionnaire, I didn't see any indication of case knowledge or potential bias. Is the state intending to board ire on that topic at all?
Well, Judge, we do have just one bias question.
All right, why don't you commence with that then, Mr. Wixon?
Thank you. Ma'am, do you have your questionnaire with you?
Yes.
I just invite you to go to page 7. Excuse me. And on page 7, under part 4, 1A, it says, do you feel that a defendant should be required to testify? Did you mark that? Yes.
Yes.
Could you explain what you mean by that?
I think when I filled this out, I didn't really understand what that meant exactly, but after what we heard today, what I learned today, I understand that he has to be too, and it's not required. Yeah, I just wasn't clear.
Fair enough, fair enough. So is it fair to say that if you're on the jury and the defendant chose not to testify and to remain silent, you wouldn't hold that against him in any way?
No, now that I understand, it's not required.
Thank you. Your Honor, I don't have any more questions.
Nope, that's good, Judge. Thank
All right, thanks, counsel. There's one more topic then we'll discuss with you. In your questionnaire, starting on page 12, we had you read through and answer some questions on your attitudes regarding the death penalty. Do you recall going through those questions and answering them?
Mm-hmm. Yeah.
Okay, having thought about your answers since you filled this out last week, is there anything you think you would change on any opinion you've given here?
No, I don't think so.
Okay. I do want to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So thinking about that, you had a choice on page 12, whether or not you support or oppose the death penalty, and you said you support it. Is that still the way you feel now?
Yes.
Okay, if you could look on the next page on 13, You were provided 7 different choices of what most accurately represents the way you feel, and you chose D, which reads, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Does that still accurately represent the way you feel about the death penalty?
Yes.
And would you be able to follow any instructions the court gave in this case if you had to consider that?
Yeah.
All right, I'll next ask you, are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay. Finally then, is there anything about your views on the death penalty that would prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions?
No.
Okay, thank you for your responses. I'll see if there's any board dire from the state.
We have no questions, Your Honor. No questions, Your Honor. Thank you.
Okay, thank you for returning that conclusion, individual board dire. Final juror will be 1100. All right, welcome back, juror number 1100. We have some additional questions for you individually here. I would note that you did raise your card when we asked if you knew something about the case. You mentioned a little bit about that in your questionnaire also, saying also you did not follow the case. And then I'll just ask the state if the state would like to commence with individual board dire for this juror on the issue of bias.
Yes, Your Honor, thank you.
Go ahead.
Good morning, sir.
Morning.
So you indicated on your questionnaire that you had a little bit of media exposure to this
Yeah.
case?
I mean, I listen to the radio, I watch TV reports and things like that, so it'd be hard to miss something. So yes, I'm aware that the case existed, but as far as I was concerned, it was over with. I mean, it's been 3 years or something like that. I just know it's been long.
Thank you. So this might sound like kind of an odd question, but what do you know about the case? Just kind of an overview.
All I know is that there were some deaths that occurred. I do know that there's the one thing that stuck in my mind. I don't even know why. Was that people had gone to Hawaii. That's the only thing I can remember.
And do you know what people had gone to Hawaii that you saw in the news? Okay.
Sure.
And would you be able to set aside whatever you've heard on the news and only consider the evidence that's introduced in trial in this case?
I will do that.
And sir, you'll be instructed that Mr. Daybell is entitled to a presumption of innocence until the state meets its burden of proof beyond a reasonable doubt. Are you okay with that?
I am. I think I need to probably have a little bit better understanding of where that line is of reasonable doubt. That's one thing I tried to understand. And so from my standpoint, I don't know where that line is drawn.
And you'll be instructed on that by the judge. The judge will provide you several instructions, and one of those instructions will be a definition of reasonable doubt that you will have. But for today's purposes, I just want to make sure that you can start this trial with a clean slate, giving Mr. Daybell the presumption of innocence that he's entitled to.
I believe that I can do that.
Okay. Thank you very much, sir. I have no additional questions, Your Honor.
All right, board dire from the defense.
And again,
Sir, there's no right or wrong answer. There's no right or wrong answer here. We're just trying to get your feelings and your impressions, and this is a chance for us to talk a little bit, to delve in deeper about things. So please don't take any offense to what I ask. Thank you. Do you have your questionnaire with you?
I do.
And I would turn to page 19. Item.
I have it in front of me.
Okay, item number 10, and I want you to go to 10D. And let me know when you're there.
I'm at 10D on 19.
And I'm going to read this so that we, and then stop me if you need to. And it reads as follows. Has any of your possible exposure to the news media, dramatized depictions, or other publicity around the case caused you to, and you underlined, form an opinion about Chad Daybell's guilt or innocence? And your response, you didn't mark the yes or no, but you said possibly because of their nature, but understand that I would need to evaluate the info at trial. So if I understand what you said there, and don't let me put words in your mouth, okay? Please clarify that and say what you need to say.
Okay.
I've gone through a number of these, and then there are a lot of people that say that. They say, you know what, at the time of trial, I can evaluate and look at the evidence independently, despite the fact that I may have some information that leads me one way or the other. Okay? And I have no doubt, and I think, I guess if you would commit to this, at the time of trial, you would be able to look at the evidence and make a determination based on what you hear during the trial, right?
I believe that I can, yes.
Okay, and that's where I'm struggling a little bit.
Okay.
Because part of your answer said possibly, and what I read that to mean is that you already have some impressions in your mind. You already have some images, and you have an idea of what you think about this case, right?
Yes, because of the nature of those reports.
Right.
You talked about that earlier.
Right.
And that, you know, sometimes when media is doing things, they do that with, you know, an intent to convince, sometimes with an agenda.
Right.
And so there's no doubt that because of the things that I heard and saw, you don't form some sort of an opinion. People always come up with some sort of advice. I think anybody would be, I guess they would be dishonest if they weren't telling you that there wasn't some sort of a bias that does come into that. But I believe that now being asked, if I were to be asked to be a juror, then I have to set all that aside and I have to then look at the information that is presented.
And you know what? I respect and admire your honesty. I really do, because you know that says a lot. That what you're willing to do is you're willing to evaluate this case at the time, despite the fact that you've had access, and despite the fact that you've seen some things and listened to some things, and that you've formed an opinion based on what you've said from these folks in the media who sensationalize things, right? But that has caused you to form an opinion at this point. But despite that, you're willing to sit down and look at this thing and make a determination. Would that be fair?
I am, yes.
Okay. And please don't take offense to anything I say.
Sure.
And again, there's no right or wrong answer. It's just we have to look at this in a certain way, and that's why we have the jobs that we do. Okay. And Judge, I'm going to move for pause on this one.
All right, response from the state.
Your Honor, if I could ask just one question.
Yes.
Sir, I don't know if I missed it, but I believe Mr. Pryor had made some reference to you forming an opinion. Have you formed an opinion? And if so, what is that opinion?
Well, the opinion is just that it was an egregious crime that occurred, and that the people that have been identified were more than likely those folks who, again, were involved in whatever occurred. And again, I don't know the details now, other than just the little things that I heard on the news.
Okay. And do you know who those people were?
I didn't even know the names until I got called on this, and it's been mentioned who the case was about. That's all.
Okay. Would you be able to set aside what you've heard on the news and and just consider the evidence in this case?
Yes, I will.
Okay. Your Honor, I'd submit to the court.
All right, and not to prolong things unnecessarily, but there were a few other comments that came up that I think in fairness, Mr. Pryor, if you have any additional voir dire on his statement, you can proceed. If not, I'll make a determination.
So on number D, talked about that you have formed an opinion, but you're willing to set that aside. Is that correct?
Yes, it's not a strong opinion. It's just, I knew that at one point in time I had formed an opinion.
And then underneath that, there's item number F. Have you formed a personal opinion whatsoever based on information from any source of Chad Daybell's guilt or innocence or anything? And you said not beyond D above. And what that's saying is whether Chad's guilty, he's one of the parties, obviously, to the media that you saw. Is that right?
Yes, I mean, and I know in this context that.
Right, he's one of the parties.
He's one of the parties.
And you formed an opinion that, and you're willing to evaluate the information that's presented to you if you're picked as a juror, but that's going to require you to say, listen, I'm willing to set aside my personal opinion about Mr. Daybell's guilt and evaluate this independently. Is that what you're saying?
I am. I believe that I've already done that by the fact that I've now been asked to be a juror.
Okay.
So then you have to go back to ground zero in my mind and start over. But again, to be honest, I have to say that it's natural for someone to hear those reports and to immediately assume at the beginning that stuff is correct.
And that's something that we all have to discipline ourselves with, right?
Correct.
When you're in a situation, all of us, and I agree, when you read something and you look at information and you're exposed to the variety of the information, you form an opinion.
Yes.
And what has to happen is you have to make a discipline yourself to say, in spite of the fact that I've formed an opinion, and in spite of the fact that I've sort of decided this is what I sort of think, I'm going to set my opinion aside and work towards trying to be fair based on the information I hear at trial, right?
That's correct. I've had to do that many times in my life.
Okay, and did you hear anything else about any other co-defendants in this case of any kind?
No, I just know that there was the deaths that occurred, and I also know that there were people who were identified. And I can't tell you even how many at this point until was gone over the charges.
Right. And so you'll agree to set aside your opinion that you've put together today. And based on that, you'll try to discipline yourself. You said you'll try.
Yes, I will.
Okay. Judge, if I could just have a moment.
Yes.
Nothing else, Judge.
All right. I have a couple of follow-up questions, Juror 1100. So just knowing what you do know, would you think this defendant here, Mr. Daybell, would need to somehow convince you or show you some proof that he's not guilty?
No.
All right. Given what you do know about the case or what you've seen or heard, will you commit that you would follow the court's instructions and hold the government to its burden of proof?
I will.
All right. The court is on this juror going to find that there's not a bias or prejudice at this stage that would prevent his service based on previous knowledge of the case, so the challenge is overruled. We have one other area to go through with you then, juror number 1100. You did fill out a questionnaire asking you about your attitudes on the death penalty. Do you remember that?
I do.
Okay, I want to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, as you consider that, you must consider it as if it would be done in absolute and carried out in the case. Do you understand that?
I do.
All right, when you filled out your questionnaire, you were given a choice of whether you support or oppose the death penalty, and you clicked a box of support and said, as the law instructs. Is that still the way you feel today?
What page is that on?
This will be on page 12.
Yeah, I have that.
Is that still the way you feel today in terms of your attitudes on the death penalty?
It is still the case that I do support that, but again, it needs to be in the appropriate context.
Okay. If you look at page 13, you had several choices here. What most accurately represents the way you feel? And you ultimately circled C, which reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. It looks like also you were really thinking about D because you kind of bracketed that a little bit and also underlined part of it. So is between those two, if you had to pick one, is C still your choice?
It has to be C, that's correct.
Okay. And are you willing to follow the facts, law, and instructions provided in this case if you're considering the death penalty?
I will do that.
Do you believe that you would be in favor of the death penalty in every case where a murder has been committed?
No.
All right. Finally, is there anything about your personal views on the death penalty that you think would substantially impair or prevent you from serving as a juror in this case and following any instructions about the death penalty?
I don't think there is.
All right. Thank you for thinking through those questions and answering them for the court. Does the state have any follow-up for Dyer on that topic?
I don't. Thank you, Your Honor.
Any follow-up from the defense?
Ever so briefly, sir, when we go back to page 13, you had your number that you marked as number C, or C if I remember right. Is that correct?
I had marked C and D was just kind of bracketed to it.
Right. And what I guess I'm asking you is that there's if there were a box that said neutral between C and D, and that was one of the options, and the neutral said, I'm neutral on this issue, but I'm only going to base my decision on the facts and evidence. Would that more likely reflect your perspective on this?
That's correct. I saw these as rated in a scale, if you will.
Right.
Descending, whatever.
Right. But again, if there was a neutral, you would say, you know, I'm more neutral on this, and I'm going to listen to the facts and evidence before I make a decision.
That's correct.
All right, Judge, I have nothing else. Thank you, Your Honor. I appreciate the time.
All right, juror number 1100 then. We will pass that juror for cause on the others, and I don't know if it's more efficient to have him remain and have the others brought back or have him return and brought back with everybody. Let's have juror 1100 go back in the jury room, and then we'll have the remaining jurors brought back in once they're ready. All right, please. Council, here you are. All right, thank you. Please be seated. All right, for those jurors that have returned, if you do us a favor one last time, and please just hold your red cards up so we can all confirm with our charts who's remaining. Okay, thank you. Having considered now these remaining jurors and concluded individual and group voir dire, does the state pass this small group for cause?
Yes, Your Honor, thank you.
Does the defense pass this group for cause?
Yes, Judge, thank you.
All right, ladies and gentlemen of the jury, then you have now been passed for cause. We will continue to question additional small groups until we reach the necessary number of jurors for the attorneys to exercise their peremptory challenges. You will be leaving today and instructed to contact the jury commissioner, Randy Rutland. He will provide you further instructions on when you will return again. And you are going to be returning one more time for the peremptory challenges stage of this trial. We're not entirely sure of when that will happen. So between now and when it does, please continue to follow the court's instruction to not investigate the case, look the case up, talk to anyone about the facts of the case, or do anything else that may cause you to become impartial or exposed to facts about the case you shouldn't know before trial. Also, you can talk to people, family, friends, employers, etc., about the possibility of your service and when that may occur, but just please refrain from engaging in any discussion with them at all about the case. You will be asked to complete another affirmation as you did today when you come back, indicating that you have followed that court's instruction. So thank you again for your time. You'll receive those further instructions. And at this time, I believe we'll have you excused. Is the state okay to have this group excused for the day?
Yes, Your Honor, thank you.
That's all right with that as well.
Yes, Your Honor.
Okay, thanks. All right, for the jury. All right. Thank you. Please be seated. All right, we're scheduled to have another group returning at 1:30 this afternoon. Is council ready and prepared to do that after lunch?
Yes, Your Honor.
Mr. Pryor?
Yes, Your Honor.
Okay, thanks all. We'll be in recess then until 1:30 when we'll reconvene with another group of jurors.
Thank you. All rise.
All right, so it looks like they're on lunch till 1:30, which
They're on
is
a break.
3:30 Eastern. So we have about an hour left.
Let's see if they come back on time.
No,
Although
right?
you can fast forward, man, we're
Yeah,
behind.
I'm going to. I'm gonna go, which still it would be. I mean, if they said 1:30,
It'll be
that would
3:30.
be 3:30. Yeah. So, all right, we are now live. We are now live, and QB fell down.
God bless America. I love
QB's back.
boing. Boing.
Bow, bow. Bow, chicka, bow, bow.
Ma'am, I don't think we did nothing with brown chicken, brown cow.
Brown chicka, brown cow.
We were on a break. We were on a break. We really were on a break. We 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 really were on a break. We were on a.
Was it on loop?
I had it on loop, and then I turned the loop off.
Y'all, Children was talking about Dexter. Okay. I have a Netflix problem. I don't have it.
Oh, wait. I'm gonna, I love Dexter.
Me too.
I'm like in love with him. Patricia, real quick, I want to just, yes. Um, I actually wanted to do a live stream this morning before the jury selection started, but I ran out of time. And I've got some things like lined up for that. So yeah, I want to be talking about her soon. Yes. Um, yeah, I wasn't a fan of the ending of Dexter, but I feel like it kind of left it open
for a comeback.
Yeah. Yeah. I think so. Steph says she would cancel Netflix if it weren't for the true crime documentaries.
That's the thing. Okay, I just love. Okay, we're not gonna discuss it, so QB don't get in trouble. But I may or may not have been crowd sharing the Netflix,
Oh yeah.
and now you can't do that. And so I'm battling with myself because I don't want to pay for Netflix, but I may have to pay for Netflix.
So how come you can't crowd share anymore?
They've got it on lockdown.
Oh, they got smart,
So
eh?
they did got smart. But they keep raising their prices and it's ridiculous.
Yeah, I know.
I mean, you ain't YouTube Premium now. Come on.
Well, didn't Netflix used to originally be like free? Like when they first started.
I don't think so because you had to pay for their service to get their DVD. When they first started, they were a DVD service, and they mailed you DVDs.
Oh, that's right. Yeah.
But you had to pay for that, and then you got the DVD, and then when you sent it back, then they were
You
like,
got
"Okay,
another
here's
one
the
that was
next one. Yeah,
huge.
here's the next one."
Yeah.
Yeah.
That's true. Maybe I'm
And
thinking of Hulu. Maybe it was Hulu that was.
Oh no, I love some Hulu. Yeah, $2.99, and you got the DVDs. Morgana, I don't want to pay for Netflix.
How much is it?
Oh, like $12.99 or something.
Pay for Netflix. Good gravy.
No, I don't watch it enough. Like I need to have. Here's what I need to do. I need to do like a free, if they have like a free 7-day trial, and see how much I watch because I haven't watched it very much. I watch it here and there. No. But I went to watch the Doomsday thing the other day, and it said, "We noticed that you're not in the household," and I was like, they're like, "Are you traveling?" And I was like, I don't know. Like, how do you know? Like, am I traveling? I don't know. Are you part of the household? No. So I
So your
deleted it.
boys don't have it?
No. They don't do the Netflix
Do they
thing.
use it?
No. Well, okay, so to be fair, oh, you know what? I need to ask Z because Z's on the same account I was, and I need to know, is he lying? Is he saying he's in that household? Because I will double back. I won't. It's okay.
Just
So here's the
saying,
thing.
if he's if he's uses
No,
it
I need to
and he
grow
lives in your
up.
house, make him
Here's
split
the
it with you.
Z don't live here.
Oh.
That's my baby. So Manchild ain't got it. Oh, I don't want to pay for it. I don't want to pay for it. I'm being a child. I know I'm being a child. Here's the thing. Y'all gonna laugh. Okay, so it's my ex-husband's Netflix. And we've always shared stuff. And it's never been a thing. but he's getting remarried. And now I'm like, I don't feel like I should.
So his new wife is like, you better not be
Well, they're
sharing
not
that
so they're
Netflix with
not
her.
married. They're not married yet. But when you pull up the Netflix, you know how it says who's watching? It's like C, Z, M, and QB. Now, if I was gonna be the new wife, I'll be like, hey homie, who that?
Mm-hmm.
I mean, I know she knows who I am. And she's good to my kids, so that's all I don't care. But anyways, I deleted it. I withdrew. I withdrew. Spin said she's been traveling. Okay, my thing is, okay, here's what happened. Here's what happened. Here's what happened. So everybody comes and they visit M, right? And they put all their things on her TV, right? Because they come and then they watch a movie with her and they're like, oh, I got the Netflix here. I'll put it on your TV or whatever. So then it's on her TV. So then her and her sister, like, they go, oh, I think we'll watch a movie, and they open the Netflix. So they opened the Netflix the other day, and they just were a whole lie, okay? And the person who's M's friend, she's not good people. Anyways, apparently they charged her for an additional account, and she was big mad. So she texts me, and she's like, "Why are you using my Netflix account?" And I was like, "Stand down, ma'am. I haven't even been there. I didn't touch your Netflix account." But I appreciate you coming at me like that.
Hi, baby.
Hi, baby. Hi, Jolie. Hi. I love her so much. So anyways, I don't know, like, if you lie and say you're traveling and they find out you're not, and the VPN thing stuff, I don't understand all that. Like, I get it's like a separate thing and you can pay for it and it's private, and I don't know. I don't get it. Like, it's not worth it to me to watch Netflix. Is all I'm saying. So maybe I'll go back in and I'll change my name. I love Tubi. Ad free is like
Yeah, I like Tubi
$18,
too.
right, Ween Baby? It's I don't like it. It's $18. I mean, they're not. See, Steph's got the $23 one. No, homie, because you got to pay too. Okay, Netflix is like, this $18 gets you one account. One person can watch at a time. What's the point of that? Margaret,
Well,
that's
I
what
don't
I'm saying.
understand what Steph got for $20 that somebody else could have for 12.
No, she's got the premium. She's got the bougie one that you don't get no ads, you don't get no nothing, and you can have like 4 people watching at one time.
Okay, and then what's the $12.99 one got?
It's got ads and everything else. I don't do ads. That's like me paying for shipping. No. Mm-mm. Nope.
Well, then you're gonna have to pay more than $12.99.
I'm not buying it. I'm not doing it. Freebie. Yep, I like Freebie. Margaret, premium YouTube. They keep raising the price, and I'm like, okay, YouTube, here you go. Here's my monies. I can never go back. The biggest mistake I ever made was getting YouTube Premium. They got me. They got me forever. They'd be like, it's gonna be $29.99. Okay, you got my
Take my
card, right?
money. Take my
You,
money.
here's my monies. You got my card, right? Just yeah, go ahead.
Just swap it.
Yep, I can't. I can't. And like the one time,
And she gone.
added me to it. Man, come
You
on.
need, I tell you what you need. You need StreamYard Premium, ma'am.
Clearly.
I
hate it here.
There ain't no such, well, there is such a thing, but
Right, Ween baby, you got to pay for the VPN. So wait, no, I'm
well,
just
how
not
much are
into it that much.
VPNs though?
I don't know. I don't know. The ex-husband's got one because he's trying to be off the grid. I'm like, sir, you have a cell phone. You're on the grid. Done. It's over. You're on the grid. And Margaret, right?
I have
Look,
premium too. I won't hardly watch a
what y'all
commercial.
missed, though, because I dropped down, 'cause my Wi-Fi hates me, is that not the girlfriend decided it was cheaper for them because they're, domestic, to do family, and they got an extra one, so they threw me on it, so I don't even have to pay for my YouTube Premium anymore. What?
Lord.
Because
Well,
we're on the
see,
family
take that
plan.
money then. Take that money and go buy daggone Netflix.
I am not. It irritates me. It irritates me to the core of my being that they act like that.
Okay, so would you rather be irritated for that and
Right,
have to
right.
pay it, or would you be irritated because you're not able to watch things you want to watch on Netflix?
But here's the thing, I have like 18 email accounts. How come I can't just keep getting free like and just watch what I want to watch? I don't know. I'm saying this on the interwebs, and Netflix is gonna come for me.
You sure are. You sure are, man.
I'm just saying. Oh, there we go. Steph solved it. Steph solved it. Well, we got to figure out the watch party thing. Steph, you weren't there the whole time the other day, but
Oh
we were.
Lord, yeah, that was bad. It was real bad.
It was bad. We were playing juggling hosts. What's it called? Anyways,
Musical hosts, like
musical
musical
hosts.
chairs.
Yes, we were playing musical hosts. So once we figure it out, or alternatively, Jenny can't move, like she can't walk around. But yeah, we could just watch party the stuff I want to watch. Steph, let's go watch party. I got a Discord. We can watch party. Let's watch party something.
If you put your traveling on Netflix, they'll email a code. If Netflix goes by IP, then it probably won't work because they'll see you have another IP and they'll send a code.
Rude. We didn't have any issues with Freebie because we weren't stopping and starting, and it wasn't a live. The whole live watch thing. It. I don't know if it was the live thing. We got to figure out that host thing. That's on my list.
Yeah, the whole thing was bad. All
It's
the
on
way
my
around, it was
list.
horrible. Yeah. Spins, do they usually go really smooth?
I think the problem was it was live. And also, there's got to be a setting. Okay, because we do them on Calf, and I'm telling you right now, Calf ain't playing musical host. She would lose her mind. So
Yeah.
no, that's not happening. So there's got to be a setting. There's got to be a setting so that you can host it. But I think the host thing is just when it's live. I don't think like when you're just watching something like on Freebie, I don't think there's like a host per se. It's just the Discord. I don't know. It was confusing.
Yeah.
And I don't know what I'm talking about, really.
I don't know. We'll figure it out. We'll get it figured out. The weekend's almost here. We'll figure it out.
Weekend's almost here. Watch party. Well, let's watch the
Well, these are actually faux watch parties because they're tests.
They're tests.
They're watch party testies. I said that on purpose
So,
too.
I know. I was
Testies.
gonna say, ma'am.
I didn't want anybody to be like, she just said testes. Kind of like QB and her looking at Dale's. Dale has a nice bird. She left. I love you.
I couldn't have timed that better. I didn't do it. Like I just dropped out. Like it just kept.
I
It
thought
just.
you did it on purpose.
I know, right? I should have said I did. That would have been perfect. Balls? What? Nobody said nothing about no
No.
Cojones. No.
Nope.
Yeah, see, sharing a sharing a stream like freebie and hosting a live is two different things. We got to figure it out. That's why everybody keeps going, "Where's the Discord? Where's the Discord?" Yeah, y'all don't want to be in there. It's scary.
No, it's not
It's a work
good.
in progress. It's great, but it's a work in progress.
Silly honey,
Don't say
stop
it's
with the
not
work.
good. I set the whole thing up. Why are you saying that?
No, it's good, but it's a work in progress. It's a literal work in progress. It is not, um it's coming along. QB's doing a really good job on, like, making all these neat little folders and,
I just added some more.
cute little ideas. It's all going well. However, the functionality of the other things like privacy settings and watch party things
Yeah, so what we
is
need to figure out right now, we need to figure out the watch party thing. Because I feel like that's something that we'll want to do in the future. Like when we watched
yeah,
the Bob thing, that was cool. That
right.
was cool, and that would be fun. Um, the other thing is, I gotta figure out. Okay, you and we's need to decide on roles, and I need to make roles because then I can give everybody a role. So you have like admin, you have moderator, you have just Joe Schmo, okay? And so when you give them that role, I don't have to set everything for every channel. I don't have to set privacy for every channel and rules for every channel. It's just okay, Joe Schmo can go in and look at the things, but they can't delete anything, they can't change anything, they can't modify anything.
Right.
That's the Joe Schmo role. I mean, we could call it that because nobody sees their role. Unless you turn red like me, because I'm like, or pink. Is it pink? It's pink.
Yeah, it's like a pinkish red.
It freaks me out. I don't know why. It's just, it's abby normal. Like, usually I'm white or purple. Moderators and the other channel I'm in is purple.
Oh, gotcha.
But I'd be Joe Schmo. Yeah, I mean, Joe Schmo needs, like, because people get stupid. They'll go in there and they'll get mad and they'll be like, I don't like what you said, and they'll delete it. We don't want none of that. So your moderator should have deleting power, okay? Because if somebody comes in, if control comes in and posts something, you want your moderators to be able to go in and be like, nah, no, we're not doing that.
Yeah.
Okay. But everybody else just needs to have a basic role, which is pretty much view only. I just haven't figured all that out yet. And you and I need to talk about like how we want to do that, because my suggestion would be that it doesn't have to be you necessarily. It should be you, but you could have other people so it doesn't fall only on you, has to allow someone into the server. Okay. They come in, they go into general, okay, and they sit in general until they agree to the rules. And you go, oh, hey, look, Spins is trying to join the Discord. She agreed to the rules. Let me assign her a role. And you give her a role, Joe Schmo, and she can then enter all of the things. So we gotta hash all that out. That's all I'm saying. Sorry, we don't need to have this discussion like right now, but they're on lunch.
Right.
But I just
You're
want
right.
everybody to know we're not trying to hide and have a secret Discord, because if we want to do that, we just go in mine, because I don't have nobody in my Discord. I got like 2 people. Rude.
There you are. You're back.
Rude.
Baby, I'm back. You can blame it on QB. What, baby? Yeah, you got pretty shoes.
They're connecting. Hi.
Mm.
I like your shoes. I can't see them.
She's pointing her foot to the computer.
I love your shoes.
She did it again.
I love her
Cracks
so
me
much.
up.
Can I have her? I want her.
Oh, she's such a
Oh,
good girl.
she's so cute.
Um,
Wayne, baby, no, you cannot be the storm. That's gross.
Ooh, the storm. No, the storm.
I can't. No, and when you do it like that, it's worse. Don't do that.
The storm.
Yeah, Jennifer. So they're
I'm Chad
suggesting
Daybell.
for Jennifer and James Crumley, they are saying 10 years.
Tries to dodge jail time by asking to live in her lawyer's guest house under house arrest instead of behind bars. What?
Whatever. She can sit down.
Are you being for real, Margaret?
Yeah.
Or is she kidding?
No, she's being for real. They're trying all sorts of, because their sentencing is like May 9th, isn't it? I think. Crumbly. Let me look it up. Crumbly. April 9th. Ooh. It's in a minute.
Lord have mercy.
That's why they coming unglued. But they're talking about they want 10 years. I can't wait for that. Can we stop and watch that?
Mm-hmm. When is it? You'll have to
April
remind
9th.
me.
I got it on my thing.
Hold on a second.
Let's see. I'm looking for let's see. They do have ramen. They call them bricks. Call them
I love
bricks.
ramen.
Have you had, okay, so you got the ramen that are the bricks, right? And then you've got the bougie ramen that have like the freeze dried stuff in them.
Mm-hmm. Like
Um,
the peas and the corn and the
yeah. So I found one at the $1.25 tree that is Korean barbecue. Y'all. It is. It's got like freeze dried meat in it. Uh-oh. She's not listening. Y'all, go to the $1.25 tree. It's in a white package. It's Yokisama or something like that. And it's Korean barbecue. It's so good.
I can't imagine barbecue. Like
It's not
chicken.
Korean barbecue, but Korean barbecue isn't barbecue. Korean barbecue is like a soy sauce based thing. And so it's beef. And then it's freeze dried beef and the sauce, the soy sauce and the vegetables. And they're all freeze dried. When you add water, they all go whoop. And I just think that's the coolest thing anyways. But
Plump right up.
Oh yeah, well because of the noodles. Oh, Yokosobo, yeah. See, Spins knows. Spins knows.
Yeah, I've seen that at the Dollar Tree before too. I think
Yokosobo.
what we have, like our main normal brand, like at Walmart, is like Marichan or something like that.
Yeah. Yeah, Morgana, you're not allowed to have the ramens.
And
No.
I much prefer the chicken over the beef. I do not like the beef ramen,
I
but
like.
Dale got some of the like cheddar cheese ramen. That stuff was actually really good.
Yeah, it's like macaroni and cheese with noodles.
Mm-hmm. It was pretty cool.
The creamy chicken is very good.
And I like the ones in the cups too.
No,
I'm gonna
ma'am.
this child. Hold
Oh
on.
Lord. Okay, y'all. They're changing it now, but the ones in the cup, you're not supposed to cook them in the cup. Don't cook them in the cup. Not the old ones. The new ones are changing to a paper cup. The old ones are in a styrofoam cup. And you eat too many of them and you get a wad of styrofoam in your belly. Just telling you, don't do it. Don't do it. I love ramen. Now I want some ramen. I think I got some Korean barbecue ones in there. They good, y'all. Go to the $1.25 tree. Tell them QB sent you. Yeah, ramen. I love ramen. And then Manchild be dressing the ramen up. He puts eggs on it and all the things, and he does fancy stuff with the ramen. I just make the ramen. That's why I like the Yokosoba, because they're like bougie. They got the freeze dried. I feel fancy when I eat them. Fancy ramen. That's like an oxymoron, ain't it? Anyways, Steph, that would be prison to have to share a bedroom with Shannon.
I'm back. She got up early today. She got up super early today. So she is being super extra today. She got up at 5:30 with me.
No, ma'am.
Yes. She never gets up that early. But she got up that early and has been up. And so she's just kind of like hitting her like slap happy.
Right. There it
And like
is, right there.
trying to get her
Wait a minute.
second wind.
Okay. The docket
What?
says Jennifer Crumley states in her PSI that in hindsight she never would have said I wouldn't have done anything different, and is asking to be released to her attorney.
God.
And y'all hold on, I gotta yell at Manchild. Stand by.
She said PSI. Doesn't that mean pressure? Like something under
Well, it does for
pressure?
tires. Hold on, I'll be right back.
Under pressure. Yeah, she's under pressure. I would be too if I were her. Under pressure. Poppy, you're not coming in that door, Poppy. Go lay down with your tiny human and scoot your boot. E.
Ben Rizzo. She gave him the hugs.
These kids are being so super extra today. Golly.
Margaret, I'm going to say no. I'm debating on whether I can get away with driving over to my best friend's house in my PJs.
Yeah, I agree. No.
No.
Yes, Steph
You're
is right. No,
Cation.
Margaret, you're on vacation.
I'm
Stop it.
in mine. I literally, y'all don't get it twisted. I have had this conversation with, can I drive to the BFF's house after Miss Clara leaves in my PJs?
Polls closed. That was quick.
What?
Margaret already said polls closed.
Yeah, she got 3 good answers. Don't do it. I mean, it's already 3:00. I mean, what's the point?
She had a poll yesterday or the day before wanting to know if she should get out of the bed or no. Should she take a nap?
That's
And
always a yes.
somebody said yes. And then she said, polls closed. Like she just got one single solitary answer. And she's like, polls closed.
Yep. See, that's the thing, Morgana. That's where I am. What if I get in a wreck? So, but here's the thing. I'm going to drive over there and I'm going to put my PJs back on. So what's the point? I just bring clothes with me to get dressed tomorrow. Like, why do I have to put on clothes
who cares
now?
if you're in pajamas? Even if I was to be in a car accident, I wouldn't care to be in my pajamas just as long
And
as I
y'all,
had a
my
bra,
pajamas are
a
like
bra
clothes.
and underwear.
My pajamas are like clothes. Like, I recycle stuff. So right now, not that y'all need to know, but I'm wearing like a sundress. That used to be a sundress I wore out, but then it started wearing out. So I'm like, I changed it over to a sleep dress.
Yeah.
So technically, I don't know.
Steph, so do I. I mostly sleep in
Yeah.
leg t-shirts. I mean, I do have like pajama bottoms, like fuzzy pajama pants. that I'll wear, but I still wear t-shirts. I do have a couple
Morgana,
like long sleep shirts, but
Morgana. We're not
if you
talking about
wear
that.
PJs.
I'm not driving over there naked.
Lord.
I don't understand people that sleep with no PJs. What if something happens in the middle of the night and you run out
Like if you have
crazy?
to jump out the window because of a fire or something. I mean,
That's what I'm saying. Like, what do? You run
hide
out
behind a
naked?
tree. Hide behind a tree, I
Oh,
guess.
Lord. 18-wheeler accident entirely blocking off the road that runs by my house. By the
You could
school.
also keep a robe or t-shirt and leggings in your vehicle. That way you could
You think I'm going to change if I get in a wreck?
No, I'm saying if you have to jump out your bedroom window in the middle of the night because there's a fire.
Oh, no. If I'm naked and there's a fire and I got to jump, it's bad enough I got to jump out the window. Y'all about to see me in my birthday suit. But see, that's why I don't sleep naked. That's why I sleep with clothes on.
Oh,
Yay.
Margaret. She said that's all I need. Trapped in a fire in my birthday suit, and they want me to climb down a ladder from the second floor. That's an ugly no one will ever unsee.
That is what I'm saying, Margaret. That's why I sleep with clothes. At least you got to wear something. You got. No, I don't understand people that sleep naked. That's just, I feel, I don't like it.
Yeah, I can't handle that idea either. And not necessarily because I would be afraid that I'd have to like bolt in the middle of the night out the window, just in general. Ugh.
I don't like it. And I know there's big cowabunga. I'm going to say that if I have to jump out a window.
Are we bad, Spins? Spin says
She
this
loves
chat
it.
is unhinged.
She loves it. She comes for the cafe part.
Margaret says Spins, bring us back under control, please. Margaret always
No.
says that she's too young to be in this chat.
Mentally, I think. It's not dirty.
Huh?
I mean, we are talking about people sleeping naked. I just don't get, okay, here's my thing. It's a security thing. Okay, because Rizzo's probably looking at you funny, turning her head sideways like, Mom, what is wrong with you? So I don't know. I know it's a trauma response. I just don't know which one, but I cannot sleep without a blanket. So it could be 100 degrees outside and I have to have a blanket on. That's why I sleep with my house so cold. I have to be covered. I can't sleep uncovered.
So wait, why does that have to be a trauma response? Because
I just
do the
know
same thing.
it's a security thing.
Oh,
It's
okay.
considered a trauma response. That you cannot physically, like I literally cannot physically sleep without a blanket. I get very anxious. I had a lot of trauma when I was younger. Ain't gonna lie. But anyways.
Well, I just wondered if there was like some scientific thing that says if you can't ever sleep without a blanket, that's a trauma.
No, it's a security. So it's a security thing. See, even Margaret's got a weighted blanket. I have thought about the weighted blanket, but because I'm so hot all the time, the weighted blanket's supposed to be the jam, though. What weight do you have? What weight do you have, Margaret? Is it really heavy? Like, do you sock yourself in your eye when you try to pull it up?
Where did she Okay.
Oh, for the love.
I'm telling you what. Where is your laptop? Where is your computer?
It's in the car. I packed it already.
Go get it.
No.
Go get it.
That's all the way out there. No,
Yeah.
I'm not going all the way out there.
All the way out there. It is 2:54. We have 35 minutes left. Go get that laptop.
Nope. Look, Margaret said she sprains herself turning over.
She socked herself right out of
Right
here,
out of
said
here.
Morgana. Right? Poof! Pow! Right in the kisser.
Anyways, I don't know. I'll find the scientific evidence. It's a security blanket. It's a security thing.
20 pounds, said Margaret.
Oh, that's nice. That's nice. And if you fold it in half, it's actually 40. Anyways, yeah, I'd probably sock myself at the eye. I'd be I do that now, because I got the dog and he wants to lay on everything, and I try to pull the blanket up, and then anyways, I sock myself in the eye. He's
Eli's
my
got
weighted
one.
blanket.
Eli's got one. He never really sleeps with it. And he's kind of just like, meh, whatever. But it makes me very claustrophobic, yeah.
See, that's what I worry about, because so I am claustrophobic in spaces that I can't move.
Yeah.
So you could put me in a small room, not a closet. The closet is look, I'm like hyperventilating just thinking about it. The closet is my cutoff. But you put me somewhere where I cannot move, like MRI, no, you got to drug me for that. I can't. So that's what I worry about, like that I would be claustrophobic.
Well, I got to be able to like have my feet hanging out of it partially, or
yeah. So
sometimes
I
I want
used to
my
do
feet
that.
curled up in it. I'm just a very wishy-washy sleeper.
Yeah, I used to not be able to sleep if my feet were under the blanket. But now that I control the air because I pay the bill, it's frigid in here. So I like to be all up under the blanket. And so that weighted blanket, I don't know how I feel about it. My problem is they're expensive, and I don't want to buy one and then not like it. And then, I need to try somebody's out. Ew.
I'm just saying, you can from like Amazon. I'm sure they have a return policy.
That's how you get them. We have a place here called Bougie Bins. That's where all the Amazon returns go. So then you go to the bin store, and there's like different days or different dollar amounts.
Oh, yeah. I've heard of those.
Yeah. Ours is called Bougie Bins.
Ours is called Goodwill.
Yeah.
But honestly, though, I mean, it'd be worth trying it and seeing. And if you don't like it, you could always either return it or give it as a gift to somebody,
less weird than me.
Yeah.
I don't know those people. Everybody's less weird than me.
That's weird.
Everybody's less weird to me. I'm an odd duck.
Oh, I think we're all odd ducks.
Are you Diamond Peyton?
No. Yes. No.
Yeah. I feel like I hear some snap dots. Oh, snap. Snap. Y'all didn't know. Oh, I'm not supposed to do that anymore. Never mind. I forgot. Shut up, QB. Shut up.
Ah, la 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 la.
Blah 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 blah.
La 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 la.
I forgot. I told y'all my mouth runs before my brain does sometimes. Like, oh
Every time
crap.
I think of that, I think of Mrs. Coffee. La la la
La la la
la.
la. You ever seen her? Okay, have you ever seen her play Among Us? Okay, do you know what Among Us is?
I've never watched her play it. No.
Okay, do you know what Among Us is?
It's the sussy character
Yes.
little people, yeah.
Yes. So you have all the people, and one of them is an imposter, and the imposter runs around and kills people. It's not violent or anything. Well, it's a little violent because you see bone, but it's not real bone. It's cartoon bone. But anyways,
Cartoon
every
bone, okay.
every single time that Kath is the imposter, she runs around singing, "Making my way downtown, walking fast, down, down, I'm homebound, dun, 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 dun." And you know she's the imposter. Like, you know, she starts singing it every time. It's like she can't help herself, and it cracks me up.
Mhm.
'Cause it's like, okay, well, we know who the imposter is. So I'm at PT the other day, and that song comes on, and I'm looking around for Among Us. What is wrong with me?
Or
What
looking around for Miss Coffee to pop
I
her
know.
or
I'm
get her
like,
in the
where's
corner.
the little sussy characters with the bones? And the people at PT are like, what? And I'm like, never mind. Just wrench my arm. It's fine. I'm fine. Everything's fine.
Wrench my arm.
Just pull it out of the socket. It's fine. Everything's fine. I'm in a gray area.
Quit. I couldn't.
I love you, Jenny. I'm sorry. Oh,
I
Lord.
can't help it. That was so funny when you wrench my
You know that's what they do. That's why I tell Tyler, I'm like, I'm telling my
wrench
friends you
my
hurt
arm.
me. I walk in there and I'm like, I told my internet friends you hurt me.
Oh, I can't breathe.
I'm gonna take y'all with me to PT one day. Look, we're gonna do a watch party. I'll host QB's PT.
Oh my God, my back. I'm getting cramps in my front and my back.
Are you breathing? Breathe, man, breathe.
Oh my God, that killed me. You don't know how many times I've heard people say, "Oh God, I wrenched my arm."
You had a visual, didn't you? Of
Wrench my
Tyler
thumb or
wrenching
my ankle.
yeah. They wrench it. They do, man. They mean.
I didn't know anybody else ever said that. When you said it, it just like just got me. It got me. Oh man, that hit me a little different.
That's funny.
That was so
I
funny.
love you laugh. I love your laugh. I love you
Oh
laughing.
my God.
I didn't mean to get you tickled like that, but
Oh, that was a big tickle.
that was funny.
Oh.
Y'all, I thought I was gonna have to take this cat back to the vet. She come up with me one-eyed today, with one eye closed. And I'm like, ma'am, open your other eye. What happened? And she's like, I can't. And she's one-eyeing me. She's fine now. I don't know what. She had a piece of something in her eyeball or something. Hi, Aiden.
Oh my God, I got mascara all the way down to my knees.
No.
Oh.
Why are you wearing mascara?
I don't know. I usually put a little bit on the days that I get up early just because.
Well, look at you, fancy pants.
I put like a little bit of like something on. Not always, but every once in a
I'm not
while.
gonna lie
Hey,
to you.
why even bother? Come along, come QB, 4 p.m. Eastern Daylight Time, and make it run right off my face.
Look, I've gotten so bad. I'm actually ashamed and disappointed in myself because I've gotten so bad. Like, I'm like, I'm not putting makeup on. This is me. This just me.
Yeah.
And I used to never. I wouldn't be caught dead leaving the house without makeup on. Now I'm like, I mean, do I
I
really
don't
need to
wear
put
it.
makeup on? I don't wear
Most
like
of
a
the
lot of
time,
makeup when I do, but
I won't wear none, not a stitch of makeup. But every once in a while, I'll get in a groove, especially on the days, like I said, that I get up early,
I don't
and
have those days.
I'll throw some on. And
I don't get up early.
yeah,
Early for me, I mean, and when I say early, I mean early for me is like 7:30, 8:30, that area. I didn't even know. The only reason why I knew there was a 5:30 a.m. is because I was coming home. Like, I don't. Mm-mm. That's why I work
well,
overnight.
how do you put the live chat on the TV? Aiden thought that she had done lost her mind.
Hi, Aiden.
Oh, Lord have mercy. That was a
Hi
good laugh.
now. They can't hear
Phew.
you, ma'am.
Who?
Squeaker says hi.
Oh, I thought you was talking about me.
No, they can't hear you, ma'am. What is wrong with your eyeball? Why are you winking at me? What happened?
She probably got the pink fungalitis.
No, there ain't no. Don't be telling me that because I've had my fingers all over her eyeball today, and you know how I feel about that. I feel like I
Well,
keep rubbing
I
it. I feel like she's got something in it. Dang cat fungalitis on my fingers.
You
Great.
probably ought to go wash your hands.
I have, but ew. Y'all know how I feel about eyeballs.
Lord, Lord, Lord.
Wait a minute. Wait a minute. Wait that daggone minute. What are you telling me?
Who?
What Steph. 1, 2.
Yeah, you showed
Oh,
me.
there it is. You right. But wait, it ain't showing. Why ain't it showing on my TV? That don't come on my TV. Y'all want to hear a funny story? Y'all want to hear a funny story?
Yes, always. But
Okay,
wait,
Miss
maybe you
Clara.
ought to give me a few minutes because
No, this is funny. Oh, I see
I mean,
fins. Oh, I see it on my TV. She put eyeballs, ma'am.
mm-hmm.
I see it. I see it. I see it. Shut up. What? I could see it on my TV. I did not even know that was a thing. Here's a funny story. You ready? It's Miss Clara, the 91-year-old that I'm
Mm,
not watching.
mm.
Old biddies. Aiden did teach us magic. Oh my God. That Aiden.
Did you just call her an old biddy?
She did. No, she called me one. It says old biddies acting like Aiden taught us magic. I can see it
Oh,
on
I
the
thought you were
TV. I
saying
don't even
little
have to
Miss
look at my
Clara
phone.
was an
No.
old biddy.
Look, I could say that. Um,
Hmm.
not in a way, not in a real shut up way, like in a playing shut up way, Spins. I can see it on the TV. I ain't even gotta look at my phone, y'all. Okay.
You
Anyways,
have to wear
Clara.
your glasses on top of your glasses to see the TV, see it.
No, the glasses on top of my glasses is for close up. That's across the room. I see
Mm-hmm.
just fine across the room. Listen, listen, listen. So, Miss Clara, um, so she has a TV, right, in her room. Okay, and then there's a TV in the living room. Now they all on the same TV, right? They on Spectrum. They got the cable. I don't have cable, but they got the cable. Okay, so Gina will be watching something on. I shouldn't say her real name. It don't matter. Anyways, my BFF. Um, she will be watching something and Claire will be like, "What are you watching?" And she'll be like, uh, what's it called? Law and Order.
And she gone. She gone. She back.
Oh, crap. I was right in the middle of the funny story. That's rude.
Mm-hmm.
Anyways, my BFF will be watching something and Claire will be like, "What are you watching?" And she'll be like, "Oh, I don't know, Law and Order SVU." And Claire will go, "That don't come on my TV." Ma'am, it's the same TV. I mean, it's a different TV, but it's all the same. Yes, it does come on your TV. She says it all the time. She's like, "That don't come
Does
on
she
my
say
TV."
it because she can't find it, or does she
Yeah,
say it
because she don't know how to
because?
work the TV. We had to set it up so she could go straight to her stories and straight to the news because otherwise it don't come on her TV.
Oh.
But so now we say that, like when you see something, why Nightbot? I can see you on my TV. That comes on my TV. Look at that. So when I
Trigger
said,
warning, trigger
yep.
warning.
So when I said, but it's really tiny. Like I need it to be bigger. But that's why I said when Steph was talking about the live chat being on the TV, I said that don't come on my TV
Hmm.
because we say that like something will happen and we'll go that don't come on my TV.
That's funny.
Gina was laughing because I told her that I said I'm heading over to your house in a little bit, but I'm waiting for your mama to leave because she was giving me the side eye about me babysitting her.
Oh, what'd she say?
I can't. Well, it came in and she was there, and I wasn't expecting her to be there, and I was like, "Oh, I didn't. You're here," and she goes, "Yeah, I live here." I'm like, "Fair." She goes, "I know she sent you to watch me, ma'am. I'm here for the dogs." So then later on, she was like, "I know she wants you to watch me." I'm like, "Again, ma'am, I'm here for the dogs." So then when I left Tuesday and I came back, when I left, when she got home, she's like, "Okay, I'm here. You can go." Oh, okay, bye. Now, don't get me wrong. Miss Clara loves me. Okay. I think she was just trying to say, hey, I can handle it from here or whatever. And so we call her, she's the queen of backhanded compliments.
Yeah.
Okay. She'll be like,
Mhm.
well, that outfit don't make you look fat. Oh, what? Ma'am.
Right. I know. Yeah.
And she don't mean nothing by it. It's just who she is. It's just who she is as a person. But anyways, so she's like, I'm here now. You can go. Oh, so I told Gina, I said, your mama dismissed me. I'm going to my house. So I'm heading back over there in a little bit, but I'm gonna wait long enough for her to go over to Brooks because I don't want her saying I'm there to watch her. I know you're here to
So,
watch me. No, I'm not.
well, why in the world wouldn't she leave her to watch the dogs if she can be trusted to watch a 1-year-old?
So okay, so here's the thing. Well, one, my BFF is not a fan of her watching the 1-year-old, but she don't have no say in that. But two, so we all do medical stuff, and most of us work overnights. So Brooke is an ER nurse, and she works overnight. So Clara goes over and stays the night, and then she keeps the baby, and then she keeps the baby until Brooke wakes up. Okay. Well, the dogs got to be fed at a certain time because they're bougie like that. And so she's over with the baby, so she can't be in two places at once. That's where I come in.
Uh-huh.
But like when I went the other day, they eat between like 5:30 and 6:30. Okay. Now they'll come at you at like 4:30. They're like, you got food? How about now? What about now? You got food? So I got over there at like 5 o'clock the other day thinking I would feed them, and they would be good. And that's when Clara was there. And I was like, oh, I didn't expect you to be here. And she's like, I live here. And I'm like, it's fair. You do. But I thought you'd be at Brooks. And she's like, well, I don't go over there till 7. She goes, I could have fed the dogs, but I know she wanted you to come over here and watch me. And I was like, oh.
Yeah.
So tonight I'm letting her feed the dogs. I'll go over there. I'll stay the night. I'll feed the dogs in the morning. And then normally Claire ain't even here. Normally she goes with them. But Gina needed a vacation.
Margaret, what in the world are you putting on clothes? She's one of those that goes on vacation to be on vacation, but then does nothing but work while she's on her vacation. You need
and
to go
take a
sit your
poll
tail down, Margaret.
and then take a poll and then totally ignore the poll. The poll rules. The poll is the poll. You closed it.
True.
Anyways, yeah, normally I go over there and I stay there for the week because there's nobody in town and I take care of everybody. This is different this time and it's freaking me out. I don't like it. Especially because I packed.
I wonder what number we're at now on the jury.
I thought I saw something that said 40, but then after that, I think there was maybe 2 more that went through. We got to be getting close. Margaret can't help it. I'm not getting dressed.
Let me check.
Oh, you got live tonight.
Yeah.
I hate that I never get to make your lives. That's going to change soon, but for now, it's what it is. I just leave it that. Goes my mouth again.
Stop talking.
I'm just going to mute myself.
Oh, Lord.
No, Margaret, we're not playing in your poll anymore. We took a poll. Sweatpants and hoodie are fine.
Wait, what?
What? What?
Oh, this is weird. Nate Eaton posted 2 hours ago.
Are they on lunch and they left?
No. But Nate Eaton posted and it says emotion.
Yeah, that was filed before. The motion to delay the trial.
Yeah.
Yeah, that was filed like last Friday and it was done like undercover. But it was denied,
They're
I
not
think.
saying why.
Yeah, they're not saying, yeah, it was denied, I think, though.
Can we have a poll about polls?
Jenny, can you share stuff from the Discord? No, you can't, but you could save it to your computer. I gotta send you this. This is some funny crap. Oh my gosh. You gonna laugh. You gonna laugh hard. You ready?
Oh God, I don't know.
Y'all. If you know, you know.
Oh my God.
Do you see it?
Yes. Oh my God. Hold on.
You gotta share it. You gotta share with the class.
Hold on. This is funny.
He's thought old news got jokes.
Check this out, Steph. Check this out, Steph.
What's Steph checking out? It's in the thing. Put it on the thing. Share with the class. There it is. The storm is in the Boise.
East Idaho News out here posting jokes. If you know, you know. The storm.
Stop
Moves
saying
into
it like that.
Boise as day 4 of jury selection and Chad Daybell's trial gets underway. The storm.
Stop saying. I was looking.
Oh Lord.
Oh my gosh. Oh my gosh. Elizabeth. She's been freaking out about one item in the mystery box that was left over. She's been worrying about it. Guess what it is?
What?
Those things I'm not supposed to mention on this channel?
Yeah.
Well, she already brought me my box when I met
and
with
you
her.
didn't get those.
And I didn't get them. And she's been staring. She's like, can I quit now? Can I quit? I just quit.
Spence says, I've never heard QB laugh like this. I'm dying.
That was funny.
Lauren called it the little shrimp.
I just can't take it when Jenny goes, the storm. That's skeevy. Like, that's gross. But that caught me like I caught you. That thing when I was going through the Twitter trying to find, and it says East Idaho News out here posting jokes. If you know, you know. And I'm like, what are they talking about? And I saw a storm and I was like, shut up. The storms are brewing. That's so gross.
I'm glad you reminded me too, Steph, because I did completely forget about it. Completely.
What? Forget about what?
The storm.
Oh, ugh. No, when you say it like that, it's gross. It's so gross.
The storm. The storm.
Stop it.
Stop it. All right, where did the thing go? I need to reshare the stream.
The storm. Gross. That was funny as crap. I'm just saying.
Ugh. Oh, we're back. No, I mean, we're not back. The court's not back in session.
Morgana.
And the thing is back. The storm.
You're not gonna want to go into the Discord.
Oh, Morgana, that's nasty. Morgana's being a dirty bird.
Exactly, Lauren. Now when somebody says a storm is brewing, I hear Jenny go, the storm. And I go, ew. Did my child get up? Stand by. I gotta turn. Wait a minute. Let me mute myself. Hold on. I gotta holler. You don't want to hear crazy hollering.
Oh, Lord. The storm.
Okay. You know how you go like, you say, hey, could you take out the trash? Hey, could you take out the trash? Hey, could you take out the trash? And then you lose your ever-loving mind and they're like, why is mom crazy?
Right. Yeah, I know exactly that.
Yeah. Morgana, no ma'am. And second of all, number C, you're going to need to get a working grocery list, a rotating grocery list.
Letter 2.
Letter 2. He was doing that yesterday, and I was like, sir, that is not, no. Oh my gosh. Steph said, I wonder if they know Jenny and Morgana got hit by the storm on day 1.
Oh my God.
Yeah, he's been doing that. It makes me crazy. He's like, so letter 2. No. But Morgana, let's talk. Can you make we need to make a rotating menu and a rotating list. And then you put a list on the refrigerator, and I don't know if the people in your house will do it or not. But as you use stuff, you just add it to the list.
Then that way you don't have to sit and make a whole new list
List
every single
every week. Every week she's got it hurts my heart.
Well, but she might actually enjoy doing it.
Um,
That might be like one of her things that she enjoys sitting down to do.
Morgana, share with the class. Do you enjoy doing the grocery list? Because I don't feel like yeah, see, I'm living in a nightmare. You don't understand. It's because she has people in her house that she can't control.
Well, then do like you said. Okay, here's what you do. You make a list of what, say 15.
She's got people that I know what she's saying. It gives her an excuse to be here. So yeah, no, okay.
What, Jenny? Have you lost your mind? Well, okay. I didn't know. I mean, you do it every week. I figure you really maybe kind of secretly enjoy it, and that's why you do it every week. I don't know.
Thursday's grocery list day, Friday's grocery shopping day. I'll be having that stuff delivered. Oh, what'd they say?
$1 grocery store and grocery list day. I ain't in here.
Ain't here. Ain't here. I like how you save that sound bite, and I send y'all all kinds of sounds, and y'all don't save those.
What?
You just stole my I hate it here and made it a thing.
Yeah, because it's funny.
It's only to you and everybody else but me. She do complain about it every week, right, Steph? Like, I don't think she secretly likes it. I think she secretly hates it.
So then why don't you do the thing? You can actually find them on all over like Pinterest and like rotating.
Do you have an Alexa? You can tell the Alexa, add it to my grocery list. You ain't even got to write it. Be like, oh, I don't want to set off anybody's things. Hey, name that I'm not supposed to say because it sets everybody's off. Add broccoli. I don't know. I understand. She got people in her house she can't.
I don't understand what you're saying. Are you trying to say that certain people in the house want like different things, and so she's got to like check with this person? Hey, do you need this week? Do you need this?
Yeah. They continually change their minds. And she can't make a set list because no, I get it.
I would make a set list, and I would say y'all are going to eat it, and you're going to like it.
Because I'm cooking it. Well, see, that's how it is in my house. Like like people be talking about how they made their kids like separate dinner. No, we don't get separate dinner. I don't. See, nobody agrees on anything, and they're all adults. So it's not like it's not like she got kids that she can be like, look, listen, I am in charge here. Now, where you can do that is because you the cook. So you eat what I eat.
Yeah,
You
but
get
the
what you
thing
get,
is,
and you
though,
don't
is
pitch
by
a fit.
now, at this point, right? Everybody, yeah, and they have their own tastes and dietary needs. I get that. But at this point, she knows she
That's
knows
my
at this
thing. I
point
would
what
make a
everybody
set
likes.
in
She
my
makes the same things all the time. Yeah, just
yeah.
make.
I would make a menu. Okay, and I'm not telling you, Morgana, because I know you got your hands full. We talked to your mama the other day. We know. But she cute and I love her, but so is Miss Clara. And anyways, I'm not comparing your mama to Miss Clara. I'm just saying I understand. Anyways, I always made a rotating menu. I had like 4 weeks of menus, and we would roll them. And then we had free night. We always had free night. You could have whatever you wanted, but you had to get it yourself.
Right.
You know, you have leftovers, or you could have cereal, or you could have sandwich or whatever, but you're on your own because that's Mama's day off. But I always had leftovers and stuff in there, and I always had stuff in there that they would like to have.
Right.
And I taught my children to cook at a very young age because I needed free night.
I don't know. We have a lot of the same things. And so, I mean, we kind of already have like sort of a rotating,
Right.
it automatically happens that way. But we'll have, like spaghetti or fettuccine or Alfredo.
I love y'all. Love you, Mama. I love you, John.
We're all sitting here
And
listening in and popping. Oh, no.
we're in trouble.
Uh-oh. We in trouble.
Look, there goes Nightbot. Nightbot said trigger warning. Margaret said, okay, sweatshirt, sweatpants, bedroom slippers, brushed my teeth, but not my hair. Is that okay?
Ma'am, you were okay an hour ago when you were in your pajamas.
Yeah. We love you, Morgana's family. We're just trying to help Morgana. Y'all get your life together. Tell Alexa. Echo. Wait a minute. Look, Steph just went for it. Excuse me, I gotta yell again.
Morgana is one person. You run her haggard. Is she gonna be laid up with y'all? There you go.
Right. Then y'all be cooking. Y'all be making the list. That's not how it works, though. Mama gets sick, she still cooks. And the other mama in the house ain't allowed to cook because she passes out.
We won't see her here from Morgana for a week. They're gonna
I know. They're gonna cut her off. They'll cut her Netflix off.
Mm-hmm. Cut her YouTube off.
She gonna go live in the woods.
Mm-hmm.
Well, the porch is mine. Unless there's a tornado. That's a whole
Then you're under the porch.
Well, that's where Steph lives.
Oh, I forgot. Yeah.
So
you can go jump in the bathtub as long as it's on an interior wall and not an exterior wall.
I know you about to have never mind. I ain't going there. We'll talk.
What?
When that is April. I know it's June. I'm having a whole conversation by myself. Steph talking about her spare bedroom.
Oh no, yeah. Margaret. Okay, this is not funny. There was a pop-up on my phone saying late spring, the storm to hit area tonight.
That skeeves me out. I don't like it. I don't like it one bit.
Morgana's going to go to the caves.
Can we sit on the front porch of the cave? I mean, I'm good then. I just want a porch.
I don't know. What's Steph say here? I don't know. Between finding a place he can afford and my health stuff, I ain't pushing.
I'm gonna keep my mouth shut. For once, let me just mute myself. Let me cancel myself. I'm canceling myself. QB got canceled. Bye.
You're funny. You funny. Oh my God, she really left. QB, ma'am. There she is. She's back.
That time I did do it.
You little meanie.
Look, you left me by myself the other day. What's that?
Hey, I couldn't help it.
You could help it. You can't leave because if you leave, the whole thing will shut down. And I was like, now what do I do? Oh, where they at? It's 3:30. This judge, I'm done. Let me tell you what. Wait till you watch that apple dumpling river thing. You wait. That judge is not. I mean, he is tapping his wrist. He like Judge Judy.
Oof.
Yeah, he's like, no. They started to fight yesterday afternoon. He goes, look, I know we're all tired. Wrap it up. Y'all can keep your side talking to yourselves. Seriously, did they go to lunch and oh, wait a minute. What did Steph say? He's my dish boy. He fills and empties the dishwasher and hand washes dishes and brings me meds when I need them, but don't want to get up. You know how you could solve that? Use paper plates and put your meds by your bedside. They did that to us the other day, Spins, but you knew. You just didn't tell us. You heard them say they were leaving. We all heard 3:30 or 2:30 or whatever.
Oh, listen to this. 5 minutes ago, Nate Eaton says, back in the courtroom, defense and prosecutors are here waiting on on Judge Boyce and the jurors.
Yeah, exactly. It's the judge. I'm tapping my wrist like Judge Judy. Margaret, ma'am. Mascara. Y'all. Ew.
What?
Ugh. I can't even hear the word storm anymore. All I hear is Jenny go, the storm.
The storm.
Steph said that storm must have been really bad. It was raining there. I was wondering if they would deduce that it had rained when they went out, or if they would wonder, you know.
You deduced it?
I did. I deduced it.
Margaret said they're on perma lunch.
Yeah, Spence, next time speak up. Even if you're wrong, we'll be like, oh, well, Spence said, but here they come. But if you're right, we won't sit here for 2 hours. It was raining lemonade. Oh, that judge, he's not. You gotta watch that guy in the Apple Dumpling Gang. He's funny. He's like he ain't having none of it, and he do look like Harry from Night Court. Yeah, I hate that I missed the lives at night. I'm gonna be there soon. I was. You were on pain meds. That's fair.
I think I gotta go wee.
Well, thank you.
You're
for that.
welcome.
I'm hungry.
I said I have to go pee, and you say you're hungry.
Well, it made me think of getting up and walking somewhere other than right here, and then I could go to the kitchen.
Yeah, and Steph says, can I have a snack in the corner?
Yeah, and then I read that and
Snack sounds good.
Mm.
Hmm.
My snacks are in the car. Dang it.
I have snacks in here.
I have snacks in here too, but the ones I like, the really good snacky snacks, are in the car. Go pee before the people come back.
I think I can wait and go pee when the people come in.
Okay, so then, yeah.
Yeah,
If you
so
don't
that
leave
way,
me by
because the
myself.
first several minutes are all like, let me tell you about a story about a man named Dred who likes to have cheesy eggs on the airplane
Oh, Chegs.
in the
Go make some
rain
Chegs. Go make some Chegs.
in the middle of the storm.
Ew. Ma'am.
Let me tell you about a man named Jed.
Old Mountaineer Barry came and said, how do I know that song? You ever wonder, like, you hear a song and you know every lyric and you're like,
Did you not ever watch the TV show?
I did, but it's just like Fresh Prince. I know all that.
Yeah.
I feel bad. Will Smith went sideways. What happened?
He did a little bit sideways, but so did Jada. Ooh.
Ew.
I'm not
He
a
drove
fan.
she drove him crazy. That's what happened to him.
I think he's just madly in love with her.
Yeah, and she
he
wrecked
wasn't feeling
him.
it no more.
She wrecked him.
She did. And I
She
tell you,
wrecked
I
him.
love me some Will Smith,
Me
okay?
too. But,
And I tell you, somebody else that wrecked somebody else was oh, hold on, let me get my
you were on
celebrity
a
straight.
roll. What happened?
Somebody did was it Jennifer Lopez that left Ben Affleck? Or am I thinking of somebody completely different?
No, you might be right.
Who was it that dumped Ben Affleck?
J-Lo.
Was it her?
Wasn't it J-Lo?
Let me go look.
I think it was J-Lo. Yeah, she destroyed him. She broke him. She broke him and gaslighted him. Gaslighted the snot out of him. She's like, "No,
Yeah.
Will, I'm not with Tupac."
She left him and then they got back together after Jennifer Garner. Okay, so it was Jennifer Garner. But see, whenever J-Lo left Ben Affleck, I was like, I'm done with you. Like, I don't ever want to see your
I
beautiful
know
face again.
I know there are a lot of people who are thinking she's gonna go down with Diddy.
Who, J-Lo?
Yeah, and they ain't mad about it.
Mm.
Look, I think anybody connected to Diddy, if Diddy did it, then if Diddy did it and you connected, y'all all can go down. That's what I'm saying, Margaret, right? They're saying she connected. She connected. J-Lo, you going down, girl, you going down. Take Jada with you. Jada wasn't involved. Jada was involved though. She's 7 degrees of separation from Kevin Bacon because Jada was with Tupac. And did he do it? I don't know.
I don't know if Diddy did it, but I think Diddy knew about it if he didn't do it.
Yep. Oh yeah, Jada in love with Pac. Big time. Big time. I think if he wouldn't have died, that would have been a whole different situation. But all I know is that
Tupac was beautiful.
I love Tupac.
Look, beautiful.
All I'm gonna say is QB. This is QB. This is not the Crime Cafe. Disclaimer. All the things. She, in my personal opinion, Will Smith is madly in love with Jada. Okay, she knows that, and she does what she wants, and she uses that against him. She has gaslighted him. She has abused him. She has messed him up because Will Smith is not the person he used to be. And it's sad to me. It's sad to me. I
It's
didn't know
sad
that.
to me too. And I'm telling you what, his kids, them kids, they a little on the.
They wrecked too.
They are hardcore.
Oh yeah, absolutely. Absolutely, Steph. She was laughing and then it hit her what he said, and she looked at Will and gave him that look, and Will jumped up and slapped Chris Rock. That ain't the Will Smith I know.
Mm-mm.
That ain't the Will Smith I know.
Mm-mm.
And I don't care what people say about Chris Rock, he handled it like a gentleman.
Mm-hmm.
Even afterwards. Mm-mm. Oh yeah, no, he thought that was gonna finally show her. That was gonna finally show her, like, prove his love to her. Mm-mm. I can't. This judge. I'm gonna start being like Abadu and be like, look, where's the trial, sir?
So it looks like there's something else going on. 7 minutes ago, they were waiting on Judge Boyce and the jurors, and then it says the attorneys head back to meet with Judge Boyce in his chambers. Chad Daybell sits alone at the defense table with his hands in a praying shape in front of his face. And then he says a few minutes after that, Daybell is now thumbing through papers and reading notes. There are 6 people in the gallery this afternoon. Madison County Sheriff Chief Deputy Vince Kakamanu, I don't know how to pronounce that. 3 reporters, including me, a college student, and Tom Evans, juror in the Vallow case. Well, where's Kay and Larry?
I don't know, but Kohberger gonna be in court in a minute.
Not an hour.
Not even 45 minutes.
Well, 45 minutes, yeah. I do want to pause and watch that because I want to see what's going on.
Mm. Mm-mm-mm. Who are you? Ooh.
I don't know, Patricia. Oh,
You seated.
We're back. Let's see what's going on.
All right, good afternoon, Ward. Okay, we're back on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We're going through small group for Dyer. This afternoon, we have another group here, and we'll have the jurors brought in. We are going to speak to one juror outside of the presence of the courtroom, and then we will return back with those remaining jurors for Dyer. At this time, I'll instruct it. Marshals, to please have those jurors brought in with the exception of the one. All right, please.
Friends, I hear you, Your Honor.
Thank you. Please be seated. All right, ladies and gentlemen of the jury, we're going to get started here momentarily with the group voir dire. However, first the court's going to meet with counsel briefly to discuss one particular juror. So we'll do that, please, in the jury room. I'll just meet with the state and the defense of this.
Y'all, did the judge leave again? Where's the judge? Are they meeting to the side? I got sidetracked. This is what happens when Jenny leaves me in charge. Oh, yeah, they must have been sidebarring. Oh, Kathy Russin just said the jury has been seated. Nate Eaton said jury has been seated. There are 15 jurors, 9 men, 6 women. The judge and attorneys leave the room to meet with individual juror in private. I don't understand. Oh, yeah, they were meeting with one in private. But it says the jury's been seated. Nate Eaton says they've been seated. All right, Margaret, I'll give you your $1.09. Yeah, it says jury has been seated. 15 jurors, 9 men, and 6 women. The judge and attorneys leave the room to meet with the individual juror in private. Go figure. All right, Margaret wins.
Thank you. Please be seated. Okay, we are back on the record now on case CR 22211623, State of Idaho versus Chad Guy Daybell, doing voir dire of a small group this afternoon. Is the state ready to proceed?
Yes, Your Honor, thank you.
Is the defense ready to proceed?
Yes, Your Honor.
All right, thank you. I'll note on the record, I just met with one juror as well as counsel for both the state and the defense. In chambers, juror 1187, who upon further review of the questionnaire and motion of the state as well as the defense has been excused for bias expressed in the questionnaire in addition for a hardship as well. So we've allowed that juror to be excused, and we will next move on to the other jurors here. I will also indicate, last I heard, we had a juror scheduled for this group, empty seat on the back row, juror 1605. Apparently has failed to appear and we haven't had word from them. Is that the latest status on this juror? All right, thank you, Mr. Bailiff. So juror 1605 has not appeared. With that then, in order to make sure we're all lining up our seating charts with where you are and who's here, if you do me a favor, please, and just hold your red card up and leave it up here for a moment while we take our notes. Okay, thank you for doing that. Having confirmed where these jurors are seated and who's here, then let me first inquire from the state, is there any objection to the manner in which this jury panel has been recalled and seated?
No, Your Honor, thank you.
Any objection from the defense?
No, Your Honor.
All right, thank you, counsel. Ladies and gentlemen of the jury, thank you for returning this afternoon. You've been recalled as prospective jurors in the case now before us. I'll reintroduce my court staff again and myself. I'm Stephen W. Boyce. I'm the district judge for Fremont County, Idaho, and I'm in charge of this trial in this courtroom. Our court clerk assisting today is Shannon Holstein, who's seated to my right. She takes minutes of these proceedings and also administers oaths to you as jurors. The court I have assisting me in maintaining courtroom order and working with the jury are marshals here today, and they will help the jurors know where they're supposed to be as they move about for these proceedings. Also, our court reporter, Mary Fox, takes a stenographic record of everything said during the trial, including today, and Courtney Stallings is my staff attorney who assists me with legal and administrative issues that come out throughout the day. Each one of you is qualified to serve as a juror of this court, and each one of you filled out a questionnaire that's now been reviewed by the attorneys and the court. And the first thing we do in a trial is to select 18 jurors in this case, which would include 12 jurors for trial and 6 alternates from among you. At this time, then, I am going to have clerk please take a roll call of the jurors that are here present. So when your name's mentioned, please hold up your red card and state either present or here so we get a record of who is attending. Madam Clerk, if you please take the roll call at this time.
Juror 977, here. Juror 1185.
Here.
Juror 1219. Juror 1248. Juror 1271.
Here.
Juror 1288.
Here.
Juror 1330. Here. Juror 1353.
Here.
Juror 1366. Here. Juror 1382. Here. Juror 1436. Here. Juror 1503. Here. Juror 1537.
Here.
Juror 1557. Here. And Juror 1632. Thank you.
All right, thank you, Madam Clerk. At this time, as I mentioned, we do have one juror who failed to appear, and for that juror, the court will require they report either by 5 p.m. or provide some explanation for the failure to appear. If there is no good explanation or further appearance, they may be subject to a fine up to $500 or imprisonment up to 5 days in county jail. That's pursuant to Idaho Code 7610 and Idaho Code 2208. Next, I am going to introduce you and to assist in participating in the jury selection process to the parties and their lawyers, and I'll briefly summarize what this case is about. When I introduce an individual, please stand and briefly face the jury panel, then retake your seat. This case has been brought by the state of Idaho. I will sometimes refer to the state as the prosecution. State's represented in this trial by Lindsay Blake, Fremont County prosecutor, Rob Wood, Madison County Prosecutor Ingrid Beatty is a specially appointed prosecutor in the case, and Rocky Wixom, a deputy Fremont County Prosecutor. The defendant in this case, Chad Guy Daybell, is represented by his lawyer, John Pryor.
Good afternoon.
This case is a criminal matter, meaning the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the amended indictment when you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho alleges that Chad Guy Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember that is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instruction as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including this jury selection process, you are instructed that you are not to discuss the case among yourselves or with anyone else, including any use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, I'm going to request that the clerk administer an oath to the entire jury panel for voir dire examination. If each of you would please stand and raise your right hand, I'll have that oath administered now.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God.
I do.
All right, thank you. Please be seated. Clerk has now impaneled this group of prospective jurors for questioning. Will the attorney stipulate that the jurors have been properly called and impaneled, beginning with the state?
Yes, Your Honor, thank you.
Yes, Your Honor.
All right, thank you. The attorney's been so stipulated. In this part of the jury selection, you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law, and in Old French it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not for the purpose of prying into your personal affairs. It's only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand or your red card. And when called upon to speak, please identify yourself by your card number. And also, these proceedings are being stenographically recorded. So give a verbal response such as yes or no. Shaking your head or nodding doesn't pick up and make a record. And also on that point, please try to avoid speaking at the same time as anyone questioning you. When only one person's talking at a time, our court reporter is able to make a clear record. I'll also note that the proceedings here are not only open to the public, but being broadcast on a court's channel on YouTube for public access. You are not being videoed or filmed. However, your audible responses are being broadcast. Keep that in mind when answering these questions. And if any question you believe would be embarrassing or something uncomfortable for you to talk about publicly, we will arrange to let you discuss that in a more private setting. Also, if you have an answer to some question that you think may prejudice the other jurors or some information they may not know about the case, for example, please don't discuss that in front of the other jurors, and we'll talk to you individually about that. This case has had a lot of pretrial media coverage, and so any facts you may know, we'll talk to you one by one, and please don't discuss those in front of the rest of the jury panel. At this time, I am going to read you a special instruction being provided in this case, and this is as follows. The defendant, JJ Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the special instruction. At this time, I would also instruct attorneys for both parties to avoid repeating questions the court's already asked. You do have the right, however, to direct follow-up questions to a juror regarding that juror's response to a previous question. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges called for cause, which means that they can ask a juror to be excused for a specific reason. In addition, each side has a certain number of peremptory challenges, which means each side can ask that a juror be excused without giving any reason. If you are excused by either side, please do not feel offended or feel that your honesty and integrity has been questioned. It has not. In addition, you may be questioned about your jury service once you're excused. If you are questioned by anyone, including members of the media, you are permitted to talk to them, but I would encourage you to respect the feelings of your fellow jurors, to not discuss anything that you think may impede the court in selecting an impartial jury while we're in this process. And if you don't want to talk to them and they persist, you could report that to the court. At this time, the court is going to begin its portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own inquiries. When I'm asking questions to certain jurors, please pay attention to those, as you may be called upon later to answer the same questions. First question I'll ask relates not the 22-page questionnaire you filled, but a juror information form, which contains information such as your residency in Ada County, for example. Is there anyone here that thinks the information in your juror information form is inaccurate and would need to be corrected? Okay, no one answered to that. I'll next ask on the questionnaire then, and without necessarily getting into the details because those will be discussed, but is there anything you think within your questionnaire that at this stage you just need to change or correct? All right, no one responded to that. The next matter I want to bring up relates to the time commitment for this trial. This is scheduled to be a long trial, and parties have estimated it will take approximately 8 to 10 weeks. Given that time frame, would such service create a hardship upon you or your family or your business or profession or occupation so as to prevent you from rendering service as a fair and impartial juror in this case? If you believe you do have a hardship given the length of the trial, please raise your red card. All right, we've got 2 jurors that have responded to that. On the front row, could you raise yours again, please? Thank you. All right, at this point then, I'm going to address those hardship requests individually. So we'll start with the first juror on the front row, number 1248.
Sure, yeah.
I was just reviewing your questionnaire real quick to see what you indicated. You did check the yes box for whether you thought there was a hardship. You said working full-time and losing that much income would be a financial burden. Have you been able to discuss your possible service with your employer in this case?
I discussed that with HR yesterday. They would only be able to cover 2 weeks.
And that is what they just confirmed yesterday?
Yes.
All right. Is that your sole source of income?
It is.
And if you were to be out 8 weeks of pay, would that financially strain you?
It would.
All right. Any follow-up questions from the state on a board dire for hardship for this juror?
No, Your Honor, we actually had a note to follow up with juror 1248. I think given that additional information today, the state would make a motion to move for cause for the hardship. And that's exactly what we were going to follow up with today.
All right. Any board dire from the defense?
Judge, we would also need to excuse.
Very well. Juror 1248, we appreciate you coming in and taking the time to fill out the questionnaire and returning. I understand with that being your sole source of income and the length of this trial, that would constitute a hardship for you, so you can be excused from service. The bailiff will take your questionnaire, and thanks again for coming in. Juror number 1632 has indicated they would have a hardship also. You did mention in your questionnaire a concern about a trip planned, I think early June. Could you give some more explanation about what the trip is, when it is, and if it could be changed?
Trip is planned for June 4th through June 12th. So vacation, family reunion. Supposed to be canceled. I also do, as far as family, take my kid to school. My wife is a teacher who is starting her workday before our kids' school day.
Follow-up board dire, please, from the state.
Your Honor, the state does not have any additional questions. We would simply submit to the court on this one.
I'll have a bit of a follow-up on the plans you have on that trip. Have you pre-purchased or already paid for anything such as flights?
They have not been purchased by me. They are being purchased by a family member. Potentially, it could be put off.
Okay. Mr. Pryor.
Tell me a little bit more about the family. It's a large extended family, or?
I don't have a large family. I do have family in Alabama
That's what the family reunion, that's where it's going to be?
Yeah, my dad's side of the family.
So how many people are we talking about?
It's my family, my parents, my brother and his wife, and then the people that live down there. Half dozen to a dozen.
And this was, what I recall, is that this was reset as a result of COVID. Is that right?
Correct. Yeah, back in, I don't remember the specific date, but back in 2020 or 2021, it was canceled because of COVID, yes.
And are other relatives flying in from other parts of the country as well?
Just my brother and his wife are flying in from Maine.
Judge, I would submit to the court.
Juror 1632, if you remained in and missed the trip, do you think that would become a distraction for you, knowing that you missed out on a trip that's been planned for several years here?
Possibly.
I understand. Given that it was already rescheduled and canceled once, it is a long trial. There's a likelihood we may well be in the trial on those dates. I am going to permit, for your request, the excusal for hardship. In addition, with your child care obligations as well, court will find you to be excused. So juror number 1632, thank you for coming in and completing your questionnaire.
Thank you.
You're welcome. Did anyone else have a concern on that issue they wanted to raise with the court? All right, well, thanks everyone for your commitment to being available for that time frame. The next issue we'll bring up then relates to whether or not you have any previous knowledge of this case. This case has had significant exposure and reporting in the media. If you have had any knowledge of that case, we'll discuss that with you individually. So all I'll ask at this time is if you do have some knowledge of this case, the facts of this case, or the issues involved with in this case, would you please raise your red card? Or your hand, okay. If you'll give us a moment, we'll note these down. All right, thank you. We'll come back and question you individually about those matters. Next topic I'll raise is the subject matter of the case. I've read to you the charges. Would the subject matter of this case, including charges involving murder, conspiracy, and insurance fraud, make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict? No one answered yes to that. I'll next ask a series of questions that will seem very obvious perhaps to you, but I'm required to ask them under Idaho law to ensure that you don't have any kind of improper connection to this case or any of the people involved in the case. So the first question along those lines is, are you related by blood or marriage to the defendant, Mr. Daybell, or do you know him from any kind of business or social relationship? No one said yes. Do any of you have a legal relationship such as guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger, any of those kinds of relationships between any of you and any of the attorneys in the case? No one said yes to that. Are any of you a party in any civil action lawsuit against Mr. Daybell? No answer to that. Have any of you ever brought a criminal complaint against Mr. Daybell or been accused of a crime by any of the prosecutors that are here present today? No one responded to that. Do any of you have any kind of an attorney-client relationship with Mr. Pryor, either now or in the past, or his law firm? No one responded to that. Are any of you related by blood or marriage to any of the lawyers here? Or do any of you know any of the lawyers from a professional, business, or social relationship? No response. Have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? There's no response there. Do any of you have any bias or prejudice either for or against the defendant, Mr. Daybell? There's no response there. Are any of you unwilling to follow the court's instructions as to the law you must apply in determining this case? No response. Do any of you have a religious or moral position that would make it impossible to sit in judgment of another or to render a fair and impartial verdict? No response to that. Are there any of you that if you are selected as a juror in this case, would you be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? There's no response to that. I have one final question then. Do any of you have any other reason why you cannot give this case your undivided attention and render a fair and impartial verdict? All right, no one responded to that. That will conclude the court section of voir dire examination. I'll next allow the state to proceed with its voir dire group. Is that going to be Ms. Blake?
It is, Your Honor.
All right, Ms. Blake, you can proceed.
Thank you. And ladies and gentlemen, thank you for being back this afternoon. I know this has already been quite a process. You were all here last week to fill out a questionnaire. Now we have you back here today. We are going to go over questions with you today, just to get some information. I want to go over a little bit why we're doing that. As you sit here today as potential jurors, what we're trying to do is make sure we select a jury that feels that they can be fair and impartial and that they can hear all the evidence in this case, give it the weight they think it's due, and ultimately render a decision and a verdict in this matter. So we go through this. The defendant, Chad Daybell, is entitled to a fair trial, and the state of Idaho is also entitled to a fair trial. So that's why we go through these questions. We just want to ensure that that's what both parties receive. So as I ask you questions, I don't want anyone to feel like I'm picking on you, but I will call on some people, get some responses, and just kind of go from there. Also, as we do this, the judge has already told you, but if at any time I ask you something that you're not comfortable talking about in a group setting, that is totally fine. I may ask something that I have no idea, maybe something personal, something that you'd rather talk about not in front of everyone. Just let us know, and we'll do our best to make those accommodations. This is not meant to make anyone feel uncomfortable. That being said, I want to start with throwing out the term brutal honesty. I want you to think about that for a minute. And juror 1219, if you hear the term brutal honesty, what does that mean to you?
Seeing the facts for what they are and speaking your mind.
Thank you for that. And juror 1537, how about for you?
Just telling the truth, I guess.
Thank you. I appreciate both those responses. And would everyone agree that it may also mean you don't hold back, even if it might hurt someone's feelings? You're not going to do a white lie. You're not going to spare feelings. It's just going to be telling it how it is. Would everyone agree that that would be being truly honest or brutally honest with someone?
Yes.
Thank you. And the reason I go over that with all of you is as you sit here today, there's two reasons for this. One is today, as we're going through this process, I'm going to ask you all to be brutally honest. Don't hold back. If there's something you think we need to know, either party, tell us. That's what we're here for today. And the second part of it is, as we go through everything, if you're selected to be a juror, at some point, the judge will give you jury instructions, and he'll tell you at what point you can start deliberating with each other. And we need to make sure that when you're back deliberating, you can also be brutally honest or honest with each other as you go through that process. Hearing that today, does that cause any concerns for anyone? No.
No.
Thank you. And we all may have someone that we know is kind of our go-to. So for me, my oldest niece, I learned pretty quick when she was little. She hadn't learned any filter. She hadn't learned kind of the little white lies or to spare feelings. So if I truly wanted to know something, I could go to her. If I wanted to know how my hair looked or how an outfit looked, she just gave it to me straight. And do most of you have someone like that in your life, whether a kid or a trusted adult that you know you can go to for just the straight answer? Yeah. That's what we're asking you to do today. Just be that person for all of us here. Have all of you flown on a plane before?
Yes.
Like everyone has. So normally you get on the plane and at some point they tell you, hey, sit back, enjoy your flight. We're going to get to the destination at approximately such and such time. And they take off. If instead of hearing that announcement, you got on the plane and the pilot came over the PA and said, so I'm going to try to land the plane and I think we're going to get to the destination at this time, and I'll do my best. Would any of you feel comfortable staying on that plane? No. And juror 1577, I think I saw a pretty emphatic shake of your head. Why wouldn't you feel comfortable staying on that plane?
There's too much doubt. There's doubt that I would make it.
You want that assurance. That's fair. And juror 1353, how about you?
I would hope he was joking.
And I think that's a fair answer as well. And the reason I bring that up is you're all going to be the pilot in this case, essentially. And we want to make sure that everyone can give us the assurance that, again, we've kind of talked about it, but that you'll be able to sit on the jury, hear the evidence, give it the weight you think it's due, and land the plane. Be able to give us that verdict after listening to everything and to be fair and impartial in doing it. Does anyone sitting here today have any concerns about your ability to do that? Thank you. The judge already talked to you a little bit about the charges in this case. And so as you all know, there's several counts of conspiracy to commit first-degree murder. And there are also several counts of first-degree murder. The victims in this case involve 2 children and a mother of 5. Because of the nature of the case, you will see some images that may be graphic. They may be disturbing to some people. It's the evidence in the case that you'll be presented with. Knowing that, does that cause anyone concerns about your ability to sit on this jury and weigh that evidence with all the other evidence and just give it the weight you think it's due? And juror 1330, I think that maybe was from you. Talk to me a little bit about that, if you're willing.
I feel like I can say that I would be fine. I think I could tell myself that I would be fine until I saw it. And as a mother, I might not be able to see.
So I don't want to put you too much on the spot, but I just want to talk to you a little bit more about that. So if you were given an instruction by the judge that you're to view all the evidence, give it the weight you think it's due, do you think viewing those type of images would have such an effect on you that you couldn't be fair and impartial and weigh the evidence, the other evidence?
No.
You think you would be able to view it, even though it might be upsetting?
Be impartial, absolutely. But could I look at it? Difficult.
And when you say difficult to look at it, if you knew you had to view all the evidence, do you think, even though it might be disturbing, which is normal, do you think you would be able to view it and then just give it the weight you think it's due in relation to all the other evidence you may see or hear?
Yes.
Thank you for that. And juror 977, I think you also are a mother. Does that cause you any concern about your ability to be able to view those images? Do you think that if shown them, even if they were upsetting to you, do you think you would be able to just weigh them and give them the evidence or the weight you think they're due in relation to all the other evidence that you may see or hear? Nothing about them would automatically make you form an opinion just based on those alone. Thank you for that. And juror 1288, I apologize, I think I missed a hand from you, so I'm sorry about that. Can you talk to me a little bit about your thoughts on that?
Yeah, I've two very young children. It would be very difficult for me to see that.
And kind of same line of questioning, while it might be difficult and it might be upsetting, do you think you would be able to view those images and give them the weight you think they're due in relation to any other and all other evidence presented in the case?
I think I would be able to, yes.
And I know there was a little bit of hesitation there, so I'm just going to follow up a little bit. If you looked at those images, do you think it would automatically cause you to form an opinion of guilt or innocence, or do you think you'd be able to just view it and wait until it's time to deliberate and form that opinion?
I think I would struggle to not make an immediate.
And when we talk about an immediate opinion, do you think you would automatically attribute the images to the defendant and hold them against him? Or would you be willing to listen to all the evidence and make that determination?
I would be willing to listen, but I worry truthfully that I could be partial at proceeding.
I may have just a moment, Your Honor.
Yes.
And juror 1288, we may follow up with you a little bit more on the individual, if you'll still bear with us and hang in there for this process. Thank you. So I also have a little kid, and in the mornings when he gets up, if I ask him, what do you want for breakfast? 9 times out of 10, it's cheesy eggs. And there is a very specific recipe that he likes me to follow. So it's the eggs and the milk and the cheese and salt and pepper. And if I modify it, he might get upset with me. He might refuse to eat it. Sometimes he might want some extra cheese and I'll do that for him. Do any of you have someone in your life like that, whether a kid or an adult you know that maybe has a specific recipe they like done just a certain way?
Yes.
And juror 1436, I think you had said yes.
Mm-hmm.
Can you tell me a little bit about that?
Well, I have 2 kids. I'm pretty picky, and they want things a certain way. And if it's not made that way, then they don't want to eat it. So,
and oftentimes, are you willing to do it the way they want?
majority, yeah.
Do you sometimes modify it?
Yes.
Fair enough. And juror 1185, how about you?
He's a pretty picky guy. Really like in the seasoning or anything, so if I try and do anything too special.
I'm having a little trouble hearing.
So, my son.
After I don't believe. I got to.
I'll just repeat it. So my son's pretty picky. If I try and add any like spices or anything to his food, which I'm always trying to do because I'm a chef, but he won't eat it.
And I noticed you were a chef, so I kind of wondered about that. So you deal with recipes a lot.
Yes.
And in your line of work, do you sometimes modify them?
Only if you have to.
So at times, do you just follow the recipe as is?
Yes.
And why do you do that?
Because it's what works.
And someone else has either determined that or you've maybe created the recipe yourself?
Yes.
And you know that's what works. So in this case, because in our everyday lives, sometimes we might modify things a little bit. We may look at a recipe and say, I'm going to add or subtract this. I'm going to do it a little bit different. But again, we've talked about the jury instructions. The judge is going to give you very specific jury instructions. And in this situation, you won't be able to modify those. So it'll be whatever the judge instructs. That's it. That's the law. That's what you follow. And that will include some instructions regarding these particular crimes and what elements are required to be proven. So in that, kind of like ingredients in a recipe, the judge will outline what is necessary. Sometimes you might look at that and think, man, I really wish this element makes no sense to me. Why do they have to prove this? Or you may think, well, they should also have to prove this. This doesn't make any sense. But you don't get to modify it here. Does anyone have concerns about their ability to follow the instructions as given by the court?
No.
And one of, or some of the charges here deal with the crime of homicide. And you'll be given an instruction, and again, it's what's given by the judge that'll be what matters. But it will include something along the lines of that the individual was involved, that the defendant engaged in conduct which caused the death of a person. So that'll be one of the elements. What you won't see is there will not be an element that says the state has to prove what the cause was. So it'll say we have to prove someone did it, but we don't have to prove how they did it necessarily. Or we don't have to prove why the person actually died, what was the cause. Does anyone have concerns that if the state is able to prove that a murder happened, will anyone be thinking that the court should have added that element? Or will everyone be able to follow the court's instruction as given?
Yes.
Follow the instruction as given. Does that cause anyone concern sitting here today? Thank you. Anyone here an NFL fan? I see some nods, so we got quite a few. Juror 1271, you nodded your head.
Yep.
So Kansas City Chiefs won this year. You don't have to tell me how you feel about it. You can if you want. Okay. So knowing that, and even with that, would you agree that every person on the Kansas City Chief team should get a Super Bowl ring?
Yes.
And that could include, and so even if the quarterback played a bigger role, do you think the punter should still get a ring?
Sure.
And the second string? Even if they didn't play on the field? And why do you think that?
In my experience from growing up playing sports to my career now is that sometimes the most underrepresented individual within that group actually is overwhelmingly a reason why there's a success to a plan being whatever that is. And it's not the one that's always sitting behind the camera. So it's very obvious to me that everyone should, right, for that reason. So you don't understand what really happens behind the scenes.
Right, thank you for that. And you're 1503. How about you? What do you think? Should everyone get the ring? And why do you think?
Well, I play soccer, I like team sports, so I think it's a collective effort to win and lose. So, yeah. So yeah, that everyone equally participates in that.
I appreciate those answers and thanks for the involvement. You heard the judge start to give an instruction regarding conspiracy, or he did give you an instruction regarding conspiracy. And he talked about it being an agreement by two or more persons to commit a crime. And the actual instruction he gave talked about that you're not to consider Lori Vallow Daybell or Alex Cox's guilt or anything that may be going on with their cases. And we all understand that. Everyone's in agreement that they'll follow that instruction. Yes. What you will hear about in this trial, though, are some actions that are alleged to have been taken by Lori Vallow Daybell and actions that have been taken by Alex Cox. And remember, a conspiracy is an agreement between two or more persons to commit a crime. An additional element is that then just one of those persons has to do an act in furtherance of the conspiracy. So just one person has to take an action that gets them closer to committing that crime. So if you were to hear evidence that there's, A, B, and C involved in a conspiracy, A, B, and C reach an agreement, and you think the state has proven that there's an agreement to meet a crime, and you think the state proves that all the individuals or the particular individuals involved wanted to commit that crime, wanted that crime to happen, and the state only shows that, say, person C did an act in furtherance. If given jury instructions describing conspiracy that way, would you be able to still hold person A or B accountable for the actions of person C, given that there had to be the agreement and just one person had to do something in furtherance?
No.
You wouldn't be able to? And that's juror 1353. So let's talk a little bit about that. What's your concern with that?
I think everybody should be responsible for their actions. You can talk about doing something, but doing it is completely different. So you're responsible for what you do, not for what you talk about.
And if you're told that conspiracy involves reaching an agreement. So we're talking about people meeting and agreeing to commit a crime. Does that change anything for you that there's that agreement, that we're required to prove there's an agreement?
No, they have to do it. They have to commit the crime.
And if you were given a jury instruction that said, this is what conspiracy is, and you just have to find one person did an act in furtherance, would you find that hard or impossible to follow that jury instruction?
It would be impossible.
Your Honor, given that, the state would make a motion to excuse juror 1353 for cause.
Judge, can we approach?
Yes.
Yankees. Oh.
Boing, boing, boing.
Boing, boing, boing.
I mean, I don't know why they're meeting, like sidebarring. That dude just said he cannot.
Mm-hmm.
Maybe he just wants off the jury. Maybe he really cannot.
Mm. Do not know.
Do not know.
Do not know. Oh, shoot. Daggone it. I forgot about the daggone thing.
I put the link in the Discord because it wouldn't fit in the back chat.
Mm.
I can try it, but I don't think it'll fit. Yeah, I think it cuts it off. You can try it, but I put it in back chat.
I got it.
Okay.
Okay, hold on. Let me pause this. Go over here. Let me pause this. And let me rewind it. Looks like they started late. It looks like it was only like 6 minutes and something, so. Let me share this tab. Make it big. So yeah, this is the live hearing for Bryan Kohberger.
Concerns we had about the specific language of the questions were being.
They must have started the feed like not right when it started, so they may have started the feed late, it looks like.
Concerns we had about the specific language of the questions were being asked. And Ms. Taylor represented to us, and I do not dispute this, that's why I want to make this part of the record, that she had not seen the actual questions themselves, that she had approved the topics that could be looked into during the survey. So I want to put that in the record that we are not accusing Ms. Taylor of drafting these questions verbatim and then say, go send these out to the public. We are concerned, though, that the people hired by the defense to conduct this survey did exactly that. And the examples of the things that are of concern can be found in the transcript of one of the calls. As Your Honor will recall, we had a person come to us who had received one of these calls, actually recorded the call. And so our office prepared a transcript, and that was attached as Exhibit B, I believe, to our motion for order prohibiting contact. In addition to generic questions about the criminal justice system, here's where we get to things that concern the state immensely. Question: have you read, seen, or heard if Bryan Kohberger was arrested at his parents' home in Pennsylvania? Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Bryan Kohberger? Question: have you read, seen, or heard if Bryan Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? Have you seen, read, seen, or heard if the cell phone tower data showed that Bryan Kohberger made several trips near the victim's home in the month before the killing? Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Bryan Kohberger was arrested for the murders? Have you read, seen, or heard if Bryan Kohberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Bryan Kohberger stalked one of the victims? Have you read, seen, or heard if Bryan Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial, or the performance of results of examination tests. And these questions specifically refer to DNA testing. Now, I recognize that the defense says, well, all of this information is out there in the public media somewhere, but that misses the point. That's assuming that every person in Latah County who is called has followed all of this nonsense in social media, has followed extensive coverage. There are people who consciously avoid reading coverage or listening to coverage about this case because they don't want to. That's the fallacy of the position defense is taking here. So what the agents of the defense have done is they have gone out and interrogated 400 citizens of Latah County and embedded in them facts specific to this case, some of which are not even true, some of which would not be admissible in court. And those people, whether they had heard that information before or not, are now saturated with that information. That is exactly what the non-dissemination order was intended to prohibit. That is reckless conduct, and it's outrageous. They can ask a survey, and they can ask people, what do you know about the Bryan Kohberger case? What have you heard about the Bryan Kohberger case? What do you think about the Bryan Kohberger case? Do you have an opinion as to whether he's guilty or not guilty? Why do you think that? They can ask all those questions, legitimate survey questions if you wanted to do a legitimate survey of public sentiment. But these questions go far beyond that. And I recognize that that it is represented that the survey questioning here in Latah County with those 400 residents has been completed, but they're already saying they want to take these questions out to other possible deniers. Doing the same thing in other potential jury pools that they're doing with our own. That is far beyond acceptable. These are questions that, quite frankly, might not be able to ask in voir dire, much less into an uncontrolled, unsupervised environment without any bounds, and just recklessly feeding this information, which is sensitive. And it's particularly sensitive when it comes to information that the state does not believe is true, or the state does not believe would be admissible or would be offered at trial. On the issue of whether information already publicly available isn't included in Your Honor's order, which it clearly is because it doesn't say otherwise, we know that there is no exception in the court's order saying if the information is already publicly known, it's okay to disseminate it again. And indeed, that would be reckless for the very reasons that I just articulated, Judge. We would then be feeding information that is potentially prejudicial or that could affect the open-mindedness of prospective jurors to people who may not have heard it before. That's completely reckless. And so, Your Honor, based on that, we think this needs to come to a stop. We think if the defense wants to continue doing survey work, which they are welcome to do, given what we've seen here, that the questions need to be approved by the court before they go out. And the question certainly should not include the types of questions, fact-specific questions that have been delivered to 400 citizens of Latah County. That's where we're standing right now, Judge. Thank you.
Thank you. So then how can we compare unless you use the same questions? That's the problem. I mean, the damage has been done.
Well, that's one argument to make, but we don't want to perpetuate the damage that was done. And if they want to do a comparison, then they could have another survey in Latah County and do a responsible survey questionnaire instead of one tainting this people. And frankly, they should ensure that they don't go to the same phone numbers that they preloaded with this other factual information when they make their legitimate survey inquiries. The defense's people brought this on themselves. It's not the state's fault. Nobody had control over this other than the folks working for the defense. They made their bed. They got to live with it. I mean, frankly, if we were in the commercial context, we would say, not only will you do this over and do it correctly, but we will not pay you for the work you did that was so outrageously wrong. That's not the context right here. I don't care about that. What I care about is making sure that more people aren't tainted. And I would suspect, Judge, as we move forward in this case, that the state will be asking the defense, and if they aren't willing to provide it, asking the court to order the defense to provide the identity of every person that was contacted in those surveys. So when we get to voir dire, we can identify people who have been contacted, I guess is the best word to describe, and faced with these questions. And so we can incorporate that into the questions during voir dire to see just how much impact, if any, it had on each one of those particular jurors. I don't know how else to deal with this. I realize
disqualified 40 people.
Well, we could 400.
400. That's what I meant. Sorry. Yeah.
400. And we could do that. You know, Latah County has almost 40,000 residents, although not all of those are going to be part of the jury panels, prospective jury panels, but 400 may be a reasonably small number. And yes, I think that certainly would be a viable solution, is just identify those people. We can certainly identify them by telephone number it was called, and just not include them on the list.
Since you're standing up, you want to talk about due process?
Actually, Mr. Nye is the one prepared to talk about due process, and that's why he's on. He's available by Zoom. If you'd like to have that now, that would be good.
I'll come back to that.
Yes, sir. Thank you.
I'm concerned about that, Ms. Taylor. So go ahead. Your turn.
Your Honor, we have Bryan Edelman ready to testify by Zoom about these surveys if the court would hear his testimony.
First, I want to hear about the process. I care more about how this came down than what he did. Although I just learned for the first time that you had nothing to do with the questions.
I didn't write the questions, Judge. Those questions are generated by Bryan Edelman, and he can tell you who he is and his educational background and why the questions are crafted as they're crafted. But I approved him doing this survey. This is not an anomaly. These kinds of surveys are done in high-profile cases quite often. I don't know how I could present to the court what's going to be required at the venue change hearing without understanding what is going on with the public. This is an anonymous survey. This is not one where anybody's identified as far as the defense wants to know this or the prosecutor wants to know this. It's a random survey, and there's a reason why there are general questions and more specific questions. And Mr. Edelman can explain that, but I'll do my best to paraphrase that.
Okay, well, I'm just curious, did Mr. Edelman, was he aware of the dissemination order?
I don't know if he was aware of that or not, but we gave him no information in the case, Your Honor. He received nothing from us as far as no police reports, no contact with our client, no interviews. He received no information. His entire construct of this survey is, as he does in his high profile cases, he pulled the media local to this area to see what the most common stories were. Those are things that are in the public arena. Though this court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public. We didn't provide him any police reports. We didn't.
I'm sorry, it's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial. Okay, and our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. Kohberger, to get a fair trial. And some of these questions actually create a concern about, well, that they're inculpatory. It could be prejudice for his client. Okay, and that I'm just surprised that both of you didn't come together and say, you know, there are certain things that we probably shouldn't put into the public on a telephone call. I mean, it really concerns me, and that's why I did what I did that Friday. Now I'm being accused of violating a due process, which is a whole big issue for me.
I can understand that would not be taken. I have to represent my client to the best of my ability. And the reason for that, Your Honor, with all due respect, I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard. And that's going to delve into our argument on due process. But since it came up and since that feels like the elephant in the room right now, I think maybe we should just go ahead and address that.
Sure.
And that was my motion. And I asked you to set aside the order that you made without having a chance to hear from us, making a decision that now you're locked into, and it was a one-sided decision.
I'm not locked into anything. My order didn't say it was permanent.
Maybe
and it told you that I was going to have a hearing.
Maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday. Now, it doesn't even reflect, you know, just when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday. I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I filed an objection the minute I could.
Because then you know that about 5 o'clock, that's what I issued that. So I had a half an hour. I read the materials that were attached to the motion that the state filed, and I had very little information. But it seemed like there were some real legitimate concerns about the survey. And obviously, it turns out there are concerns, legitimate concerns about what was done in the survey. So in my order, I told you that I was going to set a hearing. So I don't know what your understanding is with just the process. Okay, but on Friday, sent this hearing. So what are we doing today? Okay, I'm hearing you out. You had notice. I mean, really, that's what we're talking about. That's what the law. What is your understanding of due process?
My understanding is that I should have notice and an opportunity to be heard.
And you did that.
I'm having that now, but there has been a decision made by this court almost 2 weeks ago that stopped us from completing our work. I understand that Mr. Thompson raised a concern, and his last paragraph to the court in his motion was, it seems that it may have violated the non-dissemination order. And so we're stopped from completing our comparative surveys right there when we're up against the deadline to get to our motion to change a venue. I'm looking at, it stops me from doing the work and meeting the deadlines to argue for Bryan to be in a place where he can have a fair trial. I think the court should not have issued an order stopping us, but set a hearing, shorten time, set it for Monday morning. If the court wanted to set a hearing for that Monday morning, we wouldn't have lost 2 weeks worth of work if the court chooses to let us complete the work.
But that could have been more damage. I mean, you know, this less than 2 weeks really has very, very little impact, okay, on your work.
It does have an impact, Your Honor.
You don't even have a trial set. Come on.
We have our motion to change venue. We don't have trial. You're right. We don't have trial. My understanding was that we were going to hear the venue change and the court was going to make a decision and then set trial, so that we didn't send out a bunch of subpoenas and reserve this courtroom unless we're going to stay here. That was my understanding. My problem, what sets me back, is getting my work complete to get my briefing to the state in the time and the deadline that I was already given, and meeting that hearing date that's set for venue change. And from there, everything else flows. When are we going to set trial?
We wouldn't even be here, okay, if there was some communication between you and the state about the survey.
There are things I can communicate with the state about, and there are things that I cannot communicate with the state about. How I'm preparing my case is not one of those things. It's just not one of those things. I go and see Bill and Ashley. I go to their office every week. Oftentimes we talk. We email each other. We talk to each other. But I don't need their permission every step of the way to prepare my case. Doing these surveys is not an anomaly. This is something that's done in these high-profile cases.
Well, apparently, Mr. Alden did not even see the non-dissemination order, and you apparently did not give that to him. So this is a very not a usual case, number one. And you know that we've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people, without a permission of the court, without discussion with the state. I mean, that's troubles me. And then when I'm being accused, directly accused, okay, by you in your brief, that I violated his due process rights. Now, that's not what the law says, and that's not what the facts are. And you even cited cases that say exactly what due process is in the law, right?
I understand that, and I agree that's what due process is. My issue is that the order was signed, stopping our work without a chance to be heard. It's as if the state and the court had decided we violated the non-dissemination order, and we didn't.
All I was doing was stalling it, okay, for less than 2 weeks so we could have this hearing, number one. Now, if you feel like you've been
prejudiced, or your client has been prejudiced for less than 2 weeks, okay, in this work, I'll push it out. I'll just push out the trial. I mean, not the trial, but the hearing. I mean, is that satisfactory?
Your Honor, I think that might be what we need.
Fine.
I need to figure out if we're going to be able to continue the surveys. But if we are, I expect that we will need some additional time to get them done so that I can get the work to the state to review.
Okay, well, that's a different issue. I've never said, no, you can't do a survey. This was a total shock to me that Friday at 4:30.
I can understand that. It was a shock to the state.
I had to stall it out, okay? Because so that we could all talk about it and figure out what is the right path. Okay, because this is a big deal. And I take it very, very seriously. And I was surprised, okay, that this was happening behind our backs, my backs. Okay.
I understand that this probably is the first time this court has run into it. I know it was the first time that Mr. Thompson has run into it. I haven't used the survey in my own cases because I haven't had a case like Bryan's case before. This is an extremely high profile case. I've been involved in a lot of capital cases and I understand the standard of care in capital cases. I also know that this very kind of survey was used about 7 years ago in Kootenai County in another high profile case. I wasn't on the case, but I'm aware of it. I'm aware that this very survey has been used in other jurisdictions, other counties in Idaho and other states in really high profile cases. So I understand that it was a surprise to Mr. Thompson. He told me it was. And I'm hearing the court say that's a surprise as well.
How it was done. I'm not concerned. I figured there was going to be a survey at some point. There would have to be. It was the way it was done, okay, and the questions that were asked. That is the real problem, as Mr. Thompson pointed out.
So the way it was done, I know in the other Kootenai County case, permission to do the survey wasn't sought of the state, the prosecutor, or the judge. I can comment on that one. I know about that. I don't know about the other cases. So that takes us to why did we ask the questions we asked? I don't think it's common to get permission from the state to do our work. I think that it's a surprise because it's the first time that's happened, at least when this court's been on the bench and in Mr. Thompson's tenure here. So I understand that. When I met with Bill and Ashley in their office on the 21st, I asked them not to give you the police reports that they had in the transcript without me having a chance to be heard, because I didn't want an order without us being able to talk to the court. I asked if we could maybe set up an on-the-record meeting with the court to talk about this. And that wasn't what was done. It was Friday when this went out.
Sure. I mean, I would have been available on Friday to talk about it if that was necessary.
I would have gladly sat down. I didn't offer that next Friday. I would have come to town for it. I offered the following Thursday and Friday, knowing that I had a lot of availability both of those days. I would have come to town. I would have gladly sat down. By this point, the prosecutor knows I'm not telling him my preparation in the case, and I could have explained it. The thing I didn't want to happen is exactly what did happen. All of a sudden, there's an accusation against us and there's an order signed stopping us. I appreciate the court being willing to just push everything out 2 weeks. I think that's helpful. And I mean, if that's what the court's willing to do, that's fine. But the problem is we are stopped and then we have to respond to this. And if you think about the non-dissemination order, for sure, we wanted that non-dissemination order. We're the ones that asked for it. We're the ones that argued for it. We also know that our non-dissemination order mimics Idaho Rule of Professional Conduct 3.6. And when you look at that in the comments of that, I think it's helpful. There are things that we can say publicly, but we choose not to. Our team doesn't even so much as answer no comment to emails, to calls, to people trying to talk to us, because we just don't want to do that. It's easier to say nothing. So the construct of this survey is to ask these general questions. And then you ask specific ones because you get different answers when you ask those. It is not injecting information. They are, have you read, seen, or heard? And remember, these are anonymous and these are random. So they're not planned. Nobody's planned to be contacted. I don't know the names. I'm sure I can get the phone numbers if that's what the court wants. But I don't know who the people are. Nobody's identified as the person they're being called on behalf of, even when pressed by Detective Payne, that people conducting the survey didn't know. If we go back to the non-dissemination order, which mirrors Rule 3.6, that's to prevent lawyers involved in a case from making statements that will be widely disseminated, right? To talk to the press. And the purpose of that is because I read the police reports. I would have a little more credibility than anybody else on the street saying something about the case. Same with Bill. That's the purpose of it, so that we don't say things to the press on Dateline, on 48 hours, because we've actually read police reports, we've interviewed people, and we're doing the work on the case. So when you have an anonymous survey that doesn't identify the person conducting the survey, didn't know who was behind it as far as which party to the case, they can't answer that. So all of a sudden, their questioning about what you've seen in the media doesn't come from a particular party in the case. And the purpose of it is to ferret out what if people have exposure to the case. If you look at State's Attachment B, you can see on page 2 that there's questions, and I'm at lines 10 through 12, about what they know about the case from the media. This is all, again, looking at our non-dissemination order and looking at the rule, things that are in the public record, right? That everything is public in this case unless we specifically seal it. So this person says they don't know much. And then if you go to page 4, there are several things they do know, and that's the purpose of it. When somebody's given a broad question, tell me what you know about this, they're like, I don't know. I don't really know what you want, so I'm not going to say anything. And they don't give you an answer. But when you say, have you read, seen, or heard X? Well, yeah. And then it's the next question. And if the answer is, no, I don't, it's next question. Nobody's saying, well, it was in the newspaper on 15 occasions. And this is particularly borne out when you think about the things, and the state said it, some of these things are things that are just not true. That's what the Haddon case tells me I have to show you. It's not enough that there's just a lot of media coverage, and it's a lot more harmful if it's media coverage about things that aren't true. So it's nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media? And if the answer is yes, you move on. If the answer is no, you move on. That's what the survey was about. And you can see why, looking at pages 2 and 4 of State's Exhibit B. And I think that we should also think about what the words in the non-dissemination order mean. When you say we disseminated information, that means to make widely available. This is a one-on-one conversation with no party identified. This isn't making it widely available. When you talk about disseminating information, the definition of that is to put it out there by public means, radio, TV, social media. And that's not what was happening either. These were questions. And they were things lifted 100% from the media, 100% already in the public record. And it is a one-by-one conversation. This isn't something that's being put out there through social.
Well, it kind of is.
Well, now it is, but I certainly didn't expect
400
this.
people, okay? It's planting some seeds where then people are encouraged or they think, oh, wow, I didn't know that. I'm gonna look more into this. I mean, again, I mean, we were trying to keep the false information that was out there in media land, that it wasn't going to affect your client.
I agree. This is less than 1% of the population. It's one-on-one. It's not by means of public communication. To think about alleging that we violated the non-dissemination order is basically alleging that we violated our ethical rules as well. And there's parts to it.
I'm not accusing you of that, especially now that I know that you that you didn't.
I didn't write the questions, but I knew what was going to happen. I take responsibility for the choices on the case, Judge, but I just don't think this is a violation of the ethical rules or non-dissemination order. These are questions about things already in the public record. That's in our order. That's in the rule.
Let me ask you this. I mean, really, getting hit by this on late on Friday afternoon, okay? I mean, I'm not sure what a judge should do in a situation like that. But I just say, yeah, no, keep going until we can have a hearing in 2 weeks or less than 2 weeks? Or do you just pause it down so that everybody can talk about it and figure out if there is an issue? That's how I looked at it from where I was sitting and what the information that was provided to me. And you did respond to it, but you said you were going to submit a brief and affidavit. That's great, but it was 5 o'clock on Friday.
I know.
So,
and I mean, I can't tell you how frustrating that was for me. I've had this conversation with the prosecutor the day before. I'd offered to come and talk to the court and let the court look at all this. I knew full well if they did exactly what they did, the court would sign an order before I had a chance to say, hey, wait a minute. Let's really look at all of the words in the non-dissemination order. Let me tell you why we did this. I knew exactly what would happen. I don't want to say that there's like that you should do something different. I want to be heard on these things. I don't want the court to, on a Friday night, get a flurry of things that I can't respond to and ask you to think about the bigger context. We're lawyers, words mean something.
Well, did you think I wasn't going to give you an opportunity to be heard?
No, your order said I could be heard later, but there was a decision that was made then. And it's hard for me to wrap my head around the court taking this as an emergency motion when the words in the state's motion telling you put a stop to it are, it seems like they might have violated this. That is a weak accusation for the court to take an emergency order position on. But I know why the court did. The court has all of this and no context for it. And it's a Friday night. And I mean, if you'd received this on Thursday, my guess is you would have said, we're having a hearing Friday morning. I don't care if it's by Zoom.
Right. I told you all, both sides, you know, if you need to have a quick hearing, let me know. We can do it on Zoom. I mean, I want to move this thing along.
I would have been available.
Spending all this energy, okay,
yeah,
about this issue.
I lost a weekend of what I planned to respond to this. I thought we would probably be dealing with it on an in chambers on the record meeting on the Thursday or Friday until I got the motion.
Yeah, I have about 7 briefs in now.
Well, you can see we lost a lot of time.
I'm not complaining about it because I'm learning a lot.
The last thing I'm going to say on this, Judge, is that non-dissemination order contemplates that you make this statement that you reasonably know is going to go out and harm the trial. This survey was never intended to do anything but identify issues within this county to support or defeat our argument for venue change. When you hear from Bryan Edelman, which I don't know if you have to now because I've said sort of things.
I'm happy to hear what he has to say if you want him to be said
You
to me?
would know, and you probably know from his affidavit, sometimes he recommends against venue change.
Sure.
Because it's not there. He's done with Latah County. The results aren't compiled yet. I anticipate he'll recommend we change venue. Where we are now is we'd like to finish the other 2 counties. You don't have to do 2.
You did say that he said that Latah County is biased.
I anticipate he's going to recommend we change venue for that reason.
I'm interested from him how he defines bias.
And
we all have some biases.
I will not put words in his mouth for that one.
I'm not expecting you to do that.
I will either have him testify today if you want to hear it today, or we'll do it at the venue change hearing when we get there. The question, I understand the court's willing to set our deadlines out 2 more weeks for venue issues. The question remains then, what do I need to show you? What do I need to present to you so that we can do a survey, a comparative survey? The target is 2 additional counties, and I really hate that I'm in here telling you all what we need to do, but here we are. So what we need to do is survey 2 additional counties. And I mean, we don't have to, we can come in with what we have, but generally I think courts ask, where could we go? And I think that's a fair question here, because we do know the media coverage has been extensive. And so I think it's fair to understand if there's a difference. If there's not, then you're left with court convenience.
Tell me what counties?
I mean, I can. Do you want me to publicly disseminate that? Because this is the very definition of public dissemination.
I don't know if that should be done, or it seems like it could have some whether or not there's some credibility of kind of survey, depending on what county you are looking at. We have very different counties and different thinking throughout the state. So I don't know what Mr. Edelman has in mind, or what you have in mind.
I can tell you, Your Honor, his recommendation is that we do one of the counties in Southeast Idaho because it's a different news feed and it's not on the front page of the paper every day. So we will do a Southeastern Idaho county. That would either be Bannock or Bonneville, and I think Bonneville is slightly bigger than Bannock. The other county is Ada, and the reason for Ada is because it has a very large courthouse with a lot of good security, and that court system has handled high-profile cases in a way that's safe for everybody. The population's very large there, so even if we had to draw off a lot of jurors, would have the population there to do it. Additionally, Ada County makes sense when you look at the Rule 21B, the convenience because of the airport and the number of out-of-town people that will be coming in, and the ability to have hotels and restaurants where there would be people wouldn't be running to other people necessarily. So Ada makes a lot of sense for a lot of reasons to me. Those reasons, the courthouse security and places to stay among them. But Mr. Edelman, Dr. Edelman has told us that because of the news feed that we really need to do a Southeastern Idaho. And so the decision was to do both. And in my mind, that is because it makes sense to know if we're going to go to the time to understand this and really give the court a picture, the court might want to know those 2 questions.
Thank you.
Sure. I don't think I have anything left to say right now.
Okay, thank you. All right, Mr. Thompson or Mr. Nye?
I'm not sure that the due process issue is something that's at issue right now.
I think I've already made this decision. I mean, based on the facts and the law. I mean,
absolutely. There's no due process violation here.
No.
There is nothing wrong. In fact, law contemplates the court can take emergency action to stop something and call a timeout until it affords everybody the opportunity to have their say, and the court can make a final decision. That is all Your Honor did here. And I would suggest, Judge, that it would not be prudent or proper for Your Honor to change or limit your own authority on that. I think that you have to continue to reserve to yourself the ability to act quickly, to cause a timeout if you are alarmed sufficiently to justify that, and to give the parties an opportunity to appear before you and sort it out. Before
I'm not going to change that. That's for sure, because the law allows me to do that.
Yes, sir.
And I know what due process means.
And I say that only in light of an email that your staff attorney sent to us the other day ago that suggested that maybe the court was not going to be entering orders without full hearings with everybody.
Oh, well, but Ms. Taylor wanted, she said, from here on out, we're going to talk about that too. Because now I understand, because I haven't seen it yet, because I didn't have a computer, that you are stipulating to sealing all of the discovery stuff. And I just stopped, okay, in terms of signing on those orders that you're sending me, because I don't want to be accused of doing the wrong thing. And there's another situation that you brought up, Ms. Taylor, about that there was a prior thing where I had done that about the IPD.
Yep.
And the state asked to do a public order, just to say that we provided the IDG or some of the IDG to you. And that doesn't really say anything except that. But you were criticizing me for that too.
Your Honor, to be clear, it's not the content of that order. My concern is the process. My concern is it feels like from our perspective that Mr. Thompson says, hey, Judge, can you do this? And I'm getting ready to weigh in and it gets done. I didn't get a response from you. Your Honor, that was out the same day. I was in the process of writing, and this was by letter. It wasn't by motion. I was in the process of writing a letter to the court asking to be heard on some issues, and the order was signed, or the new order was generated. The content of it isn't the problem. It's the concern about the process, the concern about making sure we have a clear record of what's done, and the concern about things halting what we're doing before we can be heard. And
okay, did you want that to be not sealed? The other part, all the IGB stuff, that's like 6 pages, 7 pages?
No, Your Honor, I don't have a problem with what the court ended up doing. I was concerned about the process. And then having this order issue on a Friday without having an opportunity to talk about it, my alarm bells go off. And I think this can't happen. I probably have the court's attention squarely on me in this issue, which I anticipated, but what I didn't want to have is I don't want to have the prosecutor writing the court letters and the court doing something and me running around trying to catch up. I mean, the thing that happened is fine, but then we have this other thing that happened, and I don't want this habit. I understand. I'm sorry.
The survey. That's what.
Yeah, the order to stop. Yeah. Sure. So it's that there are 2 things that have happened without me being able to even weigh in. That's done when the prosecutor asks you to do something, and I don't like that. I want to have opportunities to be heard. I certainly understand a court's emergency power, but if this was an emergency, the state knew from March 8th about these surveys. The state sat down and talked to me, and I offered to see you with the state. And then their motion said, it seems like it might be a violation. So I think maybe we need to define emergency a little bit better, because I know you have those powers and I wouldn't ask you to not use the powers that you have. I think the problem here is the way this gets presented when there were a lot of different roads and it cuts us off. And that's what I don't want to have.
Okay, I want to solve this problem if it's possible. One of the things, I mean, because you have filed motions where you didn't ask for a hearing. There's still one, couple hanging out there. Okay, and so I don't know if I'm waiting, okay, if you're asking for a hearing or not. Or if because historically, you guys have worked really well together, okay? Stipulations, but then I don't get a stipulation, I don't get a request for a hearing. So what am I supposed to do then? So what I'm starting to wonder about is maybe we should just have a hearing, okay? At least once a week, a month. Maybe once a week.
I'm here every week.
Maybe
You can
once
do
a
it.
week. Okay.
You can do it.
Like a Thursday afternoon,
That's
okay?
the day I'm here.
And then, okay, so, and then we can kind of clean out a lot of these things that are sealed or, arguments about this or that. I don't particularly want to do that, but you and the court, okay, both of you, I say you, both sides, that you worked really hard, okay, to protect the goal of a fair trial. And all of a sudden, I feel like it's cracking a little bit, the work together, okay, because if we have to have hearings on every single thing, we got a long ways to go. And it's a lot of time, it's a lot of work, it's a lot of money, and it just makes everything more difficult. So if you can come together on certain things, then it's a stipulation that we need, then it's a stipulation. If it's a hearing, it needs a hearing. I'm fine with accommodating whatever needs to happen in short notice too. Because like I said before, I just want to keep moving on this. Just so it's taking a long time.
Your Honor, I think the record shows that we have been able to stipulate probably to the majority of things. I don't keep count. There are some issues that we have not been able to reach an agreement on. And bringing it back to the issues that are before the court right now, I realize we have a bigger picture to talk about. But the defense makes a big deal about the state hearing that there was these surveys. There were surveys going on in our community back in around the 8th or so of March. And as the declaration that's been filed with the court shows, yes, we did. And we immediately referred that to law enforcement to investigate, find out what these surveys are about, find out who these people are that are doing the survey. If you can, get that information to us. And that process is in the works. And just days before we were able to meet with Ms. Taylor on the 21st of March, just days before, we got the reports from the police department, and we also got that recording. That frankly, the recording is the icebreaker on this. It's the game changer because it's literally what was being said, what was being asked, what was being represented in the form of a question. Ms. Jennings called, reached out to Ms. Taylor to say, do you know anything about this survey? Ms. Taylor says, yes, I'll be in town on Thursday. How about we talk about it? Okay, so we sat and waited. I can tell you, I suspected that this was something that the defense had commissioned from the first we heard of it. But I didn't feel that we had enough information about the nature of the survey to determine whether it was problematic. And we've said this already, and it keeps getting missed in the arguments here. We don't care about surveys. We care about these particular questions asked in this particular survey. The defense is welcome to contract with people from California or wherever, I don't care, to go and ask people, can you be fair? What have you heard about this? All of those questions that Ms. Taylor was just talking about at page 2 of the transcript, those are appropriate questions for a survey. Page 4 are not appropriate questions for a survey. Just because they're put in the form of the question doesn't change the fact that they are an affirmative representation of a fact that if the hearer, the listener, was not aware of it, now they have been tainted by it. They have been, in your Honor's words, they have been injected with that information. That is a clear violation of the non-dissemination order. To think there's a distinction between putting something out in a press release and talking to a private citizen is is a distinction without substance. Those are both public contacts. And I can guarantee that if I went down to the bar and had a few drinks and was talking with some people and say, hey, did you know about this about the Kohberger case? And the defense found out about it, they would go ballistic. And for good reason. That should never happen. But that's exactly what's happened here. Not by Ms. Taylor. I'm not faulting Ms. Taylor for the questions themselves, but by the people they hired to do this. And it had to stop. Your Honor was absolutely correct. Cut it off. And let's sort this thing out. And if we lose 2 weeks, well, we can make up 2 weeks. Your decision was perfectly appropriate. For the defense to claim that there's some due process violation there is without any legal basis. The defense's objection is, we don't like it, Judge. Well, there's lots of things that happened in court that I haven't liked, not in this court.
Well, probably a few.
Well, maybe with Your Honor in other cases outside. That happens. That's part of the game.
I'm not here to.
But just because somebody complains doesn't mean that it's legally wrong, and there is no due process violation here. And Mr. Knight is prepared to argue due process minutiae if that's what we want. But I don't think we need to deal with that. We are dealing with the issue of these questions in the survey. They are completely inappropriate. We have a group of at least 400 people in Lake Tahoe County who have been exposed to this in violation of the non-dissemination order. I think Your Honor is probably right. The only way we can deal with, or the best way to deal with that, would be to exclude them from any prospective jury pool. But we sure as heck don't want to say to the defense's consultants, yes, go do this in other venues as well, where if we can't pick a jury here in Lake Tahoe County, we may have to go to. Go ahead and mess with them too. That's ridiculous. I do not question the right of the defense to commission surveys, responsible, proper surveys, as part of the debate over venue. But this survey cannot stand. If they are going to do that, they need to start from scratch if they want to compare it to Lake Tahoe County. There is no way to take the 400 responses that have been loaded with these factual representations in the form of questions. There's no way that that can fairly be compared to surveys without those questions anywhere else. It's apples and oranges. And yes, it may be an expense, and it may be a delay of time, and it may be an inconvenience, but it is not of the state's making. It is entirely the responsibility and the fault of the agents of the defense. Entirely. We don't care if there's a survey. Now, I'll keep saying that because we keep hearing from the defense that we don't do surveys in Lake Tahoe County. That's not the issue. We know a survey is going to happen here. Now, when it comes to this idea of what happened 2 weeks ago, when we met with Ms. Taylor, we said, Ms. Taylor, actually I said, Ann, we gave her the information. We talked about it. She indicated she wasn't aware of the actual questions. We said, we are very concerned about this. This needs to stop. And the response, if I remember, was along the lines of, well, we think they're about done in Lake Tahoe County anyway. I said, well, we need to bring this to the court's attention. Here's my proposal. We will send a letter to Judge with these attached, copy to you, and then we can have a discussion. And I was told no. The defense did not want, Your Honor, to see this without also having whatever they wanted to offer in response to it as well. I said, well, that's not how it works. I mean, we'll file a motion. Normal law practice. I've been practicing for 43 years. I lose count now. If you can't resolve something, you file a motion with the court. If there are things you want to base your motion on, you attach them to the motion, and we proceed from there. And so that's where we left it. Ms. Taylor did say, well, I could be available the following Friday, Thursday or Friday, to talk with Judge. And to my mind, well, that's too little, too late. As far as we know, these surveys are going on again right now. Wrapping up or starting somewhere else, whatever. It needed to be addressed quickly, not wait a week to have a conversation and then go into a conversation where you're left cold. We walk in the door and We aren't able to provide you the basis for our concerns. So you are completely helpless with information. That's not how it works. That's not how informed decisions are made. So we prepared a motion. We made the attachments. We filed it mid-afternoon, early mid-afternoon, not late in the day as it's characterized here. And I appreciate that Your Honor didn't see it till later in the day.
Right.
But that wasn't the intent. The intent was to get it filed as quickly as we could. There was no scheme to do some, 5 minutes to 5 o'clock filing and take some advantage of the defense. That's not the way we do business. That's not the way I do business. And frankly, it's a little offensive to have that suggestion made, but I'm going to move beyond that. I have to say, I am disappointed to learn today that Dr. Edelman and his associates were not made privy to the non-dissemination order. But we can't undo that. And once again, that's not of the state's making. My knowledge, everybody that has been asked to take actions of any type on behalf of the state has been made aware of those restrictions because they are our agents. And we know we are responsible under the court's order for the actions of our agents. Regardless, I'm disappointed. I also want to be clear that I'm not standing here today making a bar association ethical complaint against any member of the defense team. Yes, language in the non-dissemination order contains language that parrots the Idaho Rules of Professional Conduct, but the laundry list of things that the court lists, I think, are much more specific. And that's what we're concerned about. And if I'm wrong and those are in the comments, well, then maybe there's a violation of that rule, but that's not my interest. I have no interest in doing that. My interest is in taking care of this case, making sure that we can have a fair trial, making sure that Your Honor's non-dissemination order is honored. And at this point, trying to figure out a way to cure what has happened. The first thing to do is we have to say, Your Honor, court needs to say, no, you will not ask any more questions of prospective jurors without the court approving it. Because we've seen that the people retained by the defense cannot be trusted in that regard. Fools once, shame on us. Shame on you. Fools twice, shame on us. We don't want to get into that. They wish to proceed with surveys, they can, but they need to start over.
Start over in Latah County.
Yes, sir. Absolutely. Absolutely. There's no other way to get a fair comparison with any other prospective veneer without doing a new survey in Latah County and not including any of the people who were surveyed in this 400-person group. That's the only way we can avoid this taint. Again, this is not of the state's making. We are trying to salvage a mess. As Your Honor noted, there's no difference between talking, and I said just a little bit of talking one-on-one and issuing a press release or standing down in Friendship Square with a bullhorn. The dissemination is dissemination to a member of the public, and it's equally in violation of the no contact order or the non-dissemination order.
He did.
Yes.
Some
He did.
might have talked to other people, like their families.
I know
their
they
friends.
I know they have,
No.
Judge, and the reason I know that is we got a call from the sheriff's office earlier today where a woman called and said that she had heard about this survey and the survey made her uncomfortable. And when they called her back, it actually was her son that had received the survey uncomfortable. And when they called her back, and it's equally in violation of the no contact order or the non-dissemination order.
Do you think some?
Yes. Fair comparison with any other prospective veneer without doing a new survey in Latah County and not including any of the people who were surveyed in this 400-person group. That's the only way we can avoid this taint. Again, this is not of the state's making. We are trying to salvage a mess. As Your Honor noted, there's no difference between talking, and I said just a little bit of talking one-on-one and issuing a press release or standing down in Friendship Square with the bullhorn. The dissemination is dissemination to a member of the public, and it's equally in violation of the no contact order or the non-dissemination order.
Do you think some of those 400 people might have talked to other people, like their families?
I know
their friends.
I know they have, Judge, and the reason I know that is we got a call from the sheriff's office earlier today where a woman called and said that she had heard about this survey and the survey made her uncomfortable. And when they called her back, it actually was her son that had received the survey inquiries a couple of weeks ago and happened to mention it to her. And she just wanted the sheriff's office to know about that. I mean, we have good, responsible people in this county, and they can sense what's right and what's wrong. You ought to be a trained lawyer to know that it's not right to go out asking these kind of questions to people who might be prospective jurors in the case. It's just not right. So that's what we need to do today, Judge. I don't believe there's a due process issue. Matter of fact, I know there's no legal due process issue here. I appreciate Ms. Taylor isn't happy with the things ready to roll out. That's life sometimes. But there's no due process issue here. And we ask that Your Honor enter the order, cutting off any more use of this survey, directing that that the defense, if they wish to continue with the survey, start over and submit questions to the court to make sure that we aren't getting ourselves back into a similar situation, baiting people who may have no knowledge of this case with detailed information, and detailed information, some of which is completely false. And not only completely false, but it's false in a sense that makes Mr. Kohberger look bad. It is creating bias against Mr. Kohberger based on false or inadmissible evidence. That's outrageous. How can we possibly preserve a jury pool when that's going on? We can't. It has to stop. Thanks, Judge.
Thank you, Mr. Thompson. Okay, Ms. Taylor.
So not liking the result of a hearing or not liking an order from the court is one thing. That happens all the time. I think courts probably have people on both sides of the aisle that don't like whatever decision they make most of the time. And that's just the way it goes. What I complained about was not being able to have a voice before a decision was made. I think that's an important distinction. I'm not saying don't make a decision I don't like or I'll file a motion against you. I'm not saying that at all. I imagine over the course of this case, there will be decisions I like and decisions I don't. It's the way it's been in the past. This was solely about being shut out of the process before a decision was made. I understand the order said I could have my day. Here's my day. So that I want to make it clear. It's that motion didn't come because I didn't like the result. I didn't like the process. That was it.
That was my issue with the process.
And I wanted to be heard about that. I do not think that these survey questions that related to what have you heard in the media injected information to people. I understand that this is a close community, and I understand that people will call officers with concerns and the prosecutor with concerns, and that's kind of the thing that I'm worried about is the close-knit nature of it. That's a good thing unless you are an outsider having a trial. and then it's not a good thing. And that is kind of a problem that we have with that.
Well, I can tell you from my own experience, people I see that there's plenty of people here who really don't like law enforcement that much. So I think it's always a mistake to stereotype people or communities.
Fair enough, Judge. Usually I don't find that people that have issues with law enforcement make their way to my juries, but that's probably something we'll talk about a different day.
Sure.
As far as where we go from here, the moment of getting our work done and not having it out in public is over. So I suppose the court can weigh in on what we should do. I wouldn't be quick to say that we couldn't use the surveys that were done. I would, if that's the route the court is going to go to have us do other surveys. I mean, that's what we'll do if the court asks us to do that. But I'd ask the court to remember that it's quite common for the general questions to draw a no. And then you ask other questions, because then people are like, well, yeah, I did know that. And that's how you get to the heart of the real information. So I think there's got to be some give and take in there. I'll say two more things and then I'll be done. Our office did send Dr. Edelman a copy of the non-dissemination order. I didn't know he didn't receive it, but he didn't receive it. He definitely knows about it now. I would have caught that. But we didn't send him anything. Our process is to make sure that we have the signed order back from anybody that we're going to communicate with about the case. This solely had to do with him looking at what are the media stories, what are the big topics, so I can determine how saturated the community is and bias it. So that's why I didn't catch it. I'll take responsibility for that. But just to maybe allay some of Mr. Thompson's disappointment, it was sent. I don't know what happened, but he didn't receive it. He's sure this is. My other thing is, if the court wants to change the survey, I would like an opportunity to speak with Dr. Edelman about the possibility of preserving what we've done versus just starting all over before, I guess, any more surveys went out, if they're going to be changed. If the court will let us keep going with the way we're going, then we could make the comparisons from county to county. But if that's not what the court's going to do, I would like to see if there's a way to preserve what's been done by not looking at the questions that the court wouldn't want us to ask of other jurors. And I don't know if that works, so I need to talk to Dr. Hill.
Yeah, that's what I'm kind of interested in, trying to figure out. And we have to start all over, how to approach this. And I mean, one of the things that I'm concerned about is how much this costs taxpayers money. And I have no idea. I'm not part of the money, part of this. But you know, if there's a way to kind of salvage something, I'm not happy about these specific questions, especially ones that are false. Then people hear that and they just get even worse sort of impression. Okay, Mr. COVID. There are also cases that are questions that are very specific that are going to be major issues in trial. And so I'm really worried about that, particularly, again, I think I said disability is kind of ironic that, you know, this with the time, the passage of time has kind of calmed down, you know, in terms of the media and very heavy initially. I have to say that to be here today, but the streaming has probably helped a little bit. Kind of slowing things down intentionally, but I think people kind of move on a little bit. And then all of a sudden they get a phone call from a stranger talking about particular issues in Kohberger case. And so it kind of fires it up. And that's one of my worries also. Just the fact that you can say 400 people, but 400 people in town spreads really thin. So it is dissemination to some degree. And I'm no expert about it. And I don't know if you probably should, Mr. Edelman's been hearing this whole hearing. So maybe a discussion with him, maybe even a discussion with each other. And everything's kind of out in the open.
Sure.
I'm very grateful. I'm very grateful for that because I like to kind of know to some degree what's happening in this case. And let's just deal with it really quickly. I don't know, maybe we can next week.
Judge, I plan to be in town on the 11th. If the court wants a hearing, I can make myself available really any day next week. I already have plans for the 11th, but I can be available any other day the court wants.
So I'm going to be sitting with the Supreme Court in Nez County. So could you maybe have a hearing, short hearing of some kind, maybe on April 10th? Or
Your Honor, is that a Wednesday?
yeah, that's a Wednesday.
I will if that's the only time the court has. Wednesdays, I have different things, but I can cancel them if that's the only time. If the court wants me to come back Monday,
I'll
I
work
can.
with you.
I could, 3 o'clock in the afternoon would be easiest for me on that day. On the 10th.
I have a treatment court meeting 2:30 to 3:30.
I can do 4 o'clock, or if the court wants to do it at 1, I can make that happen too.
Judge, I'm confused. What are we gonna have a hearing on?
Well, I want to see what thoughts you all have about dealing with the situation now, making sure that we can salvage anything or nothing. And Ms. Taylor's going to talk to Mr. Edelman, and maybe that'll give us some thoughts. Otherwise, I mean, I could just make the decision right now, but I'm no expert about surveys.
I understand. Thank you.
Yeah. So I don't know how you feel about 4 o'clock on April 10. Could we just do that by Zoom, or do you want to be here?
Your Honor, Zoom would be fine with me. Mr. Kohberger would likely not be present. If he's present by Zoom, I will be here with him. So.
Okay, well, we can do it in person.
Let's go ahead and do it in person. I'll change my visiting day to Wednesday instead of Thursday.
Okay. Is that okay, Mr. Thompson?
Yes, sir. We can be here 10th, 4 o'clock.
And, Ms. Masseth or Mr. Nye or Ms. Beatty can participate by Zoom.
Thank you. Yes, sir. Thank you.
Because I want to make the best decision I can, if that's possible. Okay. Let's talk again about, having a hearing at least every month. Just like cleaning up. And also, I guess you just did have a stipulation that you filed, but I have some, there it is. There's pending the state's motion to temporarily seal Exhibit 1 in the state's response to defendant's 12th supplemental request for discovery. Is that?
That would be, I believe, that would be covered by the stipulation that we filed today.
Yeah,
Okay,
the goal with that, Your Honor, is we often want to file those attachments to discovery under seal, and those contain things that shouldn't be made public. We both agree to it, and originally we were getting stipulations, and then I think we've done it so much, we just started doing orders. So the purpose of that is for us to just send along those and with an order for under seal, knowing that I'm always going to stipulate to attachments to discovery responses to be under seal, and the same with them. I mean, we know what we're each asking. So.
Okay, and I just, I mean, I worry about the clerks too. Okay, so if you could just have a stipulation that says, with regard to discovery responses, you can go ahead and see. Okay, I mean, as long as it's justified.
And that's the intent of what we submitted today, Your Honor, is that attachments to discovery requests and discovery responses, not the cover document itself, but the attachments that have the details would just automatically be sealed when we're stipulating to that. So that would be routine.
Okay, great. So you backed off a little bit there, Taylor, Ms. Taylor, in that particular, you want everything, a hearing, or, you know, everything needs to be stipulated.
That is a stipulation, Judge.
Well, it is, okay.
We also, Judge, I believe we have some other things on the motion to augment the record. We've been gathering more information on that, and it's my fault that I dropped the ball last month and didn't get a second batch of information compiled to Ms. Taylor. She got that today. We are contemplating that we will be able to present the court with a stipulation on that issue as well, with certain emails and communications attached to it, and then also have an ongoing stipulation about off the record communications, email or letter communications involving the court.
Excellent.
So we're making progress. We're working together on as much as we can.
There was also a defendant's motion requesting additional deadlines that was filed on March 6th. We didn't ask for here.
Your Honor, I haven't asked for a hearing. I know the state filed an objection to that, and we don't have a hearing on that yet. My thought would be that after we submit everything on our motion for venue change, when the court's ready to make a decision on that, I think that's when we'd probably call for a hearing on our motion, and probably the state would want to be heard at the same time on their objection.
Okay. So that can just, you know, hang out there for a while.
I think so.
Okay. Now we got state's motion to unseal, state's motion for order of prohibiting contact with the prospective jurors absent leave of.
Which is relates to what we've been talking about today, Judge.
Yes, I know.
We had filed our original motion under seal. The initial response from the defense was under seal that said we object. And then the defense's memorandum with the attached affidavit was not filed under seal. So our position was that in fairness to the public record, that our motion should be unsealed and just keep the attachment sealed to protect the identity of the people who were interviewed by law enforcement or contacted law enforcement about being subject to the survey.
Any objections, Taylor?
In large part, no. There is a sentence in there where the state talks about evidence they plan to present, and that would seem like something they may want redacted before it became in the public record. Our response didn't have anything like that. I can show Mr. Thompson later, so in case he wants to prepare a redacted one for the board.
Do you know what she's talking about?
I don't, but we can talk about it, Judge, and Ms. Taylor just show us or send us what the language is. I'm sure we can work it out.
Okay. And so, and I guess this we are already covered by the stipulation. Defendant's motion to file exhibit M attached to defendant's 14 supplemental requests for discovery.
That would be covered by today's stipulation.
Okay. Okay, I think I've had my speech. So
Thank you, Your Honor.
so we don't need to hear from Mr. Nye or Mr. Edelman at this point.
I don't believe so. I think that it may be more prudent for Ms. Taylor and Mr. Edelman to talk between themselves first. And I believe the due process issue that Mr. Nye was prepared to discuss has been resolved.
Okay, I have no doubt that I did not violate due process rights
Yes, sir.
of Mr. Kohberger.
Yes, sir. Thank you.
Okay, anything else, Ms. Taylor?
Not today, Your Honor. Thank you.
Okay, great. We are adjourned. Thank you all. Thank you for your patience.
Thank you, Your Honor.
I don't know, Patricia. I feel like we had an hour-long 13-year-old boy sleepover.
I didn't mean to laugh that hard. And how come Complaint Fest has TM after it?
Do what?
Look on Patricia's thing. It says Complaint Fest TM.
How did she do that?
I don't know. I need to know these things.
Trademark. How did you trademark that? Crazy.
We learned all kinds. This whole thing on my screen. This chatter on my screen. I learned
Yeah.
that. I learned that today. Aiden learned me that. Look, see, Complaint Fest TM. Is that trademarked?
How are y'all doing that?
Oh, they trying to act like, oh, wait a minute. They trying to, they, wait a minute. Y'all showing off?
They are showing off. It's magic.
Wait a minute. I'm trying all the tricks.
Oh, they're emojis.
Oh, emojis. Rude.
Y'all act like you something.
And how come?
See, look, Billy's doing it too.
QB did it.
Everybody's trademarking everything.
QB did it. What? Oh, Margaret's TM is itty bitty.
Get out of here. Margaret says we smart.
How come there's no tutu or no ballet dancer? There's just some ballet shoes.
I don't know. Because their emojis suck. Yes.
Right? Rude.
Hashtag. I said hashtag. Trademark rude.
Hashtag rude.
You did trademark it, Morgana.
When he said that, I was like,
oh my God, look, I hate it here.
I said, excuse me, sir? What did you say? What did you say, sir? Rude TM. Lauren wins. Lauren wins the intranet.
God.
I
Who
have
was it that
words.
said that?
I hated your TM. They're killing me.
Patricia says, why is yours smaller? They're the same.
No, Margaret's is teeny on the phone.
Yeah, but Lee's is the same size as everybody else's.
Lee's is. Margaret's is the one for me that's small.
Oh,
Oh, no, Lee's is small too. On the phone.
they're all small for me on
When
StreamYard.
in
I
doubt,
don't know.
QB did it. TM. Facts. I was all righteous. I was like, yay, Jenny started it. I didn't do it. And then I was like, dang it.
You
Nope.
did it.
That was me.
That was you.
That me. Oh,
I mean,
thanks,
you're the one that
Nightbot.
called the word out. I was the
Well,
one that said,
you
"Did I just
rewound
hear
it.
that?"
Look, you rewound it and played it again. And we
Well,
were all
yeah, I
freaking
did.
out that he said it again because we didn't know you rewound it. You saw us. We were all like, bro, what? Did you just say it again? Stop. Don't say it again. Margaret, you kind of got dressed.
Got dressed on vacation.
Chegs.
Mm.
Y'all, how am I taking? Y'all don't understand. I am taking such a high dose of potassium. And why is my foot in a Charlie horse right now? Like, I don't understand. Oh, I'm
I
an
don't either.
85-year-old woman living in my body. She's mad.
Is she as mad as Clara?
Girl, let's not even talk about it. While we were watching this whole train wreck, I get a phone call from Clara, and I figured she was calling to yell at me to ask me where I was, even though she said she was feeding the dogs tonight. And she called to tell me she ain't staying over there tonight, and I don't need to come. I've had enough. So I texted my oh, you figured it out? That's cute. So I texted my BFF. I said, your mama said I'm not to come tonight. And she's like, why she said that? And I said, because Ethan's home and she's staying at the house. And she's like, oh, for the love. I was like, just go enjoy your vacation. Do you need me to go watch your mama? She's like, no. I was like, all right. And then I'm going to unpack my car. See, that irritates me because I hate packing. I hate packing. Why are you laughing?
These guys are killing me in the chat.
I know. They're funny. Them's your people.
We were on a break.
We were on a break.
Chegs.
Chegs. I want some. Speaking of which, since I'm gonna be here tomorrow morning, let me go ahead and process this Walmart order. Hey, I have a question.
You better have eggs and cheese in that cart, ma'am.
It is. I told you.
Turled.
Clara's feeding. Well, Clara was gonna feed the dogs tonight, and I was gonna go over and spend the night because they eat early in the morning. But Clara's at the house. She's not staying the night over at Book, so she's feeding them tomorrow. She told me not to come. And look, you don't argue with Miss Clara. Plus, she keeps looking at me sideways when I go over there because she thinks I'm watching her. So then Gina's like, well, take her out to dinner. And I'm like, you want me to drive all the way over there, take your mama out to dinner? She goes, oh, I thought you were already there. No, I'm not there. She told me not to come till 7. I told you. TM. I didn't see the TM until just now. You think they got a jury yet? We over here fooling around?
I'm going to go back over there and hit play and see how much longer it is. Share.
Why is my... Nope. That is not where I wanted to go.
Okay, y'all ready to resume this? I'll put it on like 1.25.
For this juror's honesty, the state would move to excuse.
Did y'all hear me?
Due to the exposure that she's had in this case.
All right, response from the defense.
And Judge, I've struggled with this because she's been extremely honest. I appreciate how
I want to be honest.
And you have been. And very forthright, and I've struggled a little bit with this, but in the end, I think, Judge, I agree with the state.
Okay, wait a minute. I'm wondering, are they doing the preemptory, whatever you call it, challenge? Is that what's going on right now?
I don't know, because that wasn't that the girl that we were watching when we left? That she was talking about, she knew all the things, but she could set it aside, and the defense said, I don't know, I'm struggling.
Oh, maybe. I didn't know. It looked like it had skipped to the very end.
It
Let me
does look
double
like it's
check.
at the very end.
I know, right?
I hear your baby.
Return in this case,
Yeah, it says live
I
right
share that
here.
concern of council, and so I'll sustain
Oh, baby.
the motion to strike. Chair 1330, thank you so much for coming in and participating in the process. You discharged your service as a juror in this case with the sincere thanks of the court.
You're welcome.
Thank you.
Thank you.
We'll next talk to 1353.
Judge.
Okay, thank you.
It's not letting me back. But
Yes. Yes.
got it, Judge. Thank you.
Okay, thank you. And we'll have juror 1219 brought in. Questioning for you outside the presence of the other jurors. I believe you've got a copy of the questionnaire you filled out. If you do, would you please turn to page 12 of that? And that is the section of the questionnaire discussing your attitudes regarding the death penalty. When you filled out your questionnaire last week, do you recall thinking through these questions on the death penalty and providing these answers?
Yes.
I'm going to advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when you consider it, consider that it should be done as if it is absolute and will be carried out in the case when you're thinking about these responses. Knowing that, and with the time that's passed since last week, is there any change or amendment you would have to those answers, or would they still be true and accurate today?
No changes.
Okay, on page 12, you had a choice of do you support or oppose the death penalty, and you said support. Is that still your position here today?
Yes.
If you would please turn to page 13. On that page, you had a set of choices that describe the way you feel and what's most accurate. You picked C. C reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty?
Yes.
And you would be willing to follow any instructions about it in this case?
Yes.
All right, the next question I'll have then is, are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay, and finally, I'll ask you, is there anything you think or we should know about your views on the death penalty that could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions about the death penalty? All right, that concludes the voir dire of the court on that topic. Does the state have any voir dire?
The state has no questions, Your Honor.
No questions, Judge.
All right, juror 1219, that concludes our individual voir dire with you. If you'd please return to the jury room with the bailiff, we'll call it another juror and let you know what's happening once we return you.
Thank you.
One, 271 will be up next. I know there was some tech issue here. Are the parties able to access that questionnaire? All right. So I don't know if it was advised for 1271. Okay, thank you. All right, juror number 1271 has returned for additional individual voir dire questioning. I'd note that this juror does have some case information and raised their card when asked if they did know something about the case. So we'll discuss that, and you can certainly openly discuss any facts you know about that here with the other jurors not present. There wasn't any indication that there may be a hardship, so I don't have any of my own voir dire in terms of bias. I'll allow the state to ask me questions about that, followed by the defense. So we'll do that for the state.
I will, Your Honor.
Go ahead, Mr. Wicks.
Thank you. Sir, in reference to what the court had just said, you had made some early responses that you do have some case information. Can you just kind of give us a nutshell of what you understand about this case before you came here?
Yeah, and I didn't know if it was the right time to ask the question, but I assume most people have some. That was kind of my take with it, is that I've just heard news clips, stuff like that. I know there was, I've heard Lori Vallow, but the other person that you guys maybe mentioned possibly a conspiracy. I don't know that name. I've seen a lot of like just news clips that have popped up on it.
On that point, I understood you said you didn't know this other person. Did you see or learn enough that you remember the names of the victims, the alleged victims?
It kind of rings a bell. I hear it, but I couldn't listen right now. I know that it's two kids. I know that that just like random little tidbits that maybe Hawaii was in a part of it or something like that, but not like I don't know a ton of details about the case. It's just I obviously have, sometimes sit and see news clips and stuff like that.
Did you happen to watch any documentaries like Netflix or anything like that?
No, no, it was just like news, it was just news clips that, it was obviously a long time that the span was unfolding. So it was just constantly you're like, someone's maybe saying something like, oh, did you hear about that? And that's about it. I just don't know a ton of details.
Do you feel, based on whatever you did gather from what you're referencing, do you feel like you could set aside anything that you have learned and freely listen to evidence as it comes in and then be impartial in rendering whatever decision you might make as a juror?
Absolutely. Like I said, I don't know enough to even be like, really put a stance on. So, yeah.
Okay. The last question on this. On your questionnaire on page 19, you had noted, I don't know enough of what happened to form any ideas, and I also believe in innocence until proven guilty. What did you mean by that?
Just the fact that even, hearing it, I'm a firm believer in the fact that, like I'm just listening to random clips, like you really don't know the whole story until sit down and go through it. It's just that's all I was saying. That is the little bit that I have heard absolutely doesn't really matter until you sit down.
So is it fair enough to say that you're going to presume his innocence until the state proves him guilty?
Absolutely.
Thank you. No, I don't have any more questions.
All right.
Questions, Judge.
Okay. The next issue we'll discuss then, juror number 1271, relates to your attitudes regarding the death penalty. If you do have a copy of your questionnaire there, this is on page 12 and 13 where we're looking. And I am going to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So thinking about that, you did provide answers here. Do you believe the answers you provided are still accurate in the way you feel here today?
Yes, yes.
Okay.
Absolutely.
You were asked if you support or oppose the death penalty on page 12. You said you support it. Is that still the way you feel?
Yes.
Okay, on page 13, there was a series of choices, 7, that go into some more detail about what you think most accurately represents the way you feel. And you selected option C, which says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still representative of how you feel about the death penalty today?
It is.
Are you in favor of the death penalty in every case where a murder has been committed?
No, I'm not.
All right, and finally then, is there anything about your views or beliefs in reference to the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions?
No.
No. Okay, thank you for your responses. Does the state have any more direct?
We do not, Your Honor.
Nothing, Judge.
All right, that concludes the board hour. Juror number 1271. We'll have you return to the jury room and the bailiff will give you further instructions. Next up will be juror 1288. And we'll have them brought in. Does council intend any voir dire in this one in relation to hardship or bias?
Yes, Your Honor, this is a juror that we've left off some questioning to pick up again during individual.
Okay, oh, correct, thank you. All right, juror number 1288, thank you for returning. We are reviewing your questionnaire here. There were some concerns raised in the group voir dire that state's going to ask about. In addition, if there's any other questions that could relate to a hardship, you can inquire there as well. The state will conduct individual voir dire this juror, then the defense. Ms. White, is that you?
Yes, Your Honor.
Go ahead.
Thank you. Juror 1288, thanks for sticking with us. I know we'd had a conversation about graphic images and I said, maybe we'll pick it up in individual. So that's where I wanted to start with you. I know I kind of had put you on the spot and you may or may not have thought too much about it before coming in today. But I believe where we left off, and correct me if I'm wrong, but I think you did have concerns about your ability to view any images of that nature that you may have a reaction to, and then just weigh them in relation to other evidence. You probably had a little more time to think about it. Do you still have that concern?
I think I'm concerned about it. I think I want to be impartial and weigh it accurately. I do think I would struggle in associating that with my own personal situation. So that's.
Like we did talk about, and I won't get into specifics, but we did talk about you have some children. Do you think, because you said you want to be impartial though, and obviously as you look at evidence and give it the weight you think it's due, you may weigh that out how you feel appropriate. Do you feel like something about seeing those images would make you automatically impugn guilt to the defendant without having heard before you've heard all the evidence and weighed it out? Would you automatically draw that assumption or conclusion, do you think?
I don't know if I would automatically assign guilt, but I think I would. I'd be a little emotional in my wanting to seek justice.
And that's fair. Do you think if instructed by the judge that you were to wait to form any opinion until having heard all the evidence and in reaching your conclusion, do you think you would be able to, even though you may have an emotional reaction, which is normal, do you think you would still be able to follow the court's instruction and wait until the end to make that final decision for yourself?
Yes. Yeah.
Thank you. I don't have any additional questions on this.
All right, thank you. Mr. Pryor?
I guess I just want to clarify.
Microphone, Mr. Pryor?
I'd like to clarify a little bit, if you don't mind. You see some graphic pictures, and I talked about that a little bit. You're going to have to block out having some sort of reaction and putting the blame on Chad. Is that what I'm hearing?
That I would have to block it out, is that right? Yes.
So in other words, you would be predisposed, or a bad word, you would be upfront. If you saw these pictures, you would instantly say, I want to blame him for this, but you'd have to stop yourself and wait until you saw the rest of the evidence. Is that what you're saying?
I'm saying it would be difficult for me to not make an immediate emotional reaction of wanting to assign guilt to somebody.
Okay. And that's what, and again, I want to remind you, there's no wrong or right answer here, because I really appreciate your honesty. I'm grateful that you're being honest. And so I'll restate what I said. You would have and I don't want to say extremely, but you would have a very difficult time not assigning guilt to somebody after looking at those pictures, and it would have an impact on you while you were deliberating. Is that fair?
I think so, yes.
And don't take this personally, sir. No, please don't. Judge, I'm gonna move for cause on this. I'm worried about the potential risk here.
All right, response from the state.
Your Honor, the state would submit to the court on this one.
All right, well, this is why we conduct these sometimes individually. Juror 1288, a few of those responses by sharing a concern of the defense that this is evidence that's likely to be admitted in the trial that may affect you in a particular way to shift a burden away from the defendant to which he's entitled. And so I appreciate you really thinking through. I can tell you very carefully considered your responses to these questions and believe that the challenge is best sustained in this point in our interest of trying to obtain the most impartial jury we can. So thank you very much for filling out your questionnaire and returning today. I'm going to sustain the motion to strike, and juror 1288 will be stricken for bias in this case. You can go ahead and go and return your questionnaire to the bailiff, and we'll move on to our next juror. Thank you. Let's talk to 1330. All right, juror 1330 is returned for individual voir dire. Thank you for coming back in. We're reviewing the questionnaire now. And we're going to be asking you about the knowledge you have about this case in addition to possibly other topics. Because the other jurors aren't here, we wish for you to discuss this in as much detail as necessary to tell us what you know. And with that in mind, looking through the questionnaire and that you've acknowledged you have some case knowledge, I'm going to have the state begin with their individual voir dire as to any possible bias, and then we'll move on to the defense. Ms. Beatty?
Thank you, Your Honor.
Go ahead.
Good afternoon, ma'am. Hi. I just have a few quick questions for you about media exposure in this case.
Yeah.
So in your questionnaire, you indicated that you come across some news on TikTok, online, but that it just kind of come up. You hadn't sought it out. Is that accurate?
The only one I sought out was the Netflix special.
The Netflix special, okay. And you watched the Netflix special?
About a year ago.
About a year ago, okay.
So it's not completely clear.
Okay. Would you, and this might sound like an odd question, but would you kind of just tell us what you remember about the Netflix special?
I remember there were several suspicious deaths. I remember that seeing aerial footage of presumably the area of land that they were found. I remember seeing the last photo of them alive.
That's about it.
And the area of land that they were found, do you know where that was?
Near Idaho Falls, I think, area.
Do you know who owned that property?
My understanding is that it was, the defendant.
Okay. So having watched that Netflix special, at the time that you watched it, did it cause you to form any opinions?
Well, I mean, everything you see on TV is formulated and produced for the benefit of the pockets of the people who own the TV.
So
I understand that. Now, would it sway me? Not necessarily, because they don't really care whether they're telling barely truths, half truths, approximate truth today's kind of thing for the sake of money. And I wouldn't say that I'm personally swayed by anything I see online when it's a for-profit situation.
Of course, I certainly appreciate that perspective. I did notice on page 19 when they asked if you could put out, when the questionnaire asked if you would be able to put out of your mind what you had read and heard, you'd initially checked no, but then you crossed it out and wrote yes. Was that something you've been kind of wrestling with a little bit?
No, I totally checked the wrong box.
Oh, okay. All right.
It was one of those where I think I read something and then I checked it and I went, oh, whoops, that's totally the wrong box. So it wasn't a rethink of the same question.
Okay. And I realize this might all sound kind of silly since I'm the prosecutor in this case, but we all have an interest in making sure that Mr. Daybell gets a fair trial.
Correct.
He's innocent until the state proves him guilty.
Yeah.
And so I think thank you, madam. The concern that I guess I'm kind of wrestling with a little bit is, you talked about how emotional it would be to look at some of these photographs.
Yes.
So do you think that it would be very difficult to look at those photographs and still put out of your mind what you saw in that Netflix special?
I'd like to say that I can do that, but I don't think anyone truly knows what they would do until the moment they've seen those pictures.
Okay.
I've never seen pictures that graphic. Most of the stuff I watch is censored to a certain degree.
Okay. Well, thank you.
So you can assume what you might do. And I would think I would still be partial to do.
Okay.
I like to believe that I would be.
But as you sit here today, you're kind of struggling with that.
You can tell yourself and you can say, you know what, I'm going to remain partial regardless of what I see. But I don't think anybody really knows when something happens to them for the very first time in their life, what the outcome will be.
Thank you so much. Just one moment. And I want to thank you very much for your honest answers. Your Honor, the state, with all due appreciation for this juror's honesty, the state would move to excuse her due to the exposure that she's had in this case.
All right, response from the defense.
And Judge, I've struggled with this because she's been extremely honest. I appreciate how
I want to be honest.
And you have been. And very forthright. And I've struggled a little bit with this, but in the end, I think, Judge, I agree with the state. I'm worried that those pictures are going to influence you, and I'm not sure I have guarantees that it's not going to be a problem. And considering what's at stake, it bothers me a little bit, but it's nothing personal.
I'd like to say that I know how I would react, but I've never had that happen.
And that's what
you can't know.
Judge, I go along with the motion to strike.
Very well. The court's considered the request to strike juror 133 on a bias grounds based on previous exposure to case information. Upon review of the questionnaire, in particular having viewed the Netflix documentary, which will contain potential evidence that would return in this case, I share that concern of counsel, and so I'll sustain the motion to strike. Chair 1330, thank you so much for coming in and participating in the process. You discharged your service as a juror in this case with the sincere thanks of the court.
You're welcome.
Thank you.
Thank you.
We'll next talk to 1353. All right, juror number 1353 has returned for individual voir dire. There were some issues brought up in terms of voir dire in the group when counsel was discussing the conspiracy charges in this case, and I indicated we delve into that further individually. In addition, in this case, I don't know that this juror had expressed any knowledge of the facts, but there is that issue to go through as well. On a hardship, we didn't really have anything to discuss there. I'll allow the state to proceed with any additional voir dire relating to those questions that came up, and then I'll allow the defense to do their voir dire on that as well.
Thank you, Your Honor. Juror 1353, you remember we were talking about the conspiracy?
Yes.
And so we talked about the judge would give you the recipe or the instructions, and they'd have certain elements. And with conspiracy, the judge had already said conspiracy would be an agreement between two or more persons to commit a crime. Would you have any problem with that?
It would have to be shown, proven, that there was an actual agreement, not just words spoken.
So when you say actual agreement, what would an actual agreement look like to you, if you could describe it?
Transfer of money, an action that would suggest that there was an agreement made.
And if the judge were to give you an instruction that says what agreement is defined as, so again, kind of like a recipe, the judge is going to tell you what an agreement means. So it could be various things, and it could be implied. Would you be able to follow that instruction in determining whether or not an agreement had been reached? Would you have concerns with that?
No.
If you're instructed on it?
No.
And then if you felt that the state had in fact met the burden of proving there was an agreement based on the court's instruction of what an agreement is, and that that's an element. And then another part of the instruction was that even if just one of those people do an act in furtherance, so one person does something to carry out the crime or to attempt to carry out the crime, would you then be able to say if there was an agreement, you could hold anyone involved in that agreement accountable?
I would have to ask who's on trial. If the person was on trial, there was an agreement, then I would have to agree with somebody that I don't know about and they agree to it. I have no idea. So I'd have to say no.
So, and I guess maybe I can explain it a little bit better. So the judge had talked about a couple other names coming up. So we had the name Vallow Daybell and Alex Cox mentioned by the court. And the court said you wouldn't concern yourself with their guilt or innocence or any proceedings that they may or may not have going on. So if you knew you weren't going to consider that, and you're only considering the defendant, and you felt the state did prove that there was an agreement, but maybe you didn't feel the state proved that the defendant was the one that committed an overt act, but you believe the state met their burden with one of the other alleged co-conspirators, would you be able to follow the jury instruction regarding conspiracy to say if there's an agreement and one of the parties to the agreement commits an overt act, you could find someone guilty?
You have to restate the question because I'm confused. If you're saying that the person that's on trial has agreed to a contract or an oath, then I think we should be concerned about that person. If there were more people that were involved with the conspiracy, their actions should be tried separately. And so I'm always willing to listen to what the court has to say and is in charge, but that's beyond my scope to know and to understand what somebody else's intentions are.
And if you were able to hear evidence regarding some of those other individuals' actions or alleged actions, and you were told you could consider those actions as part of this trial, do you feel you would then be able to consider what actions someone else took in furtherance of the conspiracy?
Once again, I'm confused by the question because what I'm saying is if we have somebody on trial for a crime
they should be proved guilty or innocent on what they've done. So somebody else talking about doing something or not doing something, notice it can be proven that they actually did that act. And if it's not to be allowed in this courtroom by the court, then that would be thrown out. But if it is allowed, then it's allowed. And if it's allowed by the judge, then I would have to agree that I can listen to that. But if it's not allowed by the judge, then it shouldn't be presented. Does that make sense?
Yes, I think I understand what you're saying.
Okay.
So it sounds like you would be willing to follow the instructions of the court.
Yes.
And if the court allows certain evidence in, you would consider all the evidence that's presented to you in making a determination.
Absolutely.
And so do you believe if you think the state meets a burden of showing there was an agreement, of proving that you could then, if the court told you you could consider actions of another individual that may have taken those in furtherance of the conspiracy in reaching a final verdict?
Yes.
I don't have anything additional.
All right, thank you, Ms. Blake. Mr. Pryor.
It really comes down to a simple thing. If the judge gives you instructions, you're going to follow them, aren't you?
Yes, sir.
Nothing else, Judge. Thank you.
All right, thank you. Without additional voir dire on those topics, then the court's going to move on to the part of your questionnaire that dealt with your attitudes regarding the death penalty. So juror number 1353, do you remember coming in last week and going through that part of your questionnaire?
Yes.
Okay, and for your reference, we're looking at page 12 is that whole section about attitudes regarding the death penalty. I'm going to advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. With that in mind, I'd like to look at your responses, a few of them. You had a choice of do you support or oppose the death penalty, and you said support. Do you recall answering that way?
Yes.
Is that still the way you feel right now?
Yes.
On the next page, you had 7 different choices to select from which one would describe most accurately the way you feel. You selected choice D, which says, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still the way you feel about the death penalty as well?
Yes.
Okay. Are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay. Is there anything about any of your thoughts or views or feelings about the death penalty that you think could prevent or substantially impair your ability to serve in this case and follow instructions on that?
No, sir.
All right. Thank you so much for your responses. Does the state have any voir dire on that issue?
No, Your Honor. Thank you.
Nothing further, Judge. Thank you.
All right, juror 1353, that concludes your individual voir dire. We'll have you return with the bailiff.
Judge, I'm wondering, just to keep the record clear, the state had made a motion to excuse juror 1353 for cause. I think given the additional answers and information provided, the state would withdraw that request.
Very well. Without a challenge, then will be passed for cause. Thank you for clarifying the record, Ms. Flake, and juror, you can return with the bailiff. And while we're waiting for our next juror, which will be 1366, something I hadn't mentioned previously with this group, but the jurors in this group did all return their affirmations, and they were all okay, with the exception of the one we discussed on the record previously. Those will be contained in the case. All right, juror number 1366, thank you for returning. We do have some individual questioning to take up with you outside the presence of the other jurors. In this particular questionnaire, the court didn't see any concern necessarily of a potential hardship. However, there may be some questions on either side of bias, and so I'll allow Kohberger on that topic and then move on to our next topic if we're still questioning. So does the state have any questions for this juror in relation to bias?
Just briefly, Your Honor.
Go ahead, Mr. Wood.
Juror 1366, I just a reminder, there's no right or wrong answers here. Just tell us what you're thinking, how you're feeling. It sounds like you've seen some media connected to this case. Is that fair?
I've seen headlines.
Headlines. Okay. So have you read articles or?
If I did, it was so long ago, honestly, I don't remember. I just really know the headlines from living locally.
Yeah. And you did state in your questionnaire that anything you had heard, you'd be able to put out of your mind and render an impartial verdict, correct?
Correct.
And you agree that this defendant has an absolute right to a fair trial?
Yes.
And to start out with a clean slate?
Yes.
And so can you commit to this court, to the state, to the defendant, that you will set aside anything that you have heard and render an impartial verdict based solely on the evidence in this court?
Yes, I can.
State has no further questions, Your Honor.
No questions, Judge. All right, juror number 1366 then, in addition, there are some questions I'll have about the part of your questionnaire you filled out called attitudes regarding the death penalty. Do you remember when you came in last week and went through this questionnaire, thinking through and answering those questions?
Yes.
All right, the questionnaire then, well, first let me advise you that it may be necessary for you to actually make a determination in this case in regard to the imposition of the death penalty or some other penalty. And so remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So with that in mind, when you filled out your questionnaire, you had a choice of whether or not you support or oppose the death penalty. You said you support the death penalty. Is that still the way you feel here today?
Yes.
All right, the next question I'll have relates to the choice you made when you had 7 different choices that describe what most accurately represents the way you feel. You circled a selection saying, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the law, by the facts, law, and instructions in the case. Is that the way you still feel about it as you sit here today?
Yes.
All right, so you would follow any instruction the court gives on that topic if that occurs in the case?
Yes.
Are you in favor of the death penalty in every case where a murder's been committed?
No.
Okay, is there anything else to be concerned about in terms of your views on the death penalty and anything you think where your views could substantially impair or prevent you from serving as a juror in this case?
No.
All right, I don't have any additional questions on that with this juror. Does the state have any more dire on the death penalty questions?
No, Your Honor.
No questions, Judge. Okay, juror number 1366, thank you for returning back. We'll have the bailiff take you back to the jury room while we talk to our other jurors, and then you'll receive further instructions. Next up, 1382. All right, next year we're going to talk to year 1382. This juror did indicate some knowledge of the case through prior media exposure to the case. And we want to talk to you about that. And again, you can discuss that in as much detail as you can so that we know where you stand on those issues without the other jurors here present. And I don't believe the issue of hardship was necessarily before the court at this time. So the state wants to inquire on board dire and bias. Do that, and who will be doing that?
I will, Your Honor.
Go ahead, Mr. Woods.
Thank you. Pam, and again, thank you for being here. And there's no right or wrong answers to the questions we're asking. We just want to get a feel for your perspectives are. I want to start just by drawing your attention to page 18 of your questionnaire. And overall, it does not appear like you have a lot of information about the case, but you did indicate some information. Besides Channel 7 News that you mentioned, do you recall seeing any other news reports or documentaries or anything?
I have not. I mean, it's not a recall or a not recall. I have not.
I simply haven't seen that.
I've watched some commercials for Channel 7. So, story coming up at 10. I've gotten some headlines. That's about it.
So then on page 18, you did note, I've seen some Channel 7 news reports years ago regarding the bodies being found and her being arrested. So I'm just going to ask, as you sit there today, from what you can recall or remember, do you remember which bodies and where they were found?
Now I know that I remember seeing, like you said, the previews to the stories and showing an aerial view of a property. So no.
So is it fair to say that you don't even remember the names of the alleged victims, if you ever even knew them? Do you recall them as you sit there?
No, but I might be able to. No, I mean, if I sat here long enough, I probably could pick up the names.
Okay.
I don't.
Okay. Well, would it be safe to say that whatever information you did glean from the news over the years, could you set aside anything that you've learned from the news if you're asked to be a juror and just listen to evidence as it comes in and then make your own decision about whether or not there's, well, guilt or not guilt, no guilt? Okay. And then would you commit, I noticed on page 19, you said everyone has a right to their day in court and to be considered innocent until proven guilty. Okay, so you'll commit to that you won't make a decision about the defendant's guilt unless and until the state meets their burden and actually proves that he's guilty. Is that fair?
Yes.
No, I don't have any more questions.
All right, Mr. Wixom from the defense.
Just very briefly, ma'am, you had a very strong opinion about media. So I don't think I have any concerns about you listening to anything the media says. Is that fair?
That's fair.
Okay. And quite frankly,
Use your microphone, Mr. Fryer.
It is on, Judge, and I'm sorry, I'll speak into it. And you were very specific when you said everybody has a right to their day in court, and you underline the proven, which means you're going to make them prove their case, the prosecutors, right?
Absolutely.
Okay, Judge, I have nothing else. Thank you, ma'am, for your time. Thank you.
All right, thank you. I do, I guess, have one question I'll raise in terms of the hardship section. You talked about your position at work, can go on 24/7, and you said I would just work after the court hours. I guess one concern I'd like to talk through with you is if your thinking might continue with full or part-time employment. If you find this to be taking up all of your mental energy and you're not able to work the way you think you would, are you concerned that you might have some hardship if you really can't work while this trial's going?
I wouldn't have a problem with it. My position is, it could probably be done extremely easily with remote. And I do have backup in I'm one of a group in HR, so I'm not restricted to the parts that I'm participating in at work.
Okay. If there were a time that you were sequestered a week, possibly 2 weeks, and you just simply couldn't work at all, would that create any kind of hardship?
Yes.
All right, thank you for just answering those follow-up questions for me. The other topic I want to discuss with you is on your attitudes regarding the death penalty. That's a section that we had you fill out in the questionnaire. Do you recall that?
Yes.
I'll advise you in this case that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember that any penalty you consider should be done as if it is absolute and will be carried out in this case. You understand that?
Yes.
All right. When you had a choice of do you support or oppose the death penalty, you didn't like the choice of yes or no and circled support, click the box, and also wrote depends next to it. And that's fine. This is designed to understand how you think about it. And so it looked like yes or no was not enough description for you. You also checked a choice saying, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. So could you explain, as you sit here, as best you can, your views on the death penalty?
That's my issue, or my choice of answers have more to do with the question. So at the end, when all of the evidence has been shown, then ask me yes or no. I wouldn't want it to be taken out of context.
Okay.
Whether I would agree, yes, death penalty is appropriate, or no, it's not. Because I think it's all situational on the facts of the case, not just an open-ended question.
All right. If you are given specific instructions in this case that say you are to consider the death penalty, would you follow those instructions?
Yes, absolutely.
And if you were given instructions that say you are not to consider the death penalty, would you follow those as well?
Yes, sir.
Are you in favor of the death penalty in every case where a murder's been committed? Okay. Is there anything about your views on the death penalty that would prevent or substantially impair you from serving as a juror in this case and following any instructions the court would give?
No.
All right, thank you. That will conclude the court's voir dire. Does the state have any voir dire questions?
We do not, Your Honor.
No questions, Judge.
All right, thank you, Juror 1382. That will conclude our questioning of you in individual voir dire. I'll have you return with the bailiff to the jury room and we'll give you some more instructions once we talk to the other jurors. Let's next talk to Juror 1436. Okay. All right, Juror 1436. All right, juror number 1436 is returned for individual board dire. Going to talk to you about the knowledge you have about this case. You do have some. Please openly discuss any facts or details you're asked about. And why don't we start there with the state conducting board dire on potential bias.
Okay. Hi. So I have a few questions for you about media exposure, and there's no wrong answers. Obviously, you know, nobody's going to hold anything against you that you saw in the media before you ever knew that you might be called as a juror on this case. So please just feel very comfortable answering these questions. You felt. So it looks from your questionnaire like you did get a decent amount of media exposure in this case. And you indicated that you felt that Mr. Daybell looks guilty according to the news reports.
Well, you know, I didn't see a ton of things and I can't even remember everything now because it was a while ago.
Sure.
But just the way the questionnaire was written, which I forget how it was exactly written, you know, saying, well, if you were to make a decision based on, you know, what you've seen in the reports and everything, then yeah.
Okay. So if you had to make a decision based on what you've seen on the reports, you would feel that he was guilty. Is that what you're saying?
Well, in the questionnaire, the way it asks,
okay.
Just kind of was like, you know, okay, so you were exposed to some media. So I did see some things on the news back then. It wasn't something I followed or anything, but you know, you see it, it comes on the local news or whatever. So it was like, oh, your perception, you know, they're implying something happened. He's in trouble, you know?
Sure.
So.
Do you mind kind of telling us what you do know about the case from what you saw in the news reports?
Let me think. Just that there was 2 people killed. I didn't know if there were 3, but there were two people killed that were children, and that, you know, it involved the husband and wife, and that they ran off to Hawaii together. So that was pretty much, and that the bodies were found on one of their properties.
Okay. Did you watch any court proceedings?
No.
Okay.
I didn't watch anything like that.
And it looks like there was a comment in here that you wrote, he may be mentally ill. Do you want to kind of talk about that a little bit?
Well, I forget what the question was.
It was, have you formed any personal opinions whatsoever based on information from any source of Chad Daybell's guilt or innocence?
Yeah, my thought was kind of like if he or she had done something like this, that person would have had to have some problems that would cause them to do that. I was trying to answer him honest.
Of course, no, that's great.
So it seems like a blanket statement, but that was the only way I thought I really could answer it on paper like that is, you know, I guess if somebody did something like this, something wasn't right.
Of course, no, and it's great that you answered those questions. Okay. Honestly, that's exactly why we're all here, and we are all very, very appreciative of your willingness to be so open with us. And just so you know, it's very common for us to ask people who've had media exposure these very specific questions. Right. Did you watch any documentaries about this case?
Oh, no.
Did you go looking for it on TikTok or anything like that? In the questionnaire, you did indicate that you had formed some opinions on Mr. Daybell's guilt based on the media reports, but you indicated that you'd be able to put those opinions out of your mind, which you had heard in the media. Is that still?
Yeah, the way I took kind of the questions being asked, like, okay, you saw so much, this is what you saw. What would your conclusion be from that? So that's kind of what I was answering when it came to actually being in a court and making that decision, those things would be put to the side.
Okay,
Miss Beatty here too, you are going pretty quick, and with this particular juror, I know it's been a real long day for our reporters, so if we can make sure there's no talking at the same time as well.
thank you, Your Honor.
Thank you.
I'm sorry, not a court reporter. So you're going to be instructed during this trial that Mr. Daybell is entitled to a presumption of innocence. That means that as he sits here right now, and up until the state is finished with its case, he's presumed innocent until we meet our burden of proof.
Right.
Is that something that you'd be comfortable with?
Yes.
And you understand that nothing that you've seen in the news or on TV is evidence?
Yes, I do understand. Yes.
And the evidence is what comes out in court? Testimony, any exhibits, anything like that?
Yes.
Okay. I have no additional questions, Your Honor. Thank you.
All right, thank you, Ms. Beatty. Mr. Pryor.
Good afternoon.
No.
We spoke earlier, but you have your questionnaire with you?
I do.
Okay, let's turn to page 14. Number 2 at the very bottom. Question is, what have you heard or what do you know about defendant Chad Guy Daybell? Do you see that? You wrote in there on trial for murder of several people. He may have mental issues. And I just want you to clarify, you said that's what you heard and that's what you know. So at the time of this writing, what you know is that he has mental issues?
No, I was just going on based on the news report and things that I've heard about him. Because I mean, obviously, he wasn't on trial. So when I said that, I'm assuming that this person is on trial because of it, and I wasn't following it. So, but I was saying, just like I was telling her earlier, that first, if somebody did commit a crime like this, my initial thought would maybe there were some mental problems.
Okay. And is that still your opinion now?
What?
That Mr. Daybell has mental issues?
No, I was just going by the reports what I had read from the news media, and you were asking me if I could form an opinion from that. That would be the opinion I would form. I don't know if that makes sense.
Then we can go to page 19. Under item number 10G.
Yeah, and
10D. And under 10D, talks about the media exposure, and again, lists here on the case, whether you formed an opinion of guilt or innocence. And you said yes.
Yeah, I kind of took the question as being, what opinion would you form based on what you've heard about?
And that's fair.
Yeah, so I was going to give an answer to, well, this is, oh, sorry.
And when you wrote this at the time, which was, well, several days ago, I guess, right? You said, looks guilty. And you were basing that's your opinion at the time you wrote this, after looking at all of the media and everything that you've been presented, he looks guilty.
Yeah, if you go by what the information I received in the media,
right? My
initial thought is, yeah, the guy's probably guilty.
And that's fair, if that's what you believe. You also believe that at the time that you have to make your judgment, that you have to block out your personal opinion and look at it regardless of whether you think he's guilty today or not, right?
Right.
You have to push that off to the side, correct?
Right.
And by pushing that off to the side, you then have to look at this thing and say, I have to be neutral despite the fact that I feel like he's guilty. Are you able to do that?
Yes.
But if we go back, your impression now, and I don't want to put words in your mouth, but the impression now is that, Mr. Daybell looks guilty and I think he's guilty. But if I get chosen for the jury, I will block that opinion of mine that I've already made, and I will judge him fairly. Is that where you stand on this?
I don't know that I believe he's guilty.
Okay.
I just, I kind of took the questionnaire as it's saying, you got this information, what opinion would you form from this information? So that was the opinion form. I don't necessarily believe that he's guilty or not guilty at this point.
Okay.
But I know I could put that aside.
And surprisingly, that's exactly what I wanted to hear.
Oh.
And you gave me exactly what I wanted to hear. Judge, I have nothing further. Thank you. I appreciate it.
All right, thank you. So juror 1436, then just.
Your Honor, I'm going to move to excuse this juror. I'm going to sort of leave it to the court. I understand that she's saying she could put this aside, but given the depth of media exposure, we do have some residual concerns, Your Honor. So I just wanted to put that in front of the court.
Response from the defense.
I appreciate everything you've done. I don't know, but even the media judge, I think that would concur.
All right, there are some comments in there. There is previous exposure. This is a long trial, a complicated case, and as we've seen with many other people, we do have some concern that maybe thoughts and knowledge about where you already are might creep into where we're going in this case. And so you've been very candid with us. We appreciate that. I'm going to sustain the strike made by the state, and with no objection from the defense, juror 1436 is excused based on potential bias, and for that reason, we'll let you go. Thank you for taking all your time to fill out the questionnaire and returning today. I'll have you return your questionnaire to the bailiff, and your jury service is concluded.
Thank you very much.
You're welcome.
We're getting close, folks. Getting close.
Next up to juror number 1503. All right, thank you for returning, juror 1503. We've got some additional follow-up questioning for you based on responses in your questionnaire, as well as indicating today in group board diary that you have some knowledge about the case. Let's go ahead and allow the state to. There was also some talk of hardship, but let's start off with this knowledge of the case on board diary. The state would like to start its board diary on that issue. You can do that.
Sure, thank you, Your Honor. Juror 1503, thanks for being here. And again, you've already heard this. There's no right or wrong answers. We just want you to tell us how you see things, how you feel and think about things. And it looks like from your questionnaire, you have seen some media on this case, both from local, national news and internet. What have you seen on this case?
Basically,
Yeah, basically just, like I said, a lot of print news, national as well as local. Some of the outcomes of some of the other connected parties, I guess, if you want to say it that way. Yeah, and like I said, just like a lot of news coverage, things that happen in Idaho, whether it's Aryan Nations coverage or other type of activities that are high profile stuff, you would read up about those kind of things. So just local interest kind of stuff. So.
Sure. And yeah, no one can hold it against you for wanting to read the news and being informed. You did mention just now, I don't know if it was in your questionnaire, but that you were aware of outcomes in a companion case, and I don't want to put words in your mouth.
Yeah, well, yeah. So in terms of the other people that were involved, like I said, I don't know how. Well, I don't know how to.
Oh, sorry about that.
So yeah, I didn't know what was allowed, in terms of details, in terms of that kind of stuff. Going into more other than, like I said, other people that I guess have gone to court.
Right.
Yeah, just what the outcomes of some of those things are.
And so we're in here just with you individually right now, so that you can be completely candid without worrying about anybody else hearing it. So it sounds like, did you follow the trial of Lori Vallow?
A little bit, but like I said, most of it was the outcome and what was finally handed down, I guess.
And so what happened in that case. I want to talk to you about a couple of your answers in the questionnaire. Starting with on page 15, at the very bottom, it says, if you did follow these cases, has that caused you to already form an opinion regarding the guilt or innocence of the defendant in this case? And you said subconscious opinions may have formed. Tell us what you mean by that.
So again, I understand, the presumption of innocence for any defendant. But again, it's hard for you to unknow things, right? And like I said, I can go in with the best intentions and saying, I'm going to go and try to be impartial and do those kinds of things. But subconsciously, there could be some influence from things that you've known or seen, or kind of things that subconsciously, and that's why I use that word, creep into your judgment or some of your decision-making process at that time. So, like I said, I think I just try to use that phrase and be as clear as I could.
Yeah.
For that. So.
Being honest about how you feel.
Yeah.
Is it fair to say that while you would do everything you can to set aside what you've heard based on your answers in your questionnaire, you do have some concern that what you have heard could affect your judgment in this case?
Yes, I brought that out to be as transparent as I can, and saying that again, it's hard to say, hey, I'm going to shut out all the things, because some of the things have been going on for years, and that things that we seen things or heard things over the course of years, and you can't just either turn them off or just shut that out. It's kind of almost like a known type of thing in the thought process, I guess. So again, like I said, I would obviously try to do my best in terms of that stuff, but again, that's why I brought up that point to say subconsciously, to try to be as above board as I could in terms of that thought process.
No, very much appreciate your candor. And it just really quick, it does look like you watched local media, you said CNN, Associated Press, and Reuters on this. Your Honor, we very much appreciate Juror 1503's candor. Based on his answers over the questionnaire and here, we would move to excuse Juror 1503 for cause.
All right, response from the defense?
Judge, I think I have to.
Very well. Juror 1503, this is the process we're going through to try to get the most impartial jury we can, based on knowledge and information you have from a case that would likely affect your views in this case. or at least have the appearance they could. We're concerned. I support the strike and will sustain it. And so thank you very much for taking your time and energy to fill out our questionnaire and return when you were supposed to. Your service as a juror in this case is concluded.
Thank you, Your Honor.
Thank you. Uh, 1537 will be up next. Okay, our next juror we're going to talk to is 1537. Thank you for returning for individual Vordar. I know it's been a long day and afternoon for you. I'll just allow the state if they have any questions on either bias or hardship for this juror.
No, Your Honor.
You may.
No. No, who's that?
No, I just confirming he's, court was allowing me to go forward.
Yeah, Mr. Whitson, please inquire.
Thank you, Judge. Hello, sir. Again, I just have a few questions in that questionnaire. There's no right or wrong answers. Just trying to understand your perspective. I do, you have your questionnaire in front of you, sir?
Yeah.
Okay. Yeah. May I call your attention to page 8? I'm looking at page 8, paragraph 3, and you were asked a question. Do you feel that the jury should be free to disregard the law given in the jury instructions if they disagree with that law? And then you appear to have checked yes. You did make some side notes, some references to Nazis and remember who else. And I can't remember who else you may have mentioned in there. Could you please just explain the comment?
I think I was referring to also the Fugitive Slave Act back in the day, where if you didn't help someone return to slavery, you could be arrested for it. And I think that would be wrong to do. So I think the jury in that case, and if they were in Nazi Germany, some evil law like that, that should be allowed to disregard.
Okay. So do we take that then, if there's something about the legal instructions that this court gives, if you sit as a juror, hear all the evidence, and then feel like you're put in a place where you feel like it's an unfair law, are you indicating that under your conscience, you wouldn't necessarily follow the instruction or follow the law?
Well, this law that supposedly was broken or accused of breaking isn't an unfair law. And I think it was just referring to it in general. That's how I read that question. So, okay, I think there was certain scenarios where it's okay.
Okay, so you don't anticipate having a problem generally following this court's instructions?
No.
Thank you. And I'm just going down to a quick reference on page 15. You had noted that you were not really familiar with this case and hadn't really followed media, but you did know, I heard of Lori Vallow from the news. Can you just let us know, what is it that you remember about Lori Vallow?
I think what I really remember was when everything was going down, my coworkers back in the day, like maybe 3 years ago, were just saying, whoa, this is a crazy story. And I remember that name. And I think recently she was convicted, possibly.
Do you happen to remember any of the other names that have come up in the case, like the alleged victims' names?
No.
Do you remember where the alleged crimes had occurred? Anything like that?
Like Idaho.
Is there anything then about what you have learned from the news that would make you think that you wouldn't still give Mr. Daybell a presumption of innocence, listen to the evidence, and then render an impartial verdict?
Can you say that again?
Is there any reason to think that you won't let him have the presumption of innocence?
No.
Okay, just a last question, and really, if maybe I'm thick, I just want to make sure that I do understand you clearly. If in this case, you're a juror, and the judge gives you a set of what will likely be a large number of different instructions to follow, and that will be what will be the law in this case for the jury to apply. If in any event that any given instruction that you see does not feel fair or right or moral to you, will you still be able to apply that instruction as the judge has given it to you, even if you feel it to be immoral or wrong?
I think I would be able to follow the instructions in this case, yeah.
Thank you. Your Honor, I don't believe I have any more questions.
All right. Okay, no further questions for this juror on those issues then. So juror 1537, there's one other topic I want to go through with you, and that's on the part of your questionnaire called Attitudes Regarding the Death Penalty. That's on page 12. Do you remember going through those questions last week and answering them in your questionnaire?
Yeah, yes.
And are your responses there still the same as the way you would feel today?
Yeah, it seems like my answers were basically just kind of, I waffle a lot, so that's accurate.
And that is fine. Part of the way that the questions are designed is to get people to think about it and be accurate in how they feel. So in filling those out, maybe that's more of a thinking about things hypothetically, but here in this case, it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. So when you're thinking about these answers, please consider that it should be done as if it would be absolute and carried out in the case. So you had an answer on do you oppose or support or oppose the death penalty. You said support, and you said very slight lean, I think. Is that what you were saying?
Yeah.
Okay. You also had a group of 7 choices about what most accurately represents the way you feel about it. You circled part C, which says you generally favor the death penalty, but would base a decision on it. I'm sorry, I'm going to read that. I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that the way you still feel about the death penalty now?
Yeah, yes, sir.
All right. Are you in favor of the death penalty in every case where a murder has been committed?
No.
All right. Finally, is there anything about your views on the death penalty that would prevent or substantially impair your ability to serve as a juror or perform your duty in this case?
I don't believe so, no.
All right, so you would follow court's instructions regardless of whether that was to consider or not consider the death penalty?
Correct.
Very well, thank you for your answers. Does the state have any additional board?
We do not, Your Honor.
Nothing further, Judge.
All right, without further voir dire, then juror 1537, we have one other juror to talk to, and then we'll have you return to the courtroom for more instruction. That will be juror 1577 next.
Y'all gonna have to do something with QB. Y'all gonna have to do something with her. Those of you left in the chat, you're gonna have to come get this QB. Somebody come
All right,
get her.
thank you for returning juror number 1577. We've got some additional questions for you outside the presence of the other jurors. State have any voir dire as it relates to any potential bias in this case?
Just briefly, Your Honor.
Go ahead, Ms. Beatty.
Good afternoon, ma'am. Hi. So you had some media exposure in this case, is that correct?
If I did, it was passively. I don't watch the news, so if it was on TV at a restaurant, it was there, but I don't participate in watching the news.
And in your questionnaire, you indicated that you haven't formed any opinion about Mr. Daybell.
No.
Is that still true?
It is.
Okay. I have no additional questions for this
No
judge.
questions.
All right. All right, there were no further concerns on hardship either, so the court will next address this part of your questionnaire dealing with the death penalty and your attitudes regarding the death penalty. Do you remember going through those questions and answering them in the questionnaire last week?
I do.
Okay, I'm going to advise you that it may be necessary for you in this case to make a determination in regard to the imposition of the death penalty or some other penalty. Remember that any penalty you consider should be done as if it is absolute and will be carried out in this case. Do you understand that?
I do.
All right. In your questionnaire, when you were asked if you support or oppose the death penalty, you said you support it. Is that still the way you feel today?
Yes.
In addition, when given a range of choices about what most accurately represents the way you feel, you selected an option that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty as well?
Yes.
All right, so to be clear, that part that says you would follow instructions in the case, you would be willing to do that?
Yes.
Do you favor the death penalty in every case where a murder has been committed?
No.
Okay, is there anything about your views on the death penalty you haven't mentioned that you think would substantially impair or prevent you from serving as a juror in this case and following instructions relating to the death penalty?
No.
All right, that concludes the court's voir dire for this juror. Does the state have any voir dire?
No, thank you, Your Honor.
That's okay. All right, thank you, counsel. Juror number 1577, if you'll return to the jury room with the bailiff, we'll have you back here shortly. Counsel, could I have a quick sidebar with you before we bring the jurors back in and adjourn for the day?
Y'all, QB's trying to connect her StreamYard to YouTube so she can chat, because it won't let her chat from her laptop. It's only letting her chat from her phone. And all of a sudden she sends me a screenshot of an error or not an error message, but like a message saying you can stream in 24 hours. So she thinks she's tore the whole internet up. I don't know what she's done. Can't do nothing with her. Can't do nothing with her. Morgana, when you're in StreamYard, does it let you chat from the computer, or do you have to chat from your phone? She is a hot mess. Okay, Morgana says I always just chat from my phone, but haven't tried through StreamYard yet. Okay. You should see what I'm seeing. In the backstage, there's 2 QBs. One whose devices are not connected, and the other one's just sitting there chilling. Maxing and relaxing. Choo choo. Oh, she's telling me to let her in.
Hello.
Hi.
Ma'am. I about showed my whole cleavage. Ma'am, I hit share and then I went, yeah, okay. And it was like all the things. And my computer was like, hey, QB, how you doing? And showed all of me. And I tried to do a JB where I slid down, so I just slammed the daggone computer shut. I'm done. I quit. I quit. I mean, when I tell you how bad that would have been, like, I'm sitting here with, you know how old people take their glasses and look down over them and they like, I can't see what that says. And then all the chins and the boobs, all of it. It was I quit. And now I'm streaming and I don't even know what that is. All I wanted to do was chat from the computer.
Oh,
I haven't eaten.
Morgana sings all of
Love me. Yeah.
loves all of you.
Y'all were about to see all of me. Remember that little dress I told y'all about? Yeah, the reason why I don't wear it outside no more is because girls are cleavagey. I hate it. I swear. I quit. Now freaking YouTube's gonna text me and be like, oh, your account's ready for you to stream. No.
Oh, I can't laugh no more like that today. My head is busting. You gotta quit it.
It's just me. It's just who I am as a person. I can't help it. I hate it here. I closed the computer. I'm afraid to open it back up. That y'all see my freaking cleavage. I'm done. I gotta eat something.
Morgana said, the girls just wanna have fun.
They definitely want to have fun.
The girls
They-
just wanna have fun.
Let me see my orange. Oh God, sorry. Is that loud? Can y'all hear all that?
Mm-mm.
Sorry. Oh, good. Yay. What is this? What? 17? What the what? Oh, never mind. I thought this orange chicken thing said, oh, but I could put it in the, ooh, I could put it in the air fryer though. Air fry, 375, 10 to 12 minutes. I am in like Flynn, yo.
Woo!
Oh, these kids went and bought some real dish detergent. They got the Platinum Power Wash. The what? They fancy. Children
Yeah, they
fancy.
buy the good stuff, not the junk stuff that leaves white powder residue all over all the dishes.
No, I bought a Dawn, but I don't want to buy the Power Wash because it's just alcohol. What they said, 375. Don't you hate when you like? Do you do this? I know you do because everybody does. Where you read the directions and then you throw it in the trash and then you got to go get
Thank you.
it.
Please be seated. We're going to have this jury panel then brought in for passing for cause. If you could instruct the marshals, please have the ready name jurors brought up.
Yeah, you got to go back through and dig the box or the bag back out of the trash can.
Ma'am, did you just cut me off?
No.
The guy just started talking.
What?
Okay, I'm losing my.
Judge,
Yes.
council approach briefing.
Yes.
Right now, are they talking?
Yeah.
Okay. I might. You know they done picked a jury, right? All right. I'm starting dinner. Can you hear me?
Yeah.
Okay. Sometimes you don't talk back to me and I don't know, and I am having technical difficulties over here, ma'am. What we have here is a failure to communicate. Putting this daggone laptop back up.
Mm-mm.
I am. Dang. Now you can stream in 24 hours. No, I can't. No, I cannot. And then StreamYard talking about, do you want to share this to your audience? I don't have no audience, StreamYard. Who are you talking about? The cats? But I will tell you, I've had a problem. I've been having a problem connecting my YouTube to StreamYard in general. Like even on my phone, I can't, but I have to type in whatchamacallit, in actual YouTube.
Thank you. Please be seated.
Yeah, Jenny, you're live in 2
We're
hours.
going to
Yeah, I know.
take a final inventory of the remaining jurors here to match against our seating charts. If you wouldn't mind, please hold up your red cards and we'll take our notes.
Trying to do this update on my iPad.
Okay, thank you.
You're welcome.
I'll inquire of the state now, and we are back on the record in the case here. Does the state pass this remaining small group for cause?
Yes, Your Honor, thank you.
Does the defense pass this small group for cause?
Yes, Your Honor.
All right, thank you, counsel. Ladies and gentlemen of the jury, you've now been passed for cause. We're going to continue on with our proceedings and have you contact our jury commissioner, Randy Rutland, on your way out, who will give you further instructions regarding when you will return. While you're waiting, please don't do anything to investigate the case, look up the case. If you see the case passively in media, please try to avoid any exposure to that so you can remain impartial in the case. And don't discuss the case amongst yourselves or with anyone else. However, you are permitted to discuss the fact that you may be serving as jurors with family, friends, employers, etc., to make arrangements, but don't engage in any discussion about the case or the facts. We will be asking you to sign an affirmation coming back that you have followed that instruction. So with that, that will conclude our juror selection for today. Does the state have anything further before we adjourn?
No, Your Honor, thank you.
Anything further from the defense?
No, Your Honor.
All right, thank you. Counsel will be adjourned until tomorrow. All right, please. Okay, thank you. We'll see everyone tomorrow.
So they're done. Yay!
Yay!
All right.
Woo-hoo. You know they were done like 2 hours ago.
Huh?
You know they were done like an hour ago.
Something like that, yeah.
Yes.
Something like that, yeah.
Something like that. This is how we do it.
This is how we do it.
Did you get my message?
Huh?
Did you get my message? I figured you're getting off now anyway, so it doesn't matter.
Yeah.
Doesn't matter.
Yeah, I got it.
I can't not be there.
Not.
Not. Who's there? Oh, sorry.
This is how we do it.
Do you know that if you take the dish to Dawn power wash and spray it on something and then dip it in paint, it gives you like a really cool thing, like a really cool effect.
Oh yeah?
Yeah, it's cool. That's a lot of people do it with tumblers.
Wow.
Yeah. Anyways, you can also do that with like your nails. You can get like not with the power wash necessarily, but if you take soap and you get the bubblies and then you do your nails and then you put your bubblies on the nails and then cure it in your light, it makes like a snake skin kind of bubbly, kind of cool.
That is cool.
Anyways. Yeah, I woke up with a headache and not eating didn't help. All right.
Oh yeah, Gail, I do. I didn't see your comment till just now. In 2 hours. Yeah.
Yeah, ma'am. Oh, let's see. How are we doing the rice? I'm so
Definitely
bad.
a long day. Definitely a long day.
This one's rough. Microwave. Proper.
Bum, 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 bum.
So it's so bad. Have you ever seen the Innovation stuff?
The what?
Called Innovation.
Oh, what is it?
It's like Chinese food, freezer Chinese food.
Oh no,
It's really good. It's actually like really, really good. But they have this sticky white rice. And I kid you not, it's frozen. And it comes in this like automatically venting like pouch.
Mm-hmm.
And you just stick it in the microwave and cook it. And then let it puff, the pouch puffs up to let the steam, and it steams the rice.
Mm-hmm.
And then it just comes back down. And then you take the rice out.
Yeah, we do that with like Uncle
The boiler
Ben.
bag. Yeah. But
Yeah.
this is like I don't need any water. Like I don't have to do nothing but throw this bag in there.
Oh, kind of like the vegetables, the steamer
Yeah,
veggies.
yeah, but it's rice. Love it.
Yeah, I
Love it.
like that whole thing. You just throw the bag in, and then
The
poof,
steamer, I
you've
love
got
them steamer ones.
beautifully. I do that a lot with like the broccoli and the Brussels sprouts.
Ooh, somebody left their vape out here.
I love Brussels sprouts.
Ooh, it's gross.
What, the Brussels sprouts?
No, the vape.
Whose
Well,
is
I
it?
said, I don't know. It's Jay's, I think. Somebody left it out on the counter. It's his, I think. He had the citrus with sunrise, but all I can taste is the grapefruit. And I like grapefruit, but not in a vape. That's not right.
Mm.
These lost Mary, though. JB ain't lying. They're pretty good.
Patricia, yes. I know what you mean about got that almost Friday feeling. Oof.
Oh.
That makes me feel like that should be a Trolls song. You know the music in Trolls?
Yeah.
Like
I was thinking,
all the
trolley.
Justin Timberlake songs. I love Justin Timberlake. But yeah, that sounds like a Justin Timberlake song from Trolls. Got that sunshine in my pocket. Got that good soul.
I don't know what I'm supposed to do with it when it's done, though.
Ooh, dun, 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 so phenomenally. Da, 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 da. It won't stop. Ooh, sorry. Yeah.
Oh, did I fall out?
You sure did, ma'am. And you know what? If you were on your laptop, you could have put yourself right back up there.
If I was on my laptop, y'all be looking at the girls.
Why?
Nobody wants that because I'm afraid to open it back up because I allowed it to have my access to my microphone and my camera.
Yeah, but you turn those off.
I know, but I didn't on accident. And so it opened up and it was sharing and I shut the computer down real quick.
Do you know how you fix that?
Wait till you're done streaming and then go back in
No,
there.
no. You put a little sticky note or a sticker or something over top of the little camera.
I got to open it to do that. I'm scared.
I don't mean right now. I mean later.
Oh, okay. All right.
I just put a sticker on. I don't put it on my laptop, but I've got one on my iPad. Because when I'm
we be
walking
seeing
around
up your
with
nose.
it, I can easily hit the cam button with my thumb and not even know it. So I've got a thank you for your order sticker across the camera on my iPad.
I love it. I love it. Oh, I should have put some. Oh, let me put some. I put no oil down. Why didn't you tell me, Jenny?
I'm sorry. What kind of oil? What are you talking about?
Avocado oil.
Oh.
Always avocado oil in the what is this thing? Air fryer.
Chaloon says never be sorry for singing. I love to sing. I love it. Music makes me happy.
Music makes me happy and I love to sing. What y'all won't love is me singing.
Oh, same. But I don't.
No,
even
you
care.
sing. You can carry a tune. I can't. I it's bad.
Well, I don't care if I sing good or not. I just sing because
I don't either. I do too. I sing all the time. I'll be like, look, you riding in my car. You can walk.
But you're gonna hear me sing.
That's right. All right, now I got avocado oil.
Oh, I'll tell you what. I'll be driving down the road, and there's some songs that just hit you right. You know what I mean?
Oh yeah, sometimes, especially them worship songs, girl.
Oh yeah. But one song, especially worship songs, right? I
They
love
get you.
Some K-Love.
Yeah.
I love K-Love. I don't know if you guys in the chat know what K-Love is, but it's a like Christian radio station, and they play a lot of really cool songs.
And then we have 90.5 here, Life FM.
Anyway. We have something like that too. But I have I don't know, there's just some songs that come on and I'm like Bryan Adams, Summer of
Right.
'69,
Right.
and
Don't Stop Believing.
yes, Guns N' Roses, Sweet
Yep.
Child of Mine,
Yep. Yep.
or
Yep. Yep.
Welcome to the Jungle.
What's really fun is sometimes I get into, because I told y'all I have an Enchilanga. She likes tacos. And sometimes I want to hear a little Latin music, and I'll have the Latin music loud, and people drive up on me on a stoplight, and they look over and they take a double take. They're like, "Girl, you forget where you were born." Nah, homie.
You white as white can be,
White,
right?
you is that rice I'm cooking? They do.
Right?
That happens all the time. I used to have it in Texas all the time, and they'd start laughing, and I'd be singing it because I know the words. Look, don't mess with me. Look at my rice. Oh, it's hot.
It's so funny because I will be hardcore jamming to some not like old school hip hop. I don't
Right.
like the new rap I just don't. But some of the old school hip hop,
Right.
I would
Oh yeah.
even now will catch myself dancing
Yes.
to,
Yep.
like busting a move, right?
And singing all the
Yes, but
words.
when I see myself doing it in the mirror, I'm like, that does not it does not
But you
translate
let
well.
you let somebody roll up on you. You got the music blaring, got the sunroof open,
Mm,
and you singing, you rapping in your car.
right?
You're like, wait, whoa, what? What? Wait a
Some
minute, ma'am,
some
ma'am.
46-year-old white woman just but hey, I'm
Hey,
telling you,
look.
I get the, Melissa McCarthy.
Oh yeah,
No, is that her name? Oh, you know who I'm talking about, right?
yeah,
The
yeah, yeah.
comedian?
That's her. That's her.
God, I love her.
I love her so much.
No, that's not her. What is the chick's name?
Are you talking about the actress or the singer?
The actress.
Melissa McCarthy.
Is that it?
Look, push it. She's singing push it real good.
Yeah,
Oh
that's
yeah, I
her,
got
that's
you.
her.
Yeah, that's
Oh my
her.
god, that song right there, "Push It." Oh, yeah. Mhm.
That's right, Patricia. Mind your business. Don't be looking over here. Me and the Lord having a moment, okay? Or I'm having a moment with salt and pepper. I don't know. But just mind your business.
Mm.
Yeah, the rice. Oh, Sherry, you know the innovate. You got to look for them. Their Chinese food is actually it's frozen and it's really good. Like I'm
Mm.
making orange chicken right now. And
Uh, go, sorry.
no, it's okay. I ain't mad. I haven't made it in now. I made it in the microwave, and normally I don't cook chicken in the microwave. Nope, 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 nope. Frozen, already cooked, don't matter. I don't care. Chicken don't go in the microwave. But
Mm.
this stuff, I will definitely eat in the microwave. But I'm making it in the air fryer for the first time, and I ain't gonna lie. This is about to be lit.
Gail said Justin Timberlake and Jimmy Fallon are BFFs, and it's so funny when they get together. I
Yes,
love Jimmy Fallon so much.
so much.
I do, and when those 2 get together, oh my god, my heart just explodes.
Speaking of so much, have you talked to your bride?
Not today.
They're stressing me out.
Huh?
Her and Zombie both are stressed out, and they're stressing me out because our group chat is quiet. When I tell you it's quiet, like there's some crickies over there, and I keep
Yeah.
sending like an SOS text. I'm like, where are you?
Yeah, they're kinda like toddlers. When they get quiet, that's when you know you gotta check in.
Yeah, I'm like, excuse me, where y'all at? Cause I'm worried. Jelly roll, jelly roll.
Um
Not turn around bright eyes. Not turn around bright eyes. Total eclipse of the heart.
Total eclipse
Eclipse
of the
of the heart.
heart.
Oh, Lord. Why? What is in the background?
Patricia's making orange chicken too. What is what in the
What?
background?
Where? Oh, nice. Great minds.
Huh?
I said great minds. No, never mind.
What'd you
There's
say was in the background? What background?
there was a message in the back chat, but it was from before. Just ignore me. You know I talk out of turn.
Oh, okay. Okay.
Plus, I got to call. What time is it? It's 8:15. I got to call M.
Mm-hmm.
No, Morgana. Oh no, yeah, that's right. I never mind. Y'all can be the same person, I guess. Next thing I know, she'll be divorcing me and marrying Margaret. Be all right.
Y'all, I'm struggling. I'm trying to connect my Apple Pencil to my iPad, and it's not having it.
Oh, are you sure you got the right one for the right one?
Yeah, I bought them.
Okay.
I bought them specifically to go together back a couple years ago. But I haven't used my pencil in a long time, and it was like put up.
Right.
And so just now I'm trying to reconnect it. So it's not wanting to connect.
Well, there was a whole thing like people were buying the new iPad and they had one of them pencils and it won't work with the new one. And so people were up in arms because they're like, I spent all this money on this Apple Pencil and now it won't work on the new one. It's like, I don't know what to tell you. Apple be like that.
Mm-hmm.
Apple be doing that.
Well, they better straighten up.
Right? All right. Oh, that orange chicken is good.
Is it?
Mm-hmm. Yo, what is this? These animals are running amok out here. I don't even know where the boy is. Hi, baby. Hi, baby. Little bit is on my shoulder because that's where she rides. No matter how big she gets, that's where she lives. What are you doing, ma'am? You want to jump? Let me get closer, please.
Here. Salt and peppers here. Salt and peppers here. All right, ma'am. Will you go call M?
Yep,
I'm gonna get off and try to figure out my dad burned.
Yeah, and
Apple
nice.
Pencil
Not
with
you.
my iPadlet, huh?
Not you.
Oh,
I was talking to the cat. Yeah, I don't know because not Jenny. Steph said something about we were having a foursome, and I don't understand. I was trying to so we didn't have to fight. So I was gonna be. It's weird. We have a whole weird dynamic. Just never mind.
A whole weird dynamic. What are you talking about?
Oh, all us people, the back chat.
Oh, okay.
Oh, there we go. Autoplay. All right, I'm gonna jump down so you can do your Southern goodbye. Love y'all, mean it. I'll see you tomorrow.
All right. Sounds good.
And thanks for having me, ma'am. Sorry,
Yeah,
I'm a
yes,
hot mess.
ma'am. Thank you for coming up here and being up here and hanging out and hanging in like a hair and a biscuit and all the things. Oh, and guess what? Guess what, QB?
What?
The storm.
All right. Love y'all. That's gross. I'm out. Bye.
Love you. Bye. The storm. Oh, I had to. Hey, Lee, welcome back. I'm leaving. I'm going to go get some dinner. Oh, is she practicing? Oh, really? If she does it as practice, she will not be ready for it. I'm so excited. Storm warning. Are you serious? Jeez, I can't. Ay, 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 ay. I don't see nothing on the way doll. Margaret says we're getting a spring storm tonight in my area. I don't want it. Yeah, and I will not be ready, says Lee. Get the tissues. Oh. Oh, the storm warning, Morgana. The storm. All right. I'm going to get out of here. I'm going to go get some dinner and try to figure out why I can't get my tablet working. Oh, and I got to do my outro. I have an outro because I had my intro this morning and I have the outro to match it and go with it. So, yes. I'll have to play the outro for you guys too. So, let's love you too, Gail. Thanks for coming. Thank you, everybody. Please give the video a thumbs up. And if you're watching on the replay, hashtag replay in the comment section down below. And yeah. I'm excitedly. I'll see you over there later on, okay? Okay. Yeah, do all the YouTubey things, all right? I love you guys. So let me find my little thingamajigger. Hold on, where's it at? Oh, here it is. All right, love you, bye.